Due to extreme urgency, this matter, my lord, because my lord, I have not been given permission by the Defense Ministry, my lord, to hold the gold bazaar from 20th to 30th, my lord. If my lord,
You have already mentioned.
my lord,
slip is with me.
my lord, that's the urgency, my lord.
300 slips, it's with me.
My lord,
I've decided whatever, either to give it in the list or not to.
my lord, I'm
Mention again and again.
Lordship, kindly bear this.
Call on the list, please. Yes.
Lord, if he has
No,
not heard
listed matter.
tomorrow, my lord,
Item number one. One who is appearing. Yes, Mr. Bachchan.
My lord, this is my application, Lord, challenging adjudication by the stamp collector, Lord. Now, Lord, the fact over here is this, Lord, there is a scheme of demerger under which, my lord, I acquire certain things. There is no immovable property in West Bengal. The Stamp Act, my lord, creates a special exception in the cases of schemes for merger and demerger. I'll presently show your lordship the provision.
Not a final hearing.
To final hearing, to Lord, my learned friend is on the other side.
Any difficulties?
My lord, it's my lord a final hearing matter. My lord, we literally, my lord, concluded.
My lord, I will finish in Lord, exactly 10 minutes, not 1 minute, not more than that. Less than that, possibly.
Whatever you say.
Your question of law, there is no question of
My lord,
fact.
it won't take too long, my lord. Only problem is, my lord, this first week for me, my lord, has been, my lord,
Yes.
I have 4 item ones, my lord.
Very
So,
good.
my lord, kindly, my lord, keep it next week, my lord. Whichever item, anytime, my lord, I'll come and do it. My lord, it'll take, my lord.
But for my learned friend's convenience, if it's
Let
possible.
it be on Monday, next Monday then.
Very well, man.
Monday will be all right for you.
Yes.
Every day will be same for you.
No, it'll be, but I'll, my lord, do it, my lord. Because your lordship's taking original side matters, my lord, first half.
No.
Oh, sorry.
From next week, Mr. Mukherjee, I'll be changing my.
Well, that's fine, my lord. Then
Probably
kindly,
3 or something like that.
my lord,
If there are
kindly.
too many appellate side matters.
Yes,
for
my
it.
lord, kindly keep it at 3 on Monday. I'll come and do it.
This will be the first matter on
Very
Monday.
well.
First original side matter on Monday.
Obliged, sir.
Obliged to.
On the prayer of the learned advocate general, the matter is adjourned till June 19, 2023.
Obliged, sir.
Obliged.
Thank Sorry. Matter মানে কিন্তু দুটো ম্যাটারই appellate
two
side
matters.
হ্যাঁ।
One in the appellate side
There's
also.
a
Both
appellate side
matters.
matter,
One
Lord.
in the appellate side, other in the audience.
Both will appear together. Yes.
Item number 2,
Sir, in this matter, I thank
Sri
for
Shankar
that.
Dutta and others.
My senior is ill. Kindly adjourn on it, madam.
Not 1 week, then next monthly
I'm
list.
for the state, my lord.
Yes, my lord.
Yeah,
I'm
for
for the
this. You're not suffering an interim order.
No. Oh,
And an adjournment is sought by the petitioner. Let the matter stand over till the monthly list of July 2023.
Item number 3, Akanksha Agarwal versus Union of India and others.
My lord, I am for the petitioner.
Right.
My lord, in this matter, my late husband was a manager with the respondent number 2. He died because of coronavirus during the second wave in service. So this matter pertains to payment of gratuity, where my claim is that the entire amount of gratuity, according to their manual, has not been paid. So my lord, for that,
Show me the manual, the relevant portion.
yes, I would like to bring your attention to page 54.
Good service has been affected in the meantime.
Yes.
You're satisfied on the service?
Yes, ma'am.
You have checked up good service?
Yes, my lord. And
Very well. Yes. Yes. Please continue.
Yes, my lord. Page 54, my lord, may kindly see. Page 53 onward, it shows the manual of service.
Right.
Page 54, my lord will see towards the end,
Yes.
paragraph 15.2.4.
Right.
Roman numeral 3, completion of 5 years, but less than 20 years of service. 12-month
Is
annulment.
there any dispute in this case regarding your being the wife or the quantum or anything like that?
On the quantum, they have not paid me the entire quantum. So in the initial round, one of their managers had admitted to that amount. Then they revised that amount, saying it is a incorrect amount. And then they have deposited part amount, which they say is the entire amount.
If there is a dispute regarding the quantum, then I'll have to direct affidavits in the matter. Because
My
they
lord.
have a right to place their case before us.
Yes, my lord. My
Well,
lord.
I'll admit the matter, but no interim relief can be given. You have been given some amount.
Yes, my lord. My lord, the amount claimed is about 8,55,000. I have been given 2,46,000. So about 6 lakh
Actually, writ petition is not maintainable on factual premise, but since you are in view of your position, definitely I'll entertain the writ, but direct affidavit.
I am obliged, my lord.
একটা order. A dispute has been raised by the widow of an employee of the respondent number 2 concern, comma, which is a government of India enterprise, comma, as regards the meager quantum of gratuity paid by the respondent number 2 on the demise of the petitioner, apostrophe S, husband. Full stop, next para. Since the dispute involves questions of fact as well, comma, the respondents are directed to file their affidavits in opposition within 3 weeks from date, full stop. Reply, if any, shall be filed within a week thereafter. Stop. The matter shall be listed for hearing on July 17, 2023. Affidavits, July 17.
My lords, I am appealing to the respondent, my lords. 2, 3, my lords.
Very well. Affidavit of service filed to be kept on record. একটা জিনিস লিখে রাখবেন। File your affidavits, disclose regarding the quantum. What is your instruction? Do you have any instruction?
My lord, I am led by Mr. Devrup Bhattacharya, my lord.
That is not an instruction.
My lord, kindly pass on, my lord.
Are you ready to pay the amount? Are you agreeable?
My lord, I don't have any instructions, my lord. I'm
Then
led.
affidavit direction remains. If there is any resolution in the meantime, just inform the court. I'll include it in the list and
My
display.
lord.
Thank you.
Obliged, my lord.
Item number 4.
হ্যাঁ ওটা থাকবে, ওটাই থাকবে, কারণ অ্যাপের করছে না সেটা বলে নিয়ে নিচ্ছে।
Item number 4.
Yes,
Secure
Mr.
Print Solutions Private
Well, I
Limited
appear
versus
for the
State of West
petition,
Bengal.
my lord.
Mr. Siddiqui is laughing means there is nothing in your matter.
I appear for the respondent WBI.
There's a good matter.
For the state, my lord. My lord, this is my lord.
This is a laughter of surrender.
Laughter of no. My lord, your lordship has known me for so many years, my lord. I am not
That's
the one
why
to
I'm saying.
surrender. I am ready to stand in the altar, but not in the surrender. But I'm not going to surrender.
That will be an alternative relief. Yes.
My lord, the matter pertains to, my lord, West Bengal in the State Support Industrial Scheme of 2008. My lord,
Right.
4th round of litigation, my lord.
Excellent.
The issue, my lord, last, my lord, when I came to court, my lord, the issue was this. I have, my lord, been given RC, my lord, there are, my lord, certificates, my lord, which are issued in part 1 and part 2. Subject to me, my lord, the
That
unit.
RC1, RC2 system
Yes,
is
my lord.
prevalent here also.
Yes. So, my lord, I have, my lord, the part 1 certificate. I have the part 2 certificate. I have the, my lord, date of commencement of commercial production that is certified by the authority. And, my lord, the subsidy which I am entitled to receive 350 lakhs admitted by the authority. Out of that 350 lakhs, I received 30 lakhs and odd. Balance not received. My lord, delay was only on the ground that the, my lord, authority, my lord, they are required to issue, my lord, exemption, my lord, those tax certificates based on which I apply for the exemption and I get that benefit. This is the, my lord, modality. Now, my lord,
Authority
lastly,
has to give those certificates, tax exemption. Which authority? The same authority.
the same authority, yes. Same authority. Now, my lord, when I come to court last time, my lord, my only prayer was this, that despite, my lord, there being an admission on the part of the authority, WBDICL, that I am out of 350, I have received 30, balance is not being paid. So, my lord, Lordship, Justice Bhattacharya was pleased to pass an order directing, my lord, the concerned respondent to take a decision.
Acha,
Now, the concerned respondent before, which is, my lord, IDCL, my lord, before, my lord, WBIDCL takes a
respondent number
decision.
4. Yes.
Respondent number 4. Respondent number 2, Director of Industries, issues me a notice out of the blue saying that we want to do an inquiry. Now, in the garb of that inquiry, what they do is they say that the RC certificate has to be revoked because date of commencement of commercial production is wrongly indicated there. RC2. And RC1 also, my lord, it's revoked.
Oh, acha, the entire thing.
And relying upon that order, it's very easy for the WBIDCL, now R4, to say that your RC has been revoked. So there is no question of granting you any benefit, further benefit. So the status now remains, I had only 30 lakhs, balance 320, I did not get. My challenge is in this writ petition to those 2 orders. Now I
I've
will
not
show.
asked you to refund those.
No. And my challenge, my
Direct
lord,
them to do so.
Kindly, I am saying, my lord,
Then he's saying no,
I am entitled to, my lord,
obviously.
320, my lord.
Now,
My lord, I would show from one clause which they have invoked.
Very
DI has invoked 7.2,
Hmm.
which gives them a right to inquire. I cannot say that they could not have inquired.
Right.
But the condition, my lord, there is only twofold. Either I have made an incorrect statement or I have made a false statement. If I demonstrate before your lordship that there is no incorrect or false statement, the date which I had indicated in my application is the date which was considered to be the date of commencement of commercial production, based on which the authorities acted and ultimately disbursed the benefit, then, my lord, 7.2 also could not have been
why is it
invoked.
said to be not the date of commencement? What is the crux of the dispute?
That is not explained in the order impugned. My lord, kindly first takes the order impugned at page 146. This is the order of the DI. But I understand
So up
possibly
to-
there won't be any scope of any interim order in this
Yes,
matter.
but Mr. Datta, only one thing, the admission part, they did not disagree with at any time.
No,
That admission on their
No,
part,
no,
that.
no.
So only on the subsequent event, this DI.
yes.
Very well.
So
Page
I would really like to argue, my lord, promissory estoppel, the conduct of the authority, and, my lord, then, my lord, demonstrate even otherwise, my lord, that clause could not have been invoked. I just want to, my lord, show, my lord, two orders, my lord. I understand there is no scope of interim order here, so I won't waste your lordship's time. Kindly takes 146.
146, yes.
My lord, second paragraph,
DI
company applied,
communication. This is the DI communication.
this is the DI order. Company applied for RC2, second paragraph, my lord.
Right.
Mentioning 29th December 2008 therein as expected date of commencement of commercial production, which clearly violates 7.2 of WBSSIS 2008. RC2 was issued on 30th of August 2012 under this scheme. Application of certificate of commencement commercial production made by the company on 27 December 2011 and stated its date of CCP as 29 December 2008.
Mr. Datta, I've seen it. Please show me 7.2.
Yes, ma'am. Kindly comes to page 48. The unit The unit shall be required to submit application in form number 1A to the DI for RC Part 2 at least 1 month ahead of commencement of commercial production. And the application shall have to be supported with authentic document certificates on actual investment in fixed capital on the date of application, estimated quantum of production of each individual item of finished goods, and balance sheet of the unit for the preceding 3 years, duly certified by any chartered accountant firm, and such other documents as are considered necessary by the DI. There is no dispute that, my lord, I had, my lord, complied with this. Now
You
fees
had not
7.5.
applied. You had not applied before 1 month.
That is not
the-
what they are saying. Kindly sees now, my lord, 7.5.
Hmm.
If at any stage it is found on inquiry that the particulars furnished by the unit are incorrect or false, and the unit concerned shall remain liable to refund the incentives enjoyed earlier and will be disqualified for enjoying further benefits of the scheme upon revocation of RC. So, my lord, when, my lord, after all this, I, my lord, come to court and, my lord, seek a direction on WB, the respondent number 4, to, my lord, consider or pass a reasoned order why, my lord, I would not be, my lord, disburse the balance incentive, they, my lord, invoke 7.5 because the other two parts of 7.5 is really the consequence. Revocation of RC would mean, my lord, disentitlement of this, my lord, incentive under the scheme. So, my
Is
lord,
there any sanction, Mr. Datta, for not applying 1 month before? I don't see any sanction here. 7.2 says you have to apply at least 1 month before. Is there any?
my lord, the at least 1 month before I have applied, my lord, 3
Before.
months. Yes.
Well, so let me hear Mr. Siddiqui.
And, my lord,
Yes.
only
Yes.
the
Yes.
order of the, my lord, R4, my lord, at 148, because it is really on the basis of the DI's order that the R4 has rejected.
Yes, that has been reliable.
Because that
So
is
one,
co-
if that goes, this also goes.
Yes, that is the, my lord.
Yes, Mr. Siddiqui.
Admittedly, my lord, he has applied at least 3 months after, 3 years after the date of commercial production. That is also an admitted fact.
So it's for that, can you revoke?
My lord, he has to apply 1 month, at least 1 month before.
What is the sanction for not doing that?
The clause 7.2 stands at his face. The clause 7.2, my lord, this is a
7.2 does not give any sanction for that. If that is not done, what is the sanction?
my lord, that if it is not done, he is not entitled to, my lord. This is incentive, my lord.
He
What-
is already entitled.
my
In
lord,
this
but-
case, you have admitted that
my lord,
promissory estoppel
That
applies.
cannot be promissory estoppel in the case of incentives, my lord.
Acha.
my lord, subject to your lordship's kind sanction. My lord, in the cases of
Very well,
incentives,
direct affidavits instead of wasting for
cases
the
of
time.
incentives, rebates
It's,
and
it's on
concessions,
the merits.
my
Very
lord,
well.
strict interpretation of the scheme, my lord, that is the
Got
law laid down by the Honorable Supreme
Learned
Court.
counsel for the petitioner contends that although the respondent authorities admitted that the petitioner was entitled to incentives under a state, this is a union scheme, union government scheme,
No, my lord,
State.
state, my lord, West Bengal.
under a state scheme of West Bengal and initially disbursed a part thereof being to the tune of rupees 30 lakh
Approximately.
approximately, comma, the balance amount was withheld by the respondent authorities when the petitioner moved court in such regard, comma, a direction was passed by a learned coordinate bench to the effect that the respondent authorities are required to furnish reasons as to why the balance was not yet disbursed. Next para, however, comma, as an afterthought, comma, the respondent authorities intimated through respondent the respondent authorities korben na. The respondent number 2 intimated to the authorities that the petitioner was not entitled to the subsidies in view of alleged violation of clause 7.2 of the relevant scheme. Next para, on such premise, comma, the respondent number 4, comma, which was the disbursing authority, comma, also resiled RESILED from its previous position and refused to disburse the balance amount to the petitioner. Next para, learned counsel argues that apart from the respondent authorities being barred by promissory estoppel, comma, even under the clause referred by the DI, that is clause 7.2, comma, no occasion arose for the respondents to refuse disbursal of the balance amount of incentive. Next para, even the provision of refund of incentives and disqualification of the beneficiary thereof, comma, as stipulated under clause 7.5 and its subclauses of the scheme, comma, have not been satisfied in any manner in the present case. Next para, learned counsel for appearing for the respondent authorities
No,
controverts such allegations and submits that clause 7.2 was not complied with by the petitioner. That apart, comma, it is argued that promissory estoppel is not applicable in the present case. Be that as it may, comma, since an arguable prima facie case has been made out by the petitioner for the writ petition being heard on its merits, comma, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within 1 week thereafter. The matter shall be listed for hearing on July 17, 2023.
2 orders have been impugned, my lord, in this said petition.
DI's order and my lord
And
R4's
the
order.
decision order, which is at page 148.
Obviously,
I mean, that
one is
not-
consequential to the other.
Yes.
Because it is passed pursuant to the order passed by this honorable court.
So I should stay both orders, Mr. Sid.
It is
Petitioner.
mentioned in the lordship's order.
Now you have read the brief and you are apprising me.
No, lord, I have read the brief, my lord. Clause 7.2 has been challenged.
That you have read, definitely. So you did not know that 2 orders were challenged, that he
No, no, I
started
always-
with that.
always, because your lordship was dictating the order, your lordship, because he placed reliance only upon page 146.
If one goes the other.
148 is the reason order passed pursuant to the direction of this honorable
See
court.
take a printout of the server copy.
Great.
Yes.
For
Next one.
hearing, item number 5.
Pearl Corporation.
Pearl
Yes,
Corporation.
Mr.
Well, I had fixed my time limit 5 minutes, 5 minutes. But yesterday, my lord, Mr. Sinha had taken your lordship through some of the documents, my lord, from the affidavit in opposition, which were contemporaneous document while executing the contract.
Right.
Now, my lord, at the time of extension, my lord, we had said that the extension is given without prejudice to claim liquidated damages, and that time is the essence of the contract.
Yes.
Now, my learned friend's client have certain grievances against me that I have not carried out my reciprocal obligations in time. Therefore, my lord, there is a cause for seeking damages, compensation, whatever, because whatever work he has done, it has been paid. There is no dispute on that. Work done, money paid. Now, what remains is two things. First is termination. Second is the fallout of the termination or the consequential effect of the termination, that whether they are entitled to any damages or not, whether in this proceeding or any other proceeding, that is for your lordship's consideration. Assuming that they are making the prayer on the second aspect as a consequential relief to the first relief, that is the termination to be set aside, please have a look towards section 55 of the Contract Act. Ajay.
Contract. Yes, Mr. Dutt.
Effect of failure to perform at fixed time in contract in which time is essential. Because I have, even at the time of extension, I've put them on notice that time is the essence. I'll take your lordship to that document. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before the specified time, and fails to do so, here I have allegedly failed to do so, any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee. Here the promisee is the petitioner. I am the promisor in respect of my reciprocal obligations. If the intention of the parties was that time should be the essence of the contract. But please skip over me the second part, take the third part. Effect of acceptance of performance at time other than that agreed upon. If in case of a contract voidable on account of the promisor's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than that agreed, the promisee cannot claim compensation for any loss occasioned by non-performance of the promise at the time agreed upon, unless, this part is important, unless at the time of such acceptance he gives notice to the promisor of his intention to do so. But I fail in doing something at a specified time, then the part which has not been performed by me becomes voidable at the instance of the petitioner. But still, the petitioner can have a right in a case of delayed performance by me, if at the time of accepting my delayed performance, he had put me on notice, sir, I am taking it, accepting it, but I am reserving my right to claim compensation. But that has not been done. Therefore, my lord, the consequential relief also in my very respectful submission, my lord, is also not maintainable in law, my lord. But I think, my lord, 5 minutes have exhausted.
No. Wait, thank you, Mr. Dutt. Yes, Mr. Dutt.
Lord, yesterday, the judgment cited 2023 2 SCC 703.
Take the microphone a bit closer.
Yes. I want to draw your kind attention to 3 paragraphs. That is paragraph number 67, maintainability of the writ petition. That is MP Power Management Company Limited.
Yes.
They have cited.
Right.
Paragraph 67.
67.
Page number 755.
Yes.
ABL marks a milestone, as it were, in the matter of superior courts interfering in contractual matter, where the state is a player even after the contract is entered into. A petition was filed under Article 226, wherein the respondent, which was incorporated under the Companies Act, reputed an insurance claim made by the appellant writ petitioner. This court undertook an elaborate discussion of earlier case law. We find that this court dealt with the several obstacles which were sought to be posed by the respondent. They included disputed question of facts being involved, availability of alternate remedy, and the case involving entertaining a money claim. This court went on to hold as follows. that is relevant to that ABL judgment. From the above discussion of ours, the following legal principles emerge as to maintainability of a writ petition. In an appropriate case, a writ petition as against a state or an instrumentality of state arising out of a contractual obligation is maintainable. First. Secondly, merely because some disputed question of facts arise for consideration, same cannot be a ground for refuse to entertain a writ petition in all cases as a matter of rule. And third is, a writ petition involving a consequential relief of monetary claim is also maintainable.
This was criticized subsequently. Next paragraph and the paragraph after that. 68 and 69.
No, what happened actually, this judgment is rendered by the 2 members bench. And that ABL also.
But it was considered. ABL was considered, not 2 judge bench could not overrule,
Yes.
but 2 judge bench interpreted ABL by virtue of para 28 of ABL itself.
Yes.
In paragraph 68, Mr. Dotto, para 28 of ABL itself has been, the very next paragraph of ABL has been considered. And in the next paragraph 69, it has been said that steered clear, some other judgment was also referred to, which was probably of a similar strength bench.
Paragraph 71 next, kindly.
71. Yes.
The court went on to approve of the ABL and observed that this court had declared that no decision lays down as an absolute rule that in all cases of disputed question of facts, the parties should be relegated to a civil court. We may also notice para 29, novel resources. Although the scope of judicial review or the development of law in this field has been noticed herein before, particularly in the light of the decision of this court in ABL International, each case, however, most be decided on its own facts. Public interest, as noticed herein before, may be one of the factors to exercise the power of judicial review. In case where the public law element is involved, judicial review may be permissible. But there are so many observations in this.
Yes, both are there.
I
Both
think
are
this is very
ultimately
confusing
the
on this
crux of the decision is that if the court feels it can interfere, it does not, it won't interfere.
Kindly
This
consider.
is the crux of the matter.
Yes,
Between the lines.
arbitration,
But
arbitrary.
Mr. Dotto, what is the public element in your case? You are Pearl Corporation, you are an individual entity. I'm a juristic entity. What is the public element involved in their wrong, alleged wrong? You say they have not given your money on the basis of the contract.
Not only there is one only criteria. I have cited one judgment, your lordship.
Yes,
That judgment is clearly on the private dispute also. The private party is the state.
Where do we draw the line, Mr. Dotto? Private dispute and public dispute? Unless a public element is involved even in a private dispute, Mr. Dotto, can we do that?
In practically, here, what is the fact in this matter? There is a building that is a police headquarters. That is the main facts. The facts is this.
True,
The police
I've seen
headquarters
that,
and
yes.
police headquarters within the state mechanism, that is absolutely within the state. And that building in a renovation of G+8 story building was entrusted to the petitioner. And that is violated.
But Mr.
The terms of the
Dotto,
contract has
they
been
are not
violated.
violating. As per their allegation, your act is detrimental to the public interest because you are not completing it in time. That's there. So if the police cannot be housed there, they will be roaming around on the streets and harassing people.
That is their point.
So that's why, Mr. Dotto, there is a scope of hampering public interest if you don't construct it quickly.
At the same time, kindly consider they have
Your grievance is different. Your writ petition's grievance, they're not giving you your money, contractual money.
not only money, they have also given a site also for doing the work.
Very well.
And most probably my extension of second occasion, that is not expired. Within that period, they cannot, because there is as per the agreement, there is a terms, until and unless they impose upon me the cost and penalty, they cannot directly terminate my contract. And as of now, my writ petition to some extent has become infractious because when I filed the writ petition,
Definitely, yes. You're not claiming damage.
there was no third party.
Right.
But when I moved the interim injunction, that was refused and giving a rider, the fate of the writ petition will binding upon the parties. That means that clause is there. If you call lordship see the first order.
Definitely, that is there.
So that my point is this, that this is completely vindictive in nature because we have filed a first occasion a writ petition for getting our money. That they are duty bound to pay money within time that they have not paid.
Yes.
For that, during the pendency of the first writ petition, they terminate me. During the pendency of my first writ petition, without getting the leave of this court.
Right.
Then the first writ petition became infractuous. Liberty was given by the coordinate bench. Then I filed the second writ petition for termination of the contract. During this pendency of the writ petition, they have also allotted to some other persons. My only point is this, there is specific clause in the contract. Before terminating me, they have to impose the cost and penalty and compensation at the time of making payment. And thereafter, without deducting any amount, they have cleared the amount as toto. So there is no latches in my part. So they are not in a position to deduct money. That is the point. Kindly see my repetition page number.
You say at least the writ court decides that you are entitled to damages and at best relegate you to the civil court for
Yes,
calculation.
yes. Because as of
That
now,
is
there is no relief from this.
Other relief cannot be
Because
given,
this
obviously.
court cannot adjudicate the quantum of damages. My
You are
prayer is
fair
this.
enough on that.
Yes, I can. Liberty may be granted. I shall file the civil suit over damages,
Very well.
and that must be hold the termination is illegal.
That must be.
Hold the termination was illegal. Cancellation of agreement was illegal.
Then I have to hold.
Otherwise,
Otherwise, you are not entitled.
no, not like this. But that as of now, that is the only
No,
pending issue.
Mr. Datta, if it's not palpable, then writ court may not do it. Then the entire thing may be relegated to the civil court. If it's palpable, vindictiveness, malafidus, if that is accepted
Violated
by
the
the
terms
court,
of the agreement.
violating terms of obviously is there,
That
and
is-
state action has to
that
be
is
on a
my
higher.
prayer. That is my prayer.
If that is accepted,
Hmm.
then only the court will say, yes, palpably it's bad, the termination is bad.
Yes.
Therefore, you are entitled to damages, quantum, writ court cannot.
Yes.
This is the
Yes.
best order you can get. And the worst order you can get is obviously outright dismissal.
Hmm.
And the middle thing is that, yes, there may be a scope of getting, if the dispute is dependent on the facts, whether even you are entitled to get, whether you are entitled to get damages at all, whether the termination was bad for other reasons, that's something which is palpable, then the entire thing has to go to the civil court. These are the three options.
Yes.
So let me think over the options. I'll draw lots and pass my order soon.
Look, I am relying my cited decision, the Supreme Court. There is when there is a
Definitely
clause,
not, yes,
when
I-
there is a clause, so they are bound by this clause.
Yes,
That is my
definitely. Arguments concluded, judgment is reserved.
Only one line, the judgment which my learned friend has cited is also considered in 2023.
Yes, it did. Yes.
This judgment is elaborately cited on the 50 years all contractual matters.
Yes.
At least 70, 80 judgments, and there is a clubbing everything, confusing one. That's judgment. Until the three members bench is decided what have to do, we are in all confusion. Which followed, which should not be followed.
Right. The ultimate crux, what I told you, that is the crux which has been distilled from all these judgments. Well, thank you.
I'm grateful, Lord.
And your best point, Mr. Datta, is that they are the police. Anyway,
Item number 6.
thank you. 6.
HON'BLE Extrusions Limited and another.
Replay, opposition file হয়নি? তাহলে replay কি করে আসবে?
6, yes, Milord, it is filed. Your
Opposition, you have to file.
Lordship, the state, they have filed and I have given my reply also. Directions.
They have given a copy to you, but probably they have not filed in court. So how can I take on record the reply? The reply টা কি করে হলো তাহলে? আমি নিয়েছি।
They don't turn up, Milord. 2020, Milord, during
This is
COVID.
a reply to what? Something which is not on record.
This is a reply to opposition.
That which has not been filed as yet.
Yes, so they should come today and Milord,
If they don't file, I cannot take the reply on
then
record.
kindly take my writ petition because this
But a
is.
writ petition I can take definitely. Please, move on.
Kindly, Milord.
Yes.
Then your lordship will ignore the opposition.
I will ignore the reply if necessary. Yes.
Milord, this is Milord.
Check the microphone
Yes.
towards me. Yes.
Milord, a scheme was floated, Milord, by the state authorities,
Hmm.
allowing me to, Milord, set up a factory.
Hmm.
Milord, also saying that I will be entitled to subsidies.
Hmm.
On that basis, Milord, I have set up a factory,
Right.
HDP, pipes, etc.
Hmm.
Now, Milord, I was sanctioned a subsidy also in terms thereof, around 2.88 crores. Thereafter, Milord, I was also sanctioned in terms of the scheme, interest subsidy, Milord, also around 57 lakhs. Till date, Milord, that payment has not been paid despite their admission that yes, you are entitled to this. Now, the issue, Milord, there is a lot of correspondence, Milord. There, Milord, there is a particular clause which
Yes.
says that it should be adjusted against yearly VAT. And in case it is not possible to adjust against VAT, you will be paid by check
Hmm.
at the 10th year. So, Milord, we have written to them that the VAT is not possible to be adjusted at all
Was
because
this scope there in the scheme?
in the scheme, this is, Milord, a clause in the scheme.
Very well. Yes. Then
Then, Milord, what happened is So they were not paying. We also tried to say that, look, we are not liable to pay any VAT. Here are the documents that VAT is not payable by me because my supplies are outside the state. So you treat me as an EOU, which is also a term in the scheme, that EOU where VAT is not payable, they will be paid, my lord, by the 10th year. Then, my lord, the sanction letter says you get a notice or a letter from the Directorate Income Tax saying that you are not liable to pay any VAT. The respondent authorities themselves obtained a letter, which I have annexed, which says that VAT is not payable by HON'BLE, and therefore they should be treated in terms of clause 16.10 of the scheme, that since it is not possible to adjust VAT, pay them by the 10th year. Thereafter, I make representation. I am not paid.
10th year has come now.
Yes, my lord, the scheme is of 2011.
You commenced business when?
Commenced business, my lord, 2011.
11.
April 2011.
Very well. That 10 period.
Yes,
That thing is.
capital subsidy, my lord, granted.
What is the last stand, Ms. Banerjee? Last stand. There's last stand. What do
Their-
they say now?
My lord, in the
To their case
opposition,
also, so that I can deal with that.
because the opposition is not with your lordship, my lord, but it is
What
with
have
me.
they? Yes.
They are saying there
Hmm.
that subsidy is a privilege. It is not something you're entitled to. To that, my answer is that, which I've stated in the reply, and also your lordship knows, my lord, there are judgments that yes, if this was a subsidy which you have not granted to me, the sanctioned or confirmed the amount payable to me, then yes, I can say that I'm challenging something which I'm not entitled to. But here you have said, yes, you are entitled to this payment. Thereafter, going back on your word.
Six, my lord.
Yes, please continue, Ms. Banerjee.
My lord,
Yes.
I'll just take your
I'm
lordship.
in the midst of hearing, almost heard.
Only 1 minute, my lord, of your lordship's precious time.
No, not in the middle of the sentence. Definitely not.
But I
Yes,
appear
please
for the-
continue,
I
Ms.
appear
Banerjee.
for the respondent.
Lord, then, my lord, in that case, my lord, I stand in a position where I have a legitimate expectation. And also, my lord, it's
So
promising.
you want to distinguish on that footing that it's a privilege is not a right, but here it's beyond privilege. They've already accepted, granted, and after that they cannot resist.
Not disbursing.
Yes, Mr. Abhishek. This is the crux of it.
No, my lord, apart from the crux of the issue, my lord, this matter, I appear for the respondent WBIDC.
Good to know that, but
My lord, all along in the orders, my name has appeared with the then learned advocate, learned additional
this is
advocate.
the
my
most important question
My
involved.
lord, the state is represented by someone else. The state was under the impression, I called up the learned AOR's office. They were always under the impression that I am appearing for the state respondent. So state is the answering respondent in this writ petition, my lord.
State has been served probably.
State has been served. State has
That's
they have
the
exchanged
times,
affidavits
my lord.
also.
Who are you for?
I appear for the respondent WBIDC. But my,
WBIDC has to disburse them.
my lord,
Yes.
I am only the disburser authority. It has to come from the state.
You
No.
disburse. State is not appearing. They have not opposed.
Sir, I have
You
informed the
disburse.
learned advocate in records office yesterday. My lord, they are engaging someone in this matter for the state. Your
Let
lordship,
them engage after the matter is over for the
My
appeal.
lord,
Mr.
kindly
Yes,
grant me a
yes,
week's
sir.
time, my lord. Kindly grant me a
That will
week's
be required, and engagement will be required for the appeal, not for this matter.
My lord,
Can you lordship
Sufficiently
kindly-
pending for sufficiently long,
You
more
put
than
them
10 years they have waited. They have waited 12 years.
yes,
You are not releasing the subsidy. Why?
and my lord, the sanction also granted by my learned friend himself.
That is your opposition. You did not
This
file
is
it.
there, my lord. The opposition has been filed. I have been told. A copy has been
Told
served
by whom, Mr. Siddiqui?
by the office of the
My
learned.
officer tells me it has not been filed.
No, the reply of opposition.
Yes, exactly. Reply has been given to you. You have given a copy of the opposition to them, not filed in court. Where is the opposition?
My lord, I am telling you, my lord, the
Don't take it so casually, Mr.
Your lordship, I
Siddiqui.
kindly
You are
appreciate-
appearing not in a drawing room of somebody.
I did not file the affidavit of opposition. My lord, I did not affirm the affidavit. But
Why are you appearing in the matter then? You have to take liability if you appear for somebody.
I appear for.
You're casually saying I have filed. That's there.
No,
It's not there.
Well,
Where is the
I
opposition?
means the state, my lord. I have not filed. I appear for the WBIDC.
Mr. Siddiqui, you are appearing for WBITC. Did you file any opposition?
WBIDC was not filed.
Then why are you supporting the state for this? Why are you taking the stand that you have filed?
No,
It's
the-
already there.
the-
You have filed or not?
WBIDC has not filed any affidavit.
That's sufficient.
WBIDC, for the state.
What is your stand in the matter? Forget the state.
my-
You are the WBITCI. You cannot just shirk your liability by saying I am the disbursing authority. You have to disburse. Why are you not disbursing? Has the state prevented you?
Lordship, I have taken the stand of the state, my lord. Your lordship,
Then argue that.
my lord, your lordship may kindly take the affidavit position of the state respondents.
Why should I? It is not on record.
Oh my God, attorney.
What is their stand? Argue on law. Why are they not entitled? Apart from privilege, a privilege is not a right. Any other point?
My lord, they were sanctioned, my lord, initially a sum of rupees 288.32 lakhs for the fixed capital investment subsidy. And
That's
some
saying
amount,
no by now.
Ah.
What is your reason for not giving?
my lord, they
Get
have
ready,
not,
I'll give you 2 minutes.
Ah.
Get ready during the hearing and argue.
my lord, they have not complied with clause 16.3 of the scheme.
Show me that. Which page? Sixteen point.
3.
Page 27.
Page 27.
Yes.
My lord, these payments are to be continued for the periods outlined in the scheme or till the financial cap is reached, whichever ends earlier, and the period shall not be extended further, even if any balance entitlement remains at the credit of the unit at the time of expiry of the period as above.
What is the period outlined?
My lord, the period outlined, my lord, is this: the date, first date of commercial production is 18th April 2011. And
Please
they
come
have
to 16.10.
subsidy on fixed capital investment for units other than mentioned at para 16.9 shall be paid in 10 equal on annual installments by way of adjustment against VAT paid by the unit in the previous year. In case it is not possible to fully adjust the same against VAT paid by the unit on year basis, balance entitlement at the close of the 9th year shall be paid to the unit through account pay check at the 10th year.
10th year is 2021.
My lord, it is for the period which has been extended. But in this particular case, it is for 5
In
years.
case it is not possible to fully adjust the same against VAT paid, here it is not possible, Mr. Siddiqui, because they are not liable to pay VAT at all. They are supplying outside the state. That is a stand taken by the petitioner.
That is,
Outside the state, and that has been resolved also because they have the authority, you have obtained some certificate from the appropriate authorities indicating that no VAT is chargeable on their production.
right.
So after that, if that be so, Mr. Siddiqui, then in case it is not possible to fully adjust the same against VAT applies, if that applies, then balance entitlement at the close of the 9th year, the balance entitlement after disbursing a minuscule amount of some lakhs remains, and that you have to disburse at the close of the 9th year. That 9th year closure arrived in 2021, and now we are in 2023. So how does it apply at all, your 16.3?
My lord, no, my lord, input VAT, my lord, they have never paid the VAT in the state
They are
of
not required to pay the VAT.
because the VAT certificate is required. This is
That
entirely,
has already been obtained by you.
my lord, the scheme is VAT compliant scheme, the entire scheme. If your lordship now reads the scheme, my lord.
Yes.
If your lordship kindly takes the scheme.
Yes.
Mode of payment is 16.
The scheme is a VAT compliance scheme,
My lord,
not
because
not an incentive or subsidy
my lord, the
scheme.
incentive is given on the basis of the certificates of VAT produced by the Commissioner of Commercial Taxes.
Let us see that.
Number
So
16, my lord.
first, let us go to the initial paragraphs of the scheme.
My
Let
lord.
us see the purpose.
The purpose is to grant incentive to the industries so that we promote the industries in the
extend
state
certain additional financial support for promotion
of
of
large and medium scale
large
industries.
and medium scale industries in the backward regions of the state.
My lord.
VAT has no connection with this.
My lord.
VAT is one of the requirements. They have to give a VAT certificate. If they don't pay VAT certificate, 16.10
This is
applies.
this is the preamble of the scheme. This is for promoting the industry in the
What does
state.
VAT come in the
My lord,
promotion?
VAT is the main ingredient for
Come
compliance
to
of the scheme.
16. Come
That
to
is the
16.
main ingredient. If your lordship kindly sees, my lord.
How do you interpret 16.10, Mr.
My lord,
Siddiqui?
lordship kindly reads the entire 16.
How do you interpret 16.10?
16.10 is that they have to pay the VAT. My lord, they have till date not paid the VAT to this state of West Bengal. They have been paying VAT to some other state. Our output VAT is much lesser than the input VAT paid there. If your lordship kindly sees clause 16, my lord,
How do you interpret the second sentence of 16.10?
in case it is not possible to fully adjust the same against VAT paid by the unit on the year basis.
Does it say anywhere that they have to be liable to pay VAT for getting this
My
subsidy?
lord.
Where does it say?
But lordship may kindly come. Mode of payment, your lordship may kindly
Mode
come.
of payment is different, Mr. Siddiqui.
Lordship, please come to the kindly.
Eligibility.
My lord, all the entitlements, 16.1, all the entitlements under the head fixed capital investment subsidy due for the respective year, interest subsidy, employment generation subsidy, EIP and CIP
Mr.
will be
Siddiqui,
credited to the account towards.
the more you
advance-
raise your voice, the more you lose your credibility as counsel of this client. Please come to page 14. Your raising of voice won't improve your case.
16.1,
Your raising of voice won't improve your case. Please come to clause 14. Don't be blind to whatever is there in the record.
Lord, I
Read
am
out 14 loudly.
a separate state
What is the heading of 14?
eligible units for investment under
No, it's eligible incentives.
incentive.
Don't lose your cool. Read it.
My lord, I never lose my cool. My lord,
Then you are not reading, you are reading incentives as units.
eligible
This is
incentive.
basic English.
I am colorblind also. Eligible incentives.
This
for
is
investment-
black and white. There is no question of color blindness.
Lordship,
It's
guide
not
me, my-
color, Mr.
but-
Siddiqui. It's
your
something else.
your
It's
lordship-
bias.
Your lordship is not, my lord, just my lord for my.
You will have to read 14, then you proceed. You
My
will
lord,
do
a
as the
separate-
court says.
My lord, a separate state supports package is envisaged for units with investment.
This
in
is
such-
the eligible incentives for investment
Ah,
under heavy investment category.
category.
Are they heavy investment?
No. This is for the entire scheme. Clause 16 is for
Please
the
read out 14 caption.
eligible incentives for investment under heavy investment category. They are not heavy investment.
Then this does not apply.
This applies for everyone. This clause 16 applies for the entire scheme. Not
I'm
that
not who is speaking of 16. What are you saying, Mr. Siddiqui? If they're not heavy, then 14 does not apply. So read 16 now.
a mode of payment.
Very well, read it.
No claim shall be entitled if it is found that the concerned unit defaulted in the matter of payment of VAT dues under the West Bengal Value Added Tax Act 2003 and Central Sales Act 1956. Payment of such incentives shall be governed by the procedure laid down below. 16.1. All the entitlements under fixed capital investment subsidy due for the respective year, interest subsidy, employment generation subsidy, EIP and CIPPA will be credited to the account of the eligible unit towards advance payment of VAT as and when such claims are preferred and admitted. So, Malad, this entire scheme is based upon payment of VAT. Whenever unit submits its VAT certificate, which is, my lord, your lordship kindly sees 16.5. The unit shall will also have to apply to the Commissioner Commercial Taxes West Bengal in the form shown at Annexure 5, requesting him to certify the total amount of VAT paid during the year in respect of which the application has been made. Such application should be filed at the close of each year. Upon receipt of such application, the Commissioner Commercial Taxes West Bengal would verify the payments and other particulars as contained in the application and issue a certificate to the Managing Director WBIDC certifying the VAT paid by the unit during the year under consideration.
Read on.
The Managing Director WBIDC on receipt of the certificate from the Commissioner of Commercial Taxes will ascertain the entitlement of the unit after adjusting the other benefits enjoyed by the unit against the same investment, if any, and will issue check twice in a year in respect of the said unit in favor of the Commissioner Commercial Taxes West Bengal to be deposited by him into the Reserve Bank of India, Kolkata Government Treasury through appropriate VAT challan as advance payment of VAT for the year following that for which the certificate has been issued by the Commissioner of Commercial Taxes West Bengal.
Come to 16.9.
100% export-oriented units and the units exempted from paying VAT CST will be entitled to FCIs only as are admissible under the WBS IS 2008 as amended up to 31/12/2010. Payment towards this subsidy will be made by WBIDC directly to the unit through account pay check in 10 equal installments for such amount which would otherwise have been adjusted against payment of VAT. This is for WBS.
Now read 16.10.
Subsidy on fixed capital investment for units other than that mentioned at para 16.9 shall be paid in 10 equal installments at para 16.9 shall
Other
be,
than
at para 16.9 shall be paid in 10 annual installments by way of adjustment against VAT paid by the unit in the previous year. In case it is not possible to fully adjust the same against VAT paid by the unit on year basis, balance entitlement of the clause of the 9th year shall be paid to the unit through account pay check at the 10th year.
Very well. Anything else, Mr. Siddiqui?
Well, this unit, my lord, is not paying back to the state of West Bengal.
Obviously, since they're not paying VAT, you are not.
But he is not in that because
Why did you disburse a portion of it?
But that disbursal will not act as an estoppel against me, my lord. We have.
Why did you disburse that in the first place?
That was a wrong fault on my part. But
Can I
that will
record that? Can I record that?
Well, you lordship may kindly record that.
Very well. Yes, please continue. Yes.
But the sanction of fixed capital investment subsidy which was issued
Hmm.
on 2nd December 2011,
Hmm.
it was not a blanket sanction which was issued at page 59 of the writ petition.
Hmm.
It was, my lord, with certain conditions which conditions had to be fulfilled for being
Yes.
entitled to fixed capital investment subsidy and interest subsidy.
Right. Let us see that.
Page 59, my lord.
59 I've got, but read the relevant portion, Mr. Siddiqui.
Clause A only, my lord, I will have the subsidy will be dispersed as and when the funds are made available to WBIDC by the state government as per clause number 16 of WBSIS 2008.
Yes.
So clause number 16 is very important, my lord. Then again,
Now, please come to B. I'm
The
sorry,
maximum
C,
limit
C, C.
the company has to submit relevant certificate from Commissioner of Commercial Taxes, West Bengal, certifying that the unit has not defaulted in the matter of payment of VAT dues under the Act before release of incentives.
If VAT is not chargeable, how can they be defaulters in payment of VAT?
But the certificate has to come from the Commissioner of Commercial Taxes.
That they say has come.
That has not, my lord, I do not know, my lord, where my learned friend has got that certificate from the Commissioner of Commerce. I subject to correction, my lord, because I was not there. That certificate in my lord, my instruction.
If the certificate is there, Mr. Siddiqui, then what will be the legal position?
Even then, my lord, being the disbursing
Say it in equal volume as you started.
Even no, my lord,
No, why not?
I started.
You should be same.
My lord, I started with a humble prayer before lordship that I appear for
Your
the
humility is exuding from your arguments, Mr. Siddiqui. Your humility is very clear from your arguments. Anyway, you are not on humility. We are on law now. Now, what is the law? If they have given that certificate or if you have procured that certificate, what is the law then?
But the law is I being the disbursing authority, I have to fully, my lord, take into consideration the entire
Are they
scheme.
entitled to VAT the subsidy then?
Clause 16, I have to comply with clause 16 of the scheme.
Are they entitled or not then?
They are not entitled. My lord, in my humble submission.
Even if they produce a certificate to that extent, they are not entitled.
Certificate saying that they have paid the VAT.
Your language does not say it. The relevant certificate from Commissioner Income Tax has to be, Commercial Tax has to be certifying that the unit has not defaulted in the matter of payment of VAT.
Question of default will come when I'm entitled to pay the VAT. The question of default will never come when I'm not entitled to pay the VAT.
Exactly. That is what I'm trying to say to you.
Then I'm not supposed to pay the amount when they have defaulted.
What does it say?
It means that
What does it say so in the scheme?
Not at all, my lord. If your lordship kindly
Scheme says subsidy has to be given by you if they are small scale or middle scale or whatever industry.
Small scale, middle scale,
Medium
large scale,
scale.
heavy
Yes.
scale, anything.
Yes.
My lord, but my humble submission before your lordship is clause 16.16 of the scheme, which relates to mode of payment.
So this is all, Mr.
My lord.
Yes, Ms. Banerjee, show me that your certificate has been.
May I take your lordship's leave, my lord, if your lordship.
Why? You will take some medicine for pressure?
Well, that is not required.
Not required. Then take your seat.
Well,
Where are you living?
I have to go before a honorable division bench. My lord, my junior is here to assist your lordship. My lord, I'm extremely-
Yes, Ms. Banerjee.
Page 74
Yes.
is a letter, my lord, from WBIDC, which says it's dated 24th May 2018. With reference to your above letter, kindly find enclosed a communication from the Additional Commissioner of Commercial Taxes that speaks for itself. My lord, kindly turns over the page, my lord. This is the communication.
Who is writing to whom this?
Yes, this is, my lord.
They are writing to you.
Yes, they are writing.
All right, all right.
Probal De Milord is of West Bengal government, writing to me, enclosing this. The clarification of clause 16.10. Kindly sees.
Read the relevant portion, Ms. Banerjee. I'm sorry.
Kindly see, my lord, B. The applicant alum is liable to pay VAT on the intrastate sales, but net VAT payability for the entire period 11-12 to 15-16 is reduced to nil due to excess ITC set off against VAT output tax liability CST is payable on interstate sales, but the applicant dealer, even after adjustment of ITC is my lord input tax credit I have learned, and ITC claims carried forward. This situation of nil VAT payability being reduced to nil arises due to inverted duty structure characterized by higher rates of tax on inputs, etc., etc. Then, my lord, last line. In light of the above, last 3 lines, I am of the opinion that the present case to be treated not as EOU dealer, but as a situation where the applicant dealer is not in a position to fully or partly adjust VAT payable with the sanctioned amount of capital and interest subsidies as per terms and conditions of the scheme. So, Milord, my VAT liability was nil.
Yes.
Because, Milord, it stood adjusted, Milord, the input tax credit. Milord, I have come to take an instruction that tax, Milord, is payable on purchase and then it can be reduced when, Milord, it makes a sale. So in my case, it was never payable in all these years. This is
the petitioner's contention is that the petitioner is entitled to subsidy stroke incentive under a scheme floated by the state of West Bengal, being the West Bengal State Support for Industries Scheme, 2008 within bracket, as amended up to December 31, 2010, bracket closed. Full stop. It is contended that the petitioner started production in the year. No, I'm sorry. The petitioner was granted the sanction for such subsidy on December 2, 2011. Full stop. Thereafter, some amount out of the total subsidy was disbursed in favor of the, nothing was given.
Also, interest subsidy was subsequently granted. That is what I mean, which is in 2015, 16 January 2015.
Interest subsidy.
Yes.
আচ্ছা কি বললাম এইটা কেটে দিন এই সেন্টেন্সটা thereafter থেকে thereafter in the year 2015 interest subsidy was also granted to the petitioner by the respondent authorities. Full stop. However, the subsidy was never disbursed in favor of the petitioner. Full stop. Next para. Learned Counsel contends that as per clause 16.10 of the scheme capital scheme, in cases where it is not possible to fully adjust the subsidy against VAT paid by the unit on year basis, balance entitlement at the close of the 9th year shall be paid to the unit through account pay check at the 10th year. First up, in the present case, the petitioner is governed by the second limb of clause 16.10, since the petitioner is not liable to pay VAT at all. Full stop. Next para. It is contended that the petitioner was informed by the respondent authorities themselves that there was a communication on the part of the additional commissioner of commercial taxes, West Bengal, which clearly indicated that the VAT payability of the petitioner was being reduced to nil, NIL, due to inverted duty structure characterized by higher rates of tax on inputs within bracket raw materials, bracket closed, locally purchased, and lower rates of tax on intra-state sales of final products. Full stop. Next para. As such, the communication, which was annexed to the letter sent by the respondent authorities to the petitioner comma, also mentioned that the petitioner be treated not as an EOU capse dealer, but as a situation where the applicant dealer is not in a position to fully stroke partly adjust VAT payable with the sanctioned amount of capital and interest subsidies as per the scheme. Full stop. Next para. Learned counsel appearing for the respondent authorities vociferously argues that a privilege is not a matter of right. Full stop. Since a subsidy under a scheme of the state is merely a privilege, comma, it is well within the discretion of the respondent authorities to disburse the same or not. Full stop. That apart, comma, it is argued that the payment of VAT within bracket value added tax bracket closed is an essential prerequisite of an applicant to get the benefit of the subsidy. Both of you please take your seats. All of you take your seats. Benefit of the subsidies under this scheme. Full stop. Next para. In support of such contention, comma, learned counsel places reliance on clause 16 of the scheme, comma, which relates to the mode of payment. Full stop. By stressing upon the mention of payment of VAT in the said clause and its subclauses, comma, it is argued by the respondent authorities that the petitioner never paid VAT to the state of West Bengal and, comma, as such, comma, is not entitled to the subsidy even under the scheme at all. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires from the records that the scheme in question was floated with the purpose of extending certain additional financial support for promotion of large and medium scale industries in the background regions of the state, comma, as mentioned in the very first paragraph of the notification dated February 22, 2011, comma, which contains the scheme. Full stop. Next para. In the said gazette notification, comma, clause 16 is one of the criteria, one of the modes of payment, but not an eligibility criteria. Full stop. Eligibility criteria for incentives under this scheme are stipulated in clause 6 of the scheme. Full stop. There is nothing in the said clause to indicate that the payment of VAT to the state is a necessary prerequisite for getting benefit of the scheme. Full stop. Clause 6.1 stipulates that a unit in the large and medium scale sector to which the scheme applies, comma, shall be eligible for securing a RC, provided that, colon diye tar niche 6.1.1, the project is covered by a detailed feasibility report stroke project report prepared for the purpose, semicolon, তার নিচের line 6.1.2, the project has been approved and sanctioned by any FI. তারপরে এটাও semicolon দিয়ে 6.1.3, while in the case of projects with an arrangement of finance from own sources, comma, issue of RC shall be considered only if the WBIDC is satisfied with the arrangement and recommends issuing RC. Full stop. Next para. Moving on to clause 16, comma, which specifies merely the mode of payment, comma, it transpires from the subclauses thereunder that on commencement of commercial production, the unit in question will have to submit an application to the managing director of the WBIDC in the prescribed form, praying for release of incentives. Full stop. The question of VAT comes in certain provisions of the said clause. Full stop. However, comma, the requirement in such mode of payment as prescribed in clause 16.9 is that 100% export-oriented units and certain units exempted from paying VAT/CST will be entitled to FCIS only as are admissible under the scheme. Full stop. Payment towards such subsidy would be made by the WBIDC directly to the unit. Full stop. Next para. However, comma, clause 6.10 is the relevant provision which governs the present petitioner concern. Full stop. The said subclause provides that subsidy on fixed capital investment, fixed capital investment for units other than that mentioned in para 16.9 shall be paid in 10 equal annual installments by way of adjustment against VAT paid by the unit in the previous year. Full stop. The crucial limb of the said clause, comma, in the context of the present case, comma, however, is the subsequent sentence therein, which specifies that in case it is not possible to fully adjust the subsidy against VAT paid by the units on year basis, comma, balance entitlement at the close of the 9th year shall be paid to the unit through account pay check at the 10th year. Full stop. Next para. The reliance of the respondent authorities on the sanction letter dated December 2, 2011, annexed at page 59 of the writ petition is entirely misplaced for the proposition sought to be advanced by the respondents. Full stop. Clause C thereof provides that the company has to submit relevant certificate from Commissioner, Commercial Taxes, West Bengal, certifying that the unit has not defaulted in the matter of payment of VAT dues under the Act before release of incentives. For sub next para, it is extremely important to note that the language of the said clause is not that if the unit is not liable to pay VAT and or has not paid VAT. Full stop. The specific phrase used is double inverted. The unit has not defaulted in the matter of payment of VAT dues under the Act, double inverted clause. Full stop. Next para. Taking into account all the relevant components of the said phrase, comma, the unit, comma, in the first place, comma, has to be liable to pay VAT. Full stop. Since, comma, in the present case, comma, the petitioner is not liable to pay VAT, comma, there could not be any accumulation of VAT dues and, comma, in turn of the unit having defaulted in payment of such illusory dues. Illusory dues. Full stop. Next para. Moreover, comma, it is clear from the communication of the respondent authorities themselves to the petitioner dated May 24, 2018, as annexed at page 74 of the writ petition, that the said authorities had enclosed a communication from the additional commissioner of commercial taxes, West Bengal, which according to the respondent authorities, spoke said communication, also annexed to the writ petition in the very next page, that is page 75, clearly shows that the additional commissioner opined that for the entire period in question, the net VAT payable by the petitioner was reduced to nil, due to the reasons as stipulated therein. Full stop. In view of such specific reasons, comma, it was further observed and advised by the additional commissioner that the situation of nil VAT payability being reduced to nil arises due to inverted duty structure characterized by higher rates of tax on inputs locally purchased and lower rates of tax on intra-state sales of final products. Full stop. It was also explained categorically that thus, there is always an accumulation of excess ITC even after setting off against VAT liability. Full stop. Next para. An empirical statement generated from the data of the commercial tax department on the basis of the quarterly returns filed for each of the four quarters of the consecutive financial years, it was stated, reflects the tax payment behavior of the dealer, in the light of which the additional commissioner advised that she was of the opinion that the present case treated not as an EOU dealer, but as a situation where the applicant dealer is not in a position to fully partly adjust VAT payable with the sanctioned amount of capital and interest subsidies as per the T and C within bracket terms and conditions bracket closed of the WBISS 2008 scheme. Full stop. Next para. In view of such clear clarification, if I may use such expression, there is no scope of the petitioner being liable to pay any further VAT dues under the scheme. Full stop. Hence, as the petitioner is otherwise eligible to get the benefit of the scheme and has already been admitted twice, once for the subsidy under the scheme and once for the interest subsidy by the respondent authorities themselves, there is no impediment on the part of the respondent authorities at all in disbursing the entire subsidies to the petitioner, including the interest subsidies as already sanctioned. Full stop. Next para. Accordingly, WPO number 274 of 2020 is allowed on contest, thereby directing the respondent authorities to immediately disburse the entire amount of the subsidy which the petitioner is entitled to under the West Bengal State Support for Industries Scheme, 2008 within bracket as amended up to 31 full stop 12 stop 10 bracket closed to the petitioner within an outer limit of 3 months from date. Full stop. Next para. In the event such payment is not made by the respondent authorities to the petitioner within the said date, the respondent authorities shall pay the entire amount of subsidies due to the petitioner along with interest calculated at the rate of 12% per annum till the date of payment of such amount to the petitioner. Full stop. Next para. No address to cause. Thank you.
Lord, one thing, Lord.
অপোজ আচ্ছা তাহলে এটার আগে একদম ইনিশিয়ালি একটা থ্যাংক ইউ it is seen that a reply filed by the petitioner was previously taken on record, full stop. However, in view of no affidavits having been filed by the respondents at all, such reply has not been looked into and be deemed to be expunged from the records. Full stop. I'll keep it on record, but deemed expunction.
One thing, Lord, today during hearing, Lord, that distinction was sought to be made, Lord, that WBIDC is separate from state, and unless WBIDC receives the money from state, they can't pay. But my lord, there.
That was heat of the moment. Next matter.
Because this here is
My
there.
lord has reported, my lord, I appeared for the WBIDC.
So my lord,
Whatever is written in your slip will be recorded.
Is there in the slip WBIDC?
respondent authorities may not be linked to state and WPI.
State is not exactly an authorities, or it's on a higher footing.
But
They are the authorities.
they are the authorities. My lord, I know, my lord, your lordship.
The last ordering portion is respondents.
Respondents. My lord, they said to the subsidy. First, as and when funds are made available to WBIDC.
That will decide in the contempt. That will decide in the contempt. Yes, call on this.
Yeah, this is like a full circle that happened. Initial order was passed by your lordship.
Spelling of full is doubtful.
No, this is it.
Yes.
And if you.
Thank you.
Item number 7.
7, yes. 7, who is for the
Electro Steel Casting Limited.
My lord, item number 7, there was a direction as long as on July 26, 2022 to file affidavit in opposition. I bring the last chance to your lordship, my lord, at least kindly grant me 2 weeks.
Till when? 2 weeks. Statistics, Mr. Dotto. He's entitled now. You are on the receiving end. Learned counsel for the you are for the state or the WIDC.
Autonomous body, is better than the state.
But in fact, my lord, going by the documents, I think he will support me.
You support him, then support him. No, Mr. Siddiqui, if affidavit is seriously not necessary, I mean, then you can come back tomorrow and apprise the court.
I think, my lord, it is necessary.
Necessary.
Subject to sanction.
Very good. On the prayer of learned counsel for the respondent authority, comma, the time for filing affidavit is extended as a last chance to the respondents, comma, till June 29 to আজকে কত তারিখ 15 June 29 2023 full stop. The matter shall be listed on June 30 2023 for hearing. Oh, I'm sorry, June 29 2023. Reply if any shall be filed by July 1 week, Mr. Dutta.
Yes.
Reply if any shall be filed by July 7 2023. The matter shall be listed for hearing on July 10.
Can you specifically mention respondent WBIDC because my learned
State has filed. State has filed.
Oh, very. On the prayer of learned counsel for the যেখানটা বললাম respondent authority না করে respondent number 2. It is usually the respondent
1, 2, and 3 has filed.
4 will file.
4.
Prayer of respondent number 4. In the appearance also, Mr. Siddiqui, please ask. You are 5. 4 না তাহলে 5 হবে। যেটা 4 বললাম 5 হবে। Please be cautious in your slip also that it is mentioned you are appearing for respondent of 5.
All 4 matters in the ordinance side, I appear for the WBIDC.
I thought in all 4 matters you are appearing for the respondent number 5. Even if there is no respondent number 5. Yes, Mr. Siddiqui. Thank you.
I'm grateful.
হয়ে গেল? না না টাইমটা এক্সটেনশন চাই। কেউ কিছু ফাইল করেনি? এক্সটেনশন থাক। সবাইকে যখন দিচ্ছি স্টেটকে। Yes.
Item number 8.
Which for the petitioner? Respond.
I'm
Yes.
for respondents 5 and 6.
Respondents.
Yes, madam.
Which for the
Madam,
petitioner?
on the last occasion, your lordship had directed the petitioner to file a reply to my opposition.
Hmm.
The respondent, I'll just tell your lordship very briefly, this was a case where the petitioner's bank account was under investigation by Directorate of Revenue Intelligence. In 2016, they had...
So there is for the revenue.
Yes, madam. In 2016, they had instructed us to mark a debit freeze on this bank account. I'm HDFC Bank. I acted in accordance with those instructions. 2016 to 19, that was operational. 2019, they sent a letter saying that we are no longer investigating. The matter has been transferred to ED, Mumbai Circle. Therefore, further instructions to be taken by ED, we are withdrawing our instructions for debit freeze.
Achha.
From then, petitioner has been approaching us. We said, you obtain a no objection from ED. We have no problems in disbursing the funds, in allowing you operations. They do not do that. They approach the ombudsman.
Ultimately, my lord, 2022 March, ED sends us a notice from the adjudicating authority.
You are Mr.
under-
Mukherjee.
Yes, my lord.
Mr. Mukherjee, I can only, because I cannot go into this in their absence, I can just adjourn for 1 or 2 times and then dismiss for default. What else can I do? Because the rest has been recorded by Justice Bhattacharya. Oh, I'm
She
sorry,
just
I have recorded.
last week.
I have recorded in the last order whatever you are submitting. I mean, the indications are there.
In my opposition, I've disclosed the ED's notice, my lord, the latest notice showing that adjudicating authority has passed an order of attachment, to which they were to give a reply, because it was their stand that ED had previously said that no objection. So that is the only question, my lord, that was to be adjudicated. ED was to be given a fresh notice also. I don't know if that has been done.
None appears for the petitioner at the time of call. Sorry, none appears for the petitioner at the time of call, although the respondent numbers 5 and 6 as well as 7 and 8 are represented through counsel. None is appearing for the Union of India.
Union of India, your lordship.
যেগুলো বলেন তার সঙ্গে and the Union of India are represented through counsel. Full stop. Next para. It is pointed out by learned counsel appearing for the respondent number 5 and 6 that the respondent numbers 7 and 8 have, in the meantime, taken a stand that the investigation in question has been transferred to the Enforcement Directorate. Full stop. It is seen from the order dated June 5, 2023, that the court had observed that a further notice regarding the next returnable date was to be served on the respondent numbers 9 and 10 by the petitioner, and to the respondent numbers 9 and 10 by the petitioner, and a receipt in that regard was to be filed on the next date of hearing. Full stop. However, since the petitioner is unrepresented today, the matter cannot be disposed of on merits in their absence. Full stop. As a last chance to the petitioners to appear and move the matter, the same is adjourned till tomorrow. I'll not record anything else, but please, if you can, please give a notice or at least verbally inform the petitioner. If they appear, I can dispose of the matter.
In fact, he was there, my lord, just 2 matters ago there at the.
Yes, he was there. That's why. That's why. Right. Next
Item number 9,
one.
West Bengal Power Development
Extreme
Corporation.
indulgence, my lord.
What is extreme?
For the extreme indulgence is after the completion of pleadings, after completion of our submissions, and after the submissions of the respondents had commenced. My lord, we have found some documents inter-party, which none of the parties, I do not know for what reason, did not produce, but which would have a tremendous bearing on the matter. There are 3 email correspondence.
What is the nature of the dispute? Satisfy me on the
Yes,
relevance of
yes.
just
My lord,
prima facie.
Yes, my lord, fire claim. My lord, initially there was a repudiation. Thereafter, my lord, the surveyor appointed an expert. The expert gives a report to the surveyor. I'm sorry, insurance company appoints an expert. Expert gives a report to the surveyor. The surveyor submits addendum reports saying that the claim is maintainable.
Yes, yes.
My lord, and the insurance company suddenly, without any reason, says that the original repudiation stands.
Yes, yes.
My lord, to that effect, my lord, the new documents are the 3 emails which deal with, my lord, disposal of salvage, which is part of the insurance settlement process, claim settlement process.
Yes.
And the correspondence exchange with the insurance company, the surveyor, my client,
What will they establish?
that the settlement process had been initiated after the initial repudiation, and the salvage sale had taken place, which would reduce the claim. So that portion.
No, for the insurance company.
Yes.
Yes, your
But
lordship.
we have served the affidavit subject to your lordship's, my lord, approval in
The
accepting
affidavit which you are wanting to use.
supplementary affidavit. We have served
Yes.
without subject to your lordship's
Advance.
approval.
Yes, definitely. Yes.
Lordship, I have to take instruction from the company, your lordship. because-
Regarding that, please take instruction. In the meantime, I'll permit them to file this affidavit. Have that affidavit with you, and on that have an instruction from them.
My lord,
So if it's possible to be resolved, then we'll resolve it.
lordship, I take instruction for 10 days time at least, your lordship. You have to get instruction from Bombay, your lordship, the head office.
Bombay is far off. You don't have to walk there actually nowadays.
Lordship, since I have an
No,
instruction.
no, write an email even or make a phone call. Take instructions.
Because this email I have to submit. Very well, lordship. Give
Make a phone
I'll-
call. Tell them to. Do I have to tell you? Tell them to send via email and instruction so
Same
that
lordship,
you are you are saved. I mean,
Well,
you are
then
protected.
your lordship, kindly keep it on Monday, your lordship, and
Not Monday. I'll keep it on. I'll give you 1 week. I'll keep it on. Today we are on 15th, 22nd.
lordship.
May I file this up?
Yes. Leave is granted to the petitioners to file supplementary affidavit, which is kept on record. Full stop. An advance copy thereof has already been served on the respondent stroke insurance company. Full stop.
Lordship.
In the said
My lord.
in the said in the said supplementary affidavit, the petitioners seek to disclose certain germane documents which may have a vital bearing on the adjudication of the present lease. Lease. Full stop. Next para. Learned counsel appearing for the respondent seeks some time to take instructions on the same. Full stop. Next para. Accordingly, the matter is adjourned till June 22, 2023. Full stop. It is made clear that in the event the respondent seeks to use a rejoinder to the supplementary affidavit, the respondent shall be prepared with the same on the next date of hearing and serve an advance copy on the petitioner. Full stop. Do that.
Lordship, 2 points, your lordship. First, your lordship, if it is it possible about 20, apart from 20,
On any other date?
23rd, your lordship, is it possible for your lordship?
For me, it's possible. No difficult.
Well, and your lordship, second point is if I'm going to file an affidavit, I mean, reply your lordship, I
At
have
that
to, I need some, because the person will come from Bombay because he's the representative of your lordship, the person needs.
You initially
that-
sought for 10 days.
Yes, your lordship.
Very well. তাহলে next returnable date টা করে দিন ওই June 22 না করে June 27, 2023. Come back on June 22.
Lordship, grateful lordship.
হ্যাঁ জার্মান ইয়ার আপনি তো জানেন এমএন ইয়ার এমএন জার্মান
Item number 10, Sandeep Bose versus State Bank of
Yes.
India and another.
Lordship, item 10, Lordship,
Petitioner?
I am
Yes.
for the petitioner, your Lordship.
Right.
The pleadings
You're for
have-
the respondent?
We are appearing for the respect.
pleadings
Please
have
take your
been
seats,
submitted.
respondents.
Yes.
Yes. What is your word?
So the matter, your Lordship, is in connection with your Lordship, the declaration of a willful defaulter by the identification committee. May I state the brief facts, what happened, your Lordship?
At
I
what
was-
stage you have come? What is the stage now?
After the decision of the identification committee.
Why don't you go for review?
Lordship, the scope of review was very limited and the main ingredient was there was no reason at all in the order itself.
Mr. Shenmugh, I'll start the matter after 10 minutes. I'll
Yes,
just take a break of 10 minutes
Yes,
and
sir.
come back and
Yes.
start the matter.
Matter.
Yes, please.
If I've challenged your lordship an order passed by the identification committee, where your lordship I have been declared as a willful defaulter. Now, lordship, I was an erstwhile director and I resigned from this particular company, Tatia Construction, sometime in 2016.
Right.
Now, after the resignation, what happened, your lordship? They issued me the show cause notice in the year 2020. I'll show those documents. Now, after issuing the show cause notices, they have given me the personal hearing. I don't have the grievance. I gave them representation objections that these are my grounds. I was not in the, I was a director. I resigned from the company in 2016. I was never, your lordship, part of that particular boarding committee. I am neither a, right at present, I am neither a director, nor a borrower, nor a personal guarantor.
Were a guarantor at any point of time?
Never.
You were only a director, you resigned in 2016.
2016. Now, they gave me a hearing, personal hearing.
They alleged that act of default, when did it happen?
Act of default before 2020. But at that point of
Before
time,
2016 also.
before 2016 also. Now,
Yes.
when the order was passed,
Hmm.
they considered the representation of the managing director, Mr. Rahul Tatia, and passed an order against me without considering any grounds, your lordship, which I have taken in my representation.
Have you
The
annexed that
entire-
order?
Yes, your lordship.
Yes.
The
Yes, in
entire
fact, yes.
order is silent.
Mhm.
Lordship, kindly
Let us see
directly come to page 127.
127, yes.
So this is the order, 26th of September 2022.
Right.
It has been written in favor of Shondip Bose, director, kindly sees. Borrower is Messrs. Tatia Construction Limited.
You are
Now,
Shondip Bose.
I am Shondip Bose.
Right.
Now, lordship, kindly see the heading, inclusion of the name of the company and its directors, guarantors, etc. in the credit information company CIC's list of willful defaulters and your submission representation before identification committee. Please refer to the show cause notice sent to you as per the direction or orders of the willful defaulters identification committee. Video later dated 28th October 2020 advising about the bank's proposal to declare you as the willful defaulter and inclusion of your name in the CIS list of willful defaulters. We also refer to your submission reply against the show cause notice dated 28th October issued by the willful defaulters identification committee of the bank. Video later dated 15th of December 2021. I'll show you, this is not my letter. This is the letter of Rahul Tati. And personal hearing before the above committee on 14th September 2022.
You were heard personally.
Heard personally, I was given that's not my grievance.
Hmm.
In this connection, the willful defaulters identification committee has examined the representation submitted by you in the personal hearing, your reply as mentioned above, and rejected your submission. The order passed by the WDIC is enclosed. You, para 3, you may also, that's sir, you can go before the review committee. Now, lordship, kindly see is page 129. The order dated 14th of September 2022. My name, Mr. Shondip Bose, your lordship, kindly sees present through VC. I was there. Now, lordship, kindly sees the next page, page 130. Third column, it's borrower, directors, guarantors submission against column number 2. The brief Rahul Tatia submission dated 15th December 2022 is mentioned here as under. So this is, your lordship, the letter written by Mr. Rahul Tatia. And the
Was your ground even considered anywhere here?
No.
You are not a director at the
nowhere, nothing. Everything is silent. They have considered the Rahul Tatia's consideration and the final, your lordship, kindly come to page 138. Not a whisper about that.
And have you annexed your reply, your rejoinder?
Everything I have annexed. I'll show you.
Just show me your these points which you have taken before me. You were not a director in 2016 because the other points must be common.
Lordship, it started.
They have dealt with actually.
Excellent. Page 84. অনেকগুলো আছে, আমি একটা একটা করে। Lordship, kindly take, your lordship, the comprehensive one is page 84. There are other also, I can show you.
Right.
Page 84. Right. Lordship, Shondip Bose, 18th of October 2021. Lordship, kindly sees the first paragraph. I was neither a promoter nor a guarantor from the loan facility extended by you, Messrs. Tatia Construction. I am an
They
experienced,
alleged that you are a guarantor or promoter. They have not even alleged.
they have not, they have said I'm a borrower. I am a
Direct,
director.
direct. Very well. So let us see
Yes,
the
yes.
relevant. So
Lordship,
these are usual things, not barred by limitation and all those written statement.
no, no, no.
No, these are like those, the general. I'm not a promoter or a guarantor. They're not saying you were a promoter.
I'm an experienced graduate civil engineer
Appreciate, yes.
and was looking after the technical advisory matter in the company. I had resigned from the board of the directors on 13th August 2016.
Hmm.
Further, I had also resigned from the company with effect from 31st of May 2018. It was not, it will not be out of place to mention that your show cause letter dated 28th October 2020 received by me on 2nd November 2020 or thereafter was after a period of 4 years after my resignation from the post of the directorship of the company and therefore regarded as time barred. Lordship has written time barred.
Hmm.
I was never a member of the audit committee of the TCL. I was in the finance committee of the TCL for a period of 2 years from 30th May 2014 to 13th August 2016, albeit an inactive member as such being a civil engineer and not man from a financial background. I have disclosed it. The finance related matter of the company was dealt with by the directors with financial expertise and CFO and GM accounts. I was in the committee with almost no role to play because being from the technical advisory side and being a non-finance person, I neither had the expertise nor was I required to dealt with. The terms of the reference of the finance committee was to discharge the responsibility on behalf of the board of directors relating to exercise all powers to borrow fund of the company's requirement, review entire banking arrangements, approve opening, modification, closure of the bank accounts, creation of securities of the movables and immovable assets, carry out the other function as may be delegated by the board, delegate other authorities of the executives and authorized representative to implement the decision of the committee from time to time. Next, lastly, Your Lordship, I said, I would like to submit as follows. The finance committee meeting from 30th May 2014 to 13th August 2016 were held on such and such date. I would like to bring to your notice that I was only monitoring the closure of the accounts, which did not warrant any expertise. I enclose here with a copy of the minutes of the meeting. Joint lenders forum held on 10th of August 2016, where the matter of the closure of current accounts was discussed and the report of the concurrent auditor has been submitted.
Why don't you go before the review committee and take these points?
Lordship,
these are good points.
Very good points, but
not
Lordship,
very good maybe, because Shengutta, if you are monitoring the closure of the accounts and if you are a part of the finance that committee, then I mean,
but they have to take a decision.
They have to take a decision.
They have to take a decision.
There you have got a better point. Yes.
Kindly come once, Your Lordship.
Your involvement has not been touched in the order.
Yes. And moreover, Your Lordship, because this is a willful defaulters list, this will have a penal consequences.
Definitely.
Lordship, kindly come to page 138.
Yes.
Page 138 is a resolution. Mr. Shondip Bose, erstwhile director. I'm sorry, Your Lordship.
No.
It's folded, Your Lordship. Page 138.
Yes, yes.
Resolution, Mr. Shondip Bose.
You're submitting with folded page. Yes. Shondip Bose, yes, you have been.
Mr. Shondip Bose kindly says erstwhile director. So they recognize that I was the erstwhile director. Mr. Morare Lal Agarwala, erstwhile director, and
there is no part to move against an erstwhile director because you were there in the company at the relevant juncture.
But he has to at least come to a finding that there is an involvement.
That is different. Involvement, your involvement, you said I was not involved due to these reasons. Those were not considered. This is your best and probably only point here.
Lordship.
At this stage.
At this stage, because
the other points are on merits.
Certainly, Your Lordship, if there is a defalcation of fund, Lordship, transfer of funds,
different aspects.
Usually, Your Lordship, the directors, they resign to evade the liability.
Yes, yes, right.
So
here you had no involvement at all, you were saying.
No involvement at all. This is Tantia construction, Your Lordship, basically, Your Lordship, controlled by Tantias. So basically, these are the employees who are actually designated as a director.
No, the moment you sign as a director,
my liability
you
comes.
sign as a scapegoat.
Yes, yes.
So that has to be kept in mind. In terms of the master circular.
I accept it. But they have to decide something. Lordship, kindly come, Your Lordship. The second line. The submissions made by them to the committee was not acceptable. The other directors, personal guarantors did not attend the meeting despite giving adequate notices. Based on the aforesaid facts as available on record, the committee considers that the event of the willful default against the criteria 2.1.3a is attributable to the borrower as described herein above. Hence, it is concluded that the name of the company, Tatia Construction Limited, corporate guarantor, Tatia Construction Private Limited, Shondip Bose, again director, Murali Lal Agarwal, director, Banwari Lal Ajitsaria, director, Rahul Tatia, promoter director, personal guarantor, Ishwari Prasad Tatia, promoter director, personal guarantor, will be included in the RBI CIBIL's other CIS list of the willful.
So only the erstwhile directors appeared.
Actually,
Three erstwhile directors
Yes.
appeared.
and all gone. Now, one thing is very important. I have to satisfy your lordship because I have to show at least your lordship that I was resigned. Kindly come to page 29 once. That's my resignation letter, and it has been uploaded in the Ministry of Corporate Affairs. May I just show that? Sorry.
Yes.
Page 29, your lordship, is my resignation letter. Shondip Bose's. This has been accepted on 13th August 2016. Now, your lordship, kindly take page 30. That's the Ministry of Corporate Affairs form where your lordship, it has been uploaded.
Uploaded.
It started from page 30. Lordship, kindly sees page 32.
Must be there. Yes. Very
Lordship, Shondip Bose and cessation has been duly uploaded. Now, after uploading this one, your lordship, the show cause notice, your lordship, has been issued in my favor. That is at page 37.
Not
That is-
exactly in your favor.
28th October 2020, those all particular allegations are there in the show cause notice. That
Dates
is
are probably not disputed here.
not
I
disputed.
don't think so. I mean,
Now,
at
lordship,
this
kindly
stage.
see the circular.
Circular, yes.
Circular is very important because mechanism has been given. Lordship,
Good.
kindly take page 41, 1st July 2015 circular that is relevant right now. Page 41, Lordship, kindly see.
41.
It starts. Now, Lordship, kindly take, your Lordship, kindly take page 43.
43, yes. Willful default.
The definition of unit is there, and your lordship also the willful default, your lordship, has been defined. What I have need to show your lordship right now, page 46, that is the penal measures. Penal measures are also there. That the moment it has been included my name, all these penal measures, your lordship, will
Yes,
start
yes,
following.
obviously, those coming.
Now, lordship, kindly come to the mechanism. Page 149, specifically written. You have to give a reasons for that. Page 49. Page 49, your lordship, clause number 3, mechanism for identification of the willful defaulters. Lordship, may I place it here, lordship, once? The mechanism referred to in para 2.5 above should generally include the following: evidence of the willful default on the part of the borrowing company and its promoters stroke whole-time directors at the relevant time should be examined by the committee headed by the executive director or equivalent, consisting of 2 other senior officers of the rank of the GM DGM.
So
Now,
your subsequent resignation loses relevance. At the relevant time is sufficient.
it's sufficient.
To bring you.
Lordship is there.
So even if that was not considered, that's not a relevant consideration.
But he has to come to a finding that I have an involvement. That is very important.
That's different. But at the relevant point of time, you were there.
Yes,
That's sufficient to rope you in. I mean, issue a show cause notice.
issue of, I have not challenged the show cause.
Your involvement comes later. That's the second limb.
That's the
First
second
limb is you were there in the company as a director at the relevant point of time. So clause A, that portion is satisfied. Now your involvement comes. Let us go on.
That's the second part. Otherwise, I would have come before the honorable court
Definitely, that is
challenging the show cause.
Right. Right.
Clause number B. If the committee concludes that an event of the willful default has occurred, it shall issue a show cause notice to the concerned borrower and the promoter stroke whole-time director and call for their submission. And after considering their submission, issue an order recording the facts of the willful default and the reasons for the same.
This has not been in your case done in
Completely, your lordship is absent.
So it will be illusory before the review committee.
Useless. Because I have to, the review committee will only review. The review committee will not,
But your reply is there.
my reply is there, all on
For
record.
the identification committee, it's not exactly illusory in this case, because if no materials were on record, then for the first time, the review committee would become the first committee. But
Yes, sir.
here, the review committee will be the second committee in your case also, because your reply is there on record.
My reply
They
is
have to
there.
consider that, and you're hearing again maybe. So
Now-
why not go before the review committee? The courts are generally loath to interfere at this stage,
Courts are all with deepest respect.
which is the first point which
Courts
will
are
be taken
also
by the
loath,
learned
Your
friend,
Lordship,
that
in
is why he's
connection with
standing.
the review of the matter.
Yes. Anyway, so this is your point.
This is my
Let us hear
best
their,
point. Apart from that, Your Lordship, everything, Your Lordship, all the
all other are
representations of-
worst points in the same bracket. Anyway,
Judgments
but
are
that
there.
is there. That point is definitely.
Lordship, judgments are there. If Your Lordship feels, Your Lordship, I can show those
Judgment
judgments.
on what proposition?
Regarding two propositions, that heartbeat of the order, Your Lordship, Victoria Memorials and Your Lordship, Kranti, regarding the
We have
reasoning of
used
the order.
Victoria Memorial too much for examples, for propositions. So leave it alone.
Then one is Kranti, Your Lordship, even the administrative orders are also should be reasoned.
So you are on reasons.
Reasons. I'm the only on the reasons.
Reasons vis-a-vis you. Because
Vis-a-vis.
there were no reasons vis-a-vis.
Yes.
Let us hear.
And thereafter, Your Lordship, the coordinate bench has also, Your Lordship, given Your Lordship certain, Your Lordship, what are the steps of mechanism by a coordinate bench. There-
Everything surrounds around this
Reasons.
B.
Yes.
Take it. Yes.
Mine.
How do you overcome B in his case?
Mine. My lord, kindly sees page 131 of the writ petition, my lord.
Yes.
At point Roman 7, my lord.
Romans 7, right?
My lord, the second line, the company during financial year 2015 to 16.
Right.
My lord, the financial year is 2015 to 2016, wherein the petitioner was the director.
His resignation subsequently does
Lordship.
not hold any.
Lordship, the director is completely responsible while he is holding the post of the director and managing the affairs of the company. More fully in this matter, he was he has conceded to the fact that he was a member of the finance committee. He was well aware of the
Financial activities.
financial affairs of the
Closure of the account and all
yes.
this stuff. Yes.
Well, when, my lord, my lord, as he claims to be a financial expert, my lord,
He's not a financial expert.
my lord, he is not, but he was in the
Because
financial
expert of, you're an expert of what?
engineering, but
I've said so, Your Lordship, page 84.
There is accounts in engineering also, and vice versa. Mandatorily.
my lord,
Anyway.
my lord, the accounts of the company was becoming NPA, my lord.
Now, other things are there only one aspect of the matter. They have, I'm just confining my query to you.
My lord.
Because the other aspects, both all of us know. Yes,
Yes,
those are there. That aspect is that they have specifically mooted certain points that for this reason, I was not involved in
My
that.
lord.
So you have not even dealt with that. What about that? Because that is their main case before this court. Because I'm just take their reply once. They've taken certain specific points. in their-
108.
108, right?
84.
Now,
84.
the points may be very frivolous, maybe whatever in your perception, maybe,
My lord.
definitely. But why haven't you dealt with that? That is the question. The finance meeting, he has said, for example, that although he says that approval of opening, modification, closure of bank accounts was in his hands.
Because that's an admission on the part of the petitioner, my lord. I need not
Actually,
submit
yes.
anything more, my lord. And my lord, even the personal hearing also is an option given to the secured creditor, my lord. My lord, that was also exercised.
That
Yeah,
was done.
Yes, yes, my lord.
He's not arguing that that was done.
No, my lord,
only,
he's not arguing. He's just, my lord, the only dispute which the petitioner has raised is that his submissions were not recorded and
not discussed in the order.
Not discussed in the order.
Only that. Basically, only that. Yes.
But it was the activity of the company, my lord. He was on board.
Right.
What for the and everything is on record. Everything is evident from the accounts of the company, my lord. He's not and he has not disputed the accounts of the company.
Very. Yes, any reply? Take your seat.
Only one thing here, what he has discussed, submitted, your lordship, regarding the accounts. I was not in the company since 2016. How can
So
I show the accounts, your lordship, in 2020? Kindly see, your lordship, the entire submissions has been recorded of Mr. Tatia, Rahul Tatia. Lordship, that's the first line, page 130.
But it is
Yes,
on the
yes,
basis
that-
of the balance sheet
So
that has been
A,
filed
B,
by the.
C, D, whatever the
That is-
observation has been
That
made.
is on the basis of Mr. Tantia,
Tantia.
definitely. There is no doubt on that.
So where
But
is
the observations are vis-a-vis the company.
vis-a-vis the company?
The activities of the company at the relevant point of time when you were a director, and not only that, you are a part of the finance committee. Admittedly,
Yes.
you are in charge of opening, closure of the accounts, etc.
I've said everything. Whatever they have asked me, I've said everything. But now you have to take a decision that whether I am
How far
liable
the
or not.
court can interfere with that decision?
Lordship,
Decision-making process I cannot find faulty simply because, yes, technically you are right. It was not reflected in the order that your specific submissions were recorded, discussed. How far that has to be done in this sort of an order? This is not a judicial order.
Lordship,
Has implications, but not a judicial order.
I am not challenging their order against Tatia Constructions.
No,
I
against
am
you,
not
I'm saying.
challenging the order against
Yes,
Rahul
obvious,
Tatia.
obvious.
Today, I am only concerned about me. And they have, Lordship, included my name in the list of the defaulters list. That's my grievance. I'm not saying, your Lordship, the accounts are correct.
I'll not decide this case against on merits, Mr. Chanu.
No, no, no.
Go against you.
Let them decide
Pretexts are
afresh.
flimsy.
Let
Your
them.
pretexts are flimsy.
My lord, there is no scope of deciding afresh. My lord, he can approach the review committee. My lord,
That is precisely what I'm just telling him. I'll give you
that
that.
is the
leeway.
mechanism. My lord,
If I
that has
say
become
one
practice.
word on the merits, your arguments, if I consider on merits, the difficulties I'll have to decide that prima facie at least. That will go against you. Because the grounds taken by you are very flimsy.
Lordship, kindly.
Even a non-commercial person like me can see through them. So the test of their being satisfied is not satisfied.
Lordship, may I say only thing?
Hmm.
Lordship, kindly do not, your Lordship, decide, because that has to be decided by the
I
administration
cannot.
committee.
That's why I'll give you that liberty to go before the review committee.
But then your Lordship,
Without any-
then your Lordship, the review committee has to decide this. Otherwise, review committee cannot say that these are the
Review
points.
committee, after JAR developers, I think it's settled.
Yes, my lord.
What the
It has
review
been
committee
settled by the
committee has.
The review committee
All
decides.
the subsequent
Lord.
judgments deal with
Yes,
JAR
sir.
developers.
Let the
and
review
it's settled.
committee, your Lordship, decides every point, your Lordship, which I have taken before the
Review committee,
identification
whatever
committee.
is the settled law, review committee will do that. Why my observations on that?
The
Why
reason,
should
your
include
Lordship, that if the review committee again will not decide, your Lordship, again I have to come.
Come, you are most welcome to court of law.
But the thing, your Lordship, the review committee, the powers are also very limited.
We cannot apprehend that. What the review committee will do or not do. We cannot apprehend that. Review committee must be knowing, the notion is that they should know the law. Because they are the review committee.
But, your
Ex
Lordship,
officio, they should have knowledge
but
of the
if
law.
your Lordship sees the mechanism, the identification committee has to give reasons. That is, your Lordship, absent. Why
Lordship,
we
the
come
reasons
before the
are-
Honorable Writ Court, your Lordship? He
reasons are
has to.
stated, my lord, in
Lordship,
the.
it's not the judicial order, your Lordship, or the precedence. It says the mechanism, your Lordship, the RBI says you have to give. Where is the reasons? That's my only question.
I'll not relegate its simplicity then on to the review committee. I'll discuss and decide on your arguments. Ashwin, take your seats. Learned counsel for the petitioner contends that the petitioner was an erstwhile director of the defaulting company, but was roped in for declaration that the petitioner is also a willful defaulter. First up, it is submitted that although the petitioner was given a personal hearing and the petitioner had filed a specific and detailed reply to the show cause notice, comma, the same was not considered at all in the impugned decision of the willful defaulter identification committee. Full stop, next para. Hey, willful default, English of capsid, first letter. Full stop. Next para. It is contended that in the said reply, comma, the petitioner has categorically elaborated as to why the petitioner was not connected in any manner with the alleged act of default. Full stop. However, comma, such detailed statements are not even reflected in the order of the identification committee. Full stop. Insofar as the petitioner is concerned, comma, as such, comma, it is argued that the decision of the identification committee was devoid of any reason whatsoever. Full stop. It is contended that the legal proposition as held by the Supreme Court as well as this High Court and several other courts is well settled to the tune that reason is the soul of a judgment. Full stop. In the absence of such reasons, comma, the declaration of the petitioner as a willful defaulter was vitiated and ought to be set aside. Full stop. Next para, learned counsel for the petitioner also places reliance on the relevant master circular of the Reserve Bank of India, dated July 1, 2015. Full stop. The mechanism for identification of willful defaulters as stipulated in clause 3 thereof are also placed by the council. Full stop. Subclause small b within bracket stipulates that the identification committee, comma, only after considering the submissions of the directors, comma, issue an order recording the fact of willful default and the reasons for the same. Full stop. The impugned decision, comma, it is argued, comma, is devoid of any such reason against the petitioner. Full stop. Next para. It is also pointed out that the entire considerations of the willful default of the identification committee were on the premise of other directors and not the petitioner. Full stop. Next para. Learned counsel appearing for the respondent authorities submits that even in the petitioner's reply to the show cause, comma, it has been categorically admitted that the petitioner was a defaulter during the relevant period, comma, when the account of default was committed. Full stop. That apart, comma, it is argued that even in the said reply, comma, the petitioner's role as a part of the finance committee of the defaulting company and his role in the accounts of the company at the said juncture have been admitted. Full stop. Next para. The consideration of the other director of the company in the decision revolved around the default committed by the company and, comma, as such, comma, also covers the liability of the petitioner as one of the directors at the said point of time. Full stop. Next para. A consideration of the impugned decision of the identification committee dated September 14, 2022 reveals that the identification committee gave detailed reason, comma, after taking into consideration the question as to whether the borrower company was a willful defaulter or not. Full stop. It is reflected in the said decision that the submissions of one Rahul Tatia and not the petitioner were considered at length. Full stop. However, comma, insofar as the plinth of the considerations are concerned in such an adjudication, comma, the primary question is the involvement of the borrower in an act of willful default. Full stop. Apart from the fact that the petitioner was indeed a director of the company at the relevant juncture, comma, it is also seen from the reply to the show cause, comma, given by the petitioner himself, comma, that the petitioner admitted that he was a part of the finance committee of the defaulting company at the relevant juncture and had participated in several meetings of the said company. Full stop. The petitioner has also admitted in his reply that he was monitoring the closure of accounts, comma, but alleged that the same did not warrant any expertise. Full stop. Next para, however, comma, the responsibilities to be discharged by the finance committee, comma, as disclosed in the reply of the petitioner himself, comma, clearly shows that the same cannot be entirely divorced from the functioning of the company, comma, vis-a-vis the alleged act of default. Full stop. Next para. Hence, comma, insofar as the limited scope of a writ petition is concerned, comma, there is nothing to indicate that there was a patent fallacy in the decision-making process of the identification committee, and or that the impugned decision was devoid of any reason, at least on the cardinal questions involved in such adjudication. Full stop. Hence, comma, there is no scope of interference in the present writ petition. Full stop. However, comma, it is made clear that the petitioner, comma, in law, comma, has the remedy of approaching the review committee to ventilate its grievances. Full stop. The petitioner is given the liberty to so approach, and, comma, if such an approach is made, comma, the review committee shall decide the grievances raised by the petitioner, comma, including those raised herein, comma, without being unduly prejudiced or influenced by any of the observations made herein. Full stop. Accordingly, WPO number 2853 of 2022 is dismissed in the light of the above observations. No orders to cost. Sorry.
Can it be disposed of, your lordship? Lordship has directed your lordship the review committee. Lordship. Otherwise, they will subject to your lordship.
There is no
Dispose of. Dispose of.
grateful, Lordship.
I'm grateful.
But in the light remains, the light of the observations remain,
Yes.
glowing on you. Thank you. Thank you. Next one.
Item number 11.
Item 11, your lordship, same order, but your lordship, the position is same, erstwhile director, but he was not a, your lordship, member of a finance committee.
কপি পেস্টই হবে ফিনান্স কমিটির জায়গাটা বদলে আগের অর্ডারটা কপি পেস্ট হবে বাট ফিনান্স কমিটির জায়গাটা কমিটি portions. I'll delete the finance committee portions if it makes a meaning.
Yes, your lordship.
The
Maybe
other logic remains the same.
Maybe page number, your lordship, if your lordship has reflected the page number, that should be 61. My opposition, my objection. Reply is in 61. If your lordship has given the page
Probably I
number,
have not given.
then your lordship.
Not given. ওই ফিনান্স কমিটিটা একটু পরেরটাতে দুটো জিনিস করতে, একটা ফিনান্স কমিটিটা রেখে একটু বোল্ড লেটার করে দেবো আমি, তাহলে যেটা ডিলিট করো করে দেবো।
My lord, may I just indicate one thing, my lord? My lord, the account of the company, my lord, became NPA, my lord, in 2014, my lord.
I've not gone into those
I know.
deliberately. There are other things also caught my eye. Maybe he has some answer to those also.
Lordship.
But if I go into those, the more I go into that, it will prejudice him
Lordship.
before the review.
Lordship has already held that it is the power of the review committee, my lord.
Yes,
to-
yes. Let it be decided by the review.
Lordship.
I'm grateful.
Grateful.
Item number 12, HON'BLE and another versus State Bank of India and others.
Lordship, for the petitioner, I'm seeking a small indulgence. Lordship,
Small or big, I'll decide. What is the indulgence?
Lordship, by your previous order, supplementary affidavit as well as affidavit in
Yes.
reply was to be filed. It was ready. It was served on the other
What
side.
happened in the meantime? Yes.
Lordship, probably somebody has taken our brief with them by
I'll keep it
mistake.
tomorrow.
Lordship, we are filing the entire thing fresh because we are not getting our brief.
Why
So,
should I keep it? Tell me.
Lordship, if kindly keeps it after Monday. We'll serve the same meanwhile on the other
Let's
side
set
as
the
well.
time. On the prayer of learned counsel for the petitioners, comma, the time for filing supplementary affidavit and reply by the petitioners is extended till June 21, 2023, when the matter shall next be listed.
Grateful, grateful. Your
21st June is Wednesday, next Wednesday, about a week.
Grateful.
Appearance to the madam.
Please give your appearances, ma'am.
Item number 13.
Yes.
Mr. Ajoy Singh versus
You for the petitioner?
I am for the respondents, my lord. My lord, the petitioners were directed to file their affidavit in reply by your order of March 27th, which expired on April, my lord. Thereafter, your lordship further granted them an extension on 6th of June. Thereafter, my lord, no reply has come, my lord.
This is a case, my lord, strangely,
Yes.
with leave.
Are
my
they
lord.
enjoying any interim order?
No, they are not enjoying an interim order. My lord, there is an eviction order. Thereafter, they filed an appeal before under section 9. They withdrew the appeal. Then, my lord, they approached the port trust for settlement. We said, okay, we can settle. If you pay this, that is not paid. Now, my lord, they have filed this writ petition. So interim order was rightly rejected, my lord. and-
No, I'll dismiss for default then. Let them come with a restoration application and hear out lock stock there. When the matter is called on for hearing, none appears for the petitioner, although the respondents are represented through counsel. Full stop. It transpires from the order dated June 6, 2023, that the time for filing affidavit in reply of the petitioner was extended till June 13, 2023. June 13, 2023. Full stop. However, as of today, no such reply has been filed in court and/or copy thereof being served on the petitioner. Full stop. It appears that the petitioner is regularly absent at the time of call and has lost interest in the matter. Full stop. Accordingly, WPO 238 of 2023 is dismissed for default without any order as to cost.
Lordship, I'm grateful. Much obliged.
Should I record interim order if any? Was there an interim order? No, there was.
There was no interim.
Thank
Grateful.
Item number 14, Shyam Babu versus the state of West Bengal and others.
No, nothing, not today. Not today.
Item number 15, Deepak Kejriwal versus the state of West Bengal and others.
Your Worship, I am appearing on behalf of the petitioner, Your Worship.
You are for the respondent?
Your Worship, I was led by the council. Mr. Ghosh is on the way, Your Worship.
Which Mr. Ghosh? Mr. Malay Ghosh?
Mr. Rupa Ghosh, Your
Sir Rupak Ghosh.
Yeah.
You start the matter.
Your Worship, I can.
On the way means how far away?
It's hardly, Your Worship.
Seems to be far away.
Your Worship. Council side. I'm just.
Yes.
The
Mr. Rupak Ghosh.
Yes.
Mr. Ghosh is
You start the matter.
This is also on the way, my lord.
Well, start the matter. Start the matter. No difficulty.
The petitioner, my lord, does business of manufacturing of wooden and steel furnitures, my lord. Now, my lord, the respondent number 2 is a company, my lord, which is the main purpose of incorporation of the company was promoting the MSME business, my lord. Please.
Today, at least, let me begin the arguments, my lord.
Yes.
My lord, the main purpose of my lord, this particular respondent is, my lord, encompassed in, my lord, kindly takes the writ petition. Lord, kindly come to, my lord. Lord, page 40. I just want to show what are the objects, my lord, of my lord, page 40, my lord. This is downloaded from the website of my lord, the respondent number 2. My lord, the West Bengal Small Industries Development Corporation was established in the year 1961 under the aegis of Micro, Small, Medium Enterprises and Textiles Department, with the sole objective of promotion and growth of micro, small and medium enterprises throughout the state by providing infrastructure and also by extending marketing support to the MSMEs having low investment capacities. Kindly mark this low investment capacities portion, but high potentiality in respect of employment generation. Thus, over the years, WBSIDCL has been grown as a trusted friend and guide to MSMEs and playing a significant and pivotal role in socio-economic development through revenue and employment generation. Now, my lord, kindly comes to the last paragraph.
at page 40, during the years, SIDCL has developed 51 number of industrial and commercial estates widely scattered all over the state. All the estates have been developed in prime locations wherein land and sheds for setting up of the industries are allotted, now kindly mark, at subsidized rates with all modern infrastructural facilities. Subsidized rates, friend, and my lord, help and support. This has, my lord, mission, my lord, is quoted to promote micro, small, and page 41, medium and enterprises by way of land allotment, infrastructure, consultancy services, etc. Lord, kindly come to page 42. Developed in prime location where land and sheds for setting up of the industries are allotted at subsidized rates with all modern infrastructural facilities. This has helped a large number of MSMEs towards industrial growth as well as generated extensive employment. Presently, WBCS is functioning as a nodal agency for state assistance. Now, my lord, this is the object with which, my lord, the respondent number 2 has been established. My lord, kindly come to page 43, the next document. This is an allotment letter to the petitioner issued on 2nd September 2003 for allotment of a space in Shilpo Bhavan, which they have developed. Respondent number 2 has developed in a my lord, fairly, my lord, prime location in the city of Calcutta for, my lord, a short-term lease basis for 15 years. My lord, this is reference your lordship finds, application dated 22nd July. So we applied, they allotted. Now, my lord, kindly, my lord, come to page 44, which says, my lord, the lease rental, clause 7. The lease rental for such short lease shall be paid by you at the rate of ₹10 per square feet. This was the agreed rent. Now, my lord, the clause 3 are the things that we are supposed to, my lord, give within 30 days. My lord, kindly come to clause, my lord, 12, which is very important and germane for the present dispute. The monthly rent as above, clause number 12.
Yes,
12. The monthly rent as above is subject to upward revision by not less than 5% or existing rent after 3 years and at the time of renewal, revision of the deed, or after expiry of this lease tenure, whichever is earlier, present rate of occupier share of municipal taxes area authority is 18% of the existing rent is payable by you. So, my lord, in the allotment letter also, they agree that the rate of escalation is my lord, 5% for every 3 years. Now, my lord,
this should be not less than 5%.
Not less than
of existing
rent, which is 10 rupees per square feet.
Yes.
Now, my lord, kindly, my lord, come to, my lord, after this allotment letter, in terms of the allotment letter, we entered into a registered lease, page, my lord, 47. Short-term lease for 15 years, page 47. This is dated 29 September 2003. Now, my lord, some of the clauses of this lease, only two or three clauses, I'll my lord, draw your lordship's attention.
What are you challenging, Mr. Ghosh?
Yes.
Tell me, then we'll.
Yes, my lord, the long and short of the matter is, my lord, this short-term lease has expired by efflux of time. This short-term lease has a clause that there would be there is a renewal clause which says if I ask for renewal, the authority will grant me renewal. I have asked for renewal. The authority initially said that it will, in fact, accepted, let me put it this way, accepted my proposal, and my lord, in fact, has granted me the extension, the renewal. Only thing is the quantum of rate. This was 10 rupees, your lordship has seen. That by dint of that escalation clause has come to, the last paid rent is 15 rupees per square feet. Last paid rent, which I am depositing. After expiry of this lease in 2018, also I have been continuously depositing at the rate of rupees 15 per square feet. They have been accepting. After my request for renewal, they have accepted my request for renewal and has granted me the lease. But the rate of rent, they have escalated from rupees 15 to rupees 75.
Great. So now let us see the clauses.
Yes.
I get your point.
Now, kindly see page 47. The short-term lease starts from that page. Lord, kindly one or two clauses, my lord. Lord, kindly come to page 59. This is, my lord, clause 5, Roman 3. Clause 5, your lordship, you will get at page 58. It's a continuation of clause 5.
Yes.
If clause 5 starts at page 58, Roman 3 is at page 59.
Right.
Which says, provided always and it is hereby further agreed as all amounts remaining due and payable by the lessee to the lessor shall constitute a charge upon the shed structure. This is not very important. Lessee may, however, hypothecate or charge or mortgage the leasehold, also not very important. 3, Roman 3. If the lessee pays rent and municipal taxes regularly and in time and in manner aforesaid, a rebate of 10% will be allowed to him for such timely payment. Now, this why I'm showing your lordship, because a point was raised at the time when it was first being argued at the interim stage that that as if the petitioner is unilaterally depositing the rent at rupees 15% even after the expiry of the lease, and we as if the respondent number 2 is not accepting it. We have deliberately made RTGSs or deposited the amount. I will show by relying on Roman 3, 5 Roman 3, that not only have they raised rent bills, they have given me the rebate also. Accepting rent at rupees 15 per square feet even after expiry.
The rebate was given also after the expiry.
Yes.
That's very
That is why I am showing this. Now, my lord, kindly come to page 60. It's a bhalo copy hai, page 60. Kindly see Roman 7. My lord, I hope my lord has a better copy at your lordship's, my lord.
Yes, this is a good copy.
Reasonable, my lord.
Reasonably good. Yes, I can read it.
Should the lessee duly pay the installments of rent and interest and other dues, if any thereon, and faithfully perform and observe the conditions hereon on part of the lessee, in that event, the lessee will be entitled to renewal of the demise, must be for premises, for a further term of 15 years on such terms and conditions as may be agreed by and between the parties hereto, upon the lessee giving notice of such intention of such renewal at lessee, at least must be at least 6 months prior to expiration of the period demise than subsisting.
So whether you faithfully perform, that is the important question. Subject.
Not a single default.
No, the faith comes in.
Yes. There is no bad faith between us.
Anyway, yes.
There's no bad faith.
Faithfully is subjective.
There has to be some parameters to determine faith.
Yes.
My lord, kindly now, my lord.
So all of these have been complied basically. So you have been adhering to the.
Yes, and not only that, as I told you, Lord, they are giving rebate. Now, my lord, what happens thereafter is interesting. My lord, kindly, my lord, come to, my lord, the first document at page 67.
67 years.
Yes. Since the lease was about to come to an end, in terms of that clause, we had to write about 6 months prior in point of time. First letter is of 15 December 2017. I'm just skipping it over because this is the morally admitted position. My lord, 15 December 2017, I write to the chairman WBSITCL saying that we have always complied. We have been in good terms with you. We have no other option but to get this lease extended. Hence, give us appointment to meet you, sir.
This was substantially heard, Mr. Ghosh.
Yes, it was.
And substantially marked also. So I'm being helped.
Yes. Well, it was almost more or less.
They have released this at the outset. Substantially matters, hard matters should be released. All the then my list will become. I'll be able to take up new matters.
No, that I leave.
No, I have also substantially heard it. Please let us continue.
That I always leave it to your lordship. Well,
Mr. Ghosh, let us continue.
Yes, that's what I'm
unnecessarily.
saying. I have no problem.
The cord was very, very apprehensive when I said that.
No, that when your lordship asked that question faithfully,
But my lord, one thing is there, when the hearing took place, that was at the ad interim stage. Now, after exchange of affidavits, is before your lordship.
And Mr. Ghosh, this is a very flimsy pretext to shark responsibility for the court. So let us continue. Yes.
My lord, page 69.
Page 70 is the relevant.
My lord, page 70. Yes.
Let us come to that.
March 2018.
Because the next flap is there.
Yeah. My lord, first, second, third, fourth last paragraph from the bottom.
Right.
Henceforth, we are entitled for renewal for another 15 years term as per the agreement clause. This is, my lord, 30th March 2018.
Yes.
Now, my lord, kindly comes to the actual my lord, acceptance at page 71. This is to inform you that the board of directors of this corporation in its 345th meeting held on such and such has agreed to allow you to renew 3716 square feet building space at Shilpa Bhavan first floor for a further term on long term. This kindly marks further term on a long term. No short term lease will be allowed. After finalization of the rate and tenure of long term, the same will be communicated to you.
Previous agreement
Short
was-
term, 15.
Very well,
15.
yes.
So long term would have been 30 and 99. At least 30 or if not 99.
Good.
Now, my lord, one more aspect I am sorry I should have pointed it out. In the meantime, during the subsistence of the earlier lease, we were asked to vacate and or surrender a portion of the leased out premises. That also we complied. Though it, my lord, really amounted to some, my lord,
So proportionate decrease was there in
yes. As per the per square feet area we had to pay. So my
Right,
lord,
right,
whatever was the decreased square
Exactly.
foot area, we paid.
True.
But that is also there. We complied. The moment they said that they require some portion of the leasehold property, we have, my lord,
So
surrendered.
they may argue probably there is a contradiction of terms here, because renewal at the same time no longer short term lease but long term, which
Long
is
term.
different
But it
from
is also, my lord, the clause is hedged on the terms and conditions.
Hmm.
That is also
and
there.
renewal. The expression renew is there.
Renew is there. Right.
Very good.
So, my lord, this is what they communicate at page 71.
Right.
Then, my lord, kindly come to page 72. This is our letter. First, we'd like to thank you for accepting our renewal proposal for a further term. We would like to draw your kind attention to the fact that we are agreeing for entering the lease agreement with mutually agreed terms. Please find enclosed here with the rent calculation sheet for your ready reference and necessary consideration. So we give the necessary, my lord, calculation which your lordship will find at page 73 along with our acceptance letter at the, my lord, agreed rate of 15 rupees per square feet. Now, my lord, at page 75, 20th July 2018, they reply saying, you have already been informed via this office letter dated such and such of the decision of the 345th meeting of the board of directors. However, you are hereby informed that the backdrop of schedule towards payment of lease premium that has been shown by you in your letter under reference cannot be accepted. The lease premium tenure will be informed to you shortly, and the long-term lease will be effected soon after expiry of your short-term lease on 28/9/2018. Again, my lord, they reiterate this is a long-term lease, not a short-term lease.
No, the short term lease had not yet expired.
No, because this is all happening with the short-term lease would happen
Obviously.
28th September. We had to activate the renewal clause 6 months before.
Definitely,
So we
yes.
accepted and they, my lord, we activated, they agreed.
Hmm.
Now, my lord, kindly, my lord, I am not troubling your lordship with the, my lord, payment receipts which are thereafter enclosed. Kindly straight away, my lord, come to page 103. This is really the cause of action. This is 18th of August 2022.
Yes.
Page 103. There's a circular which is given, which is pasted on the building premises. It says, as per decision of the 362nd Board of Director meeting dated 22nd July 2022 of the WBSI, the rate of short-term rent of stalls at Shilpa Bhavan Commercial Park has been considered and approved at the rate of rupees 80 per square feet per month for ground floor and rupees 72 per square feet per month for the first floor for renewal for further 15 years. That is short term. Not long term, short term, and jump from 15 to 72 because we are on the first floor. So 72. That is give or take around 600 times the increase, 600% increase of rent. My lord, this is what, my lord, hit us, my lord. So, my lord, kindly then they followed it up with a specific letter at 31st January, on 31st January 2023, page 104, to us in particular and all the other lessees, my lord, which says you have been able to make, you will have to make payment of security deposit of 18 lakhs such and such only as 6 months rent. The monthly rent will be rupees 72 per square feet, which is really in terms of the
You see,
circular.
after agreeing to the renewal, they could not reside from that rent, the previous rate of rent.
Yes.
5% and all.
5%. Because that allotment data stands, you agree to a particular mechanism of rent escalation. We are agreeable to 5%. My lord, a little more can also be, my lord, considered, but 600%. And when your objective is to give accommodations to micro and small medium industries at a subsidized rate.
Yes, obviously. What is a subsidized rate? That is subjective.
No, they have now, my lord,
So
I'll
whether
come
that
to
is
that.
also a subsidized rate, 80.
A 72 rupees is a subsidy. I'm obliged, my lord. They have now disclosed, pursuant to, my lord, the Right to Information Act, they have now disclosed the valuer's report, based on which they have come to 72 and 80. Your lordship will be shocked. They are taking the rate at the rate of sale. This is not even a long-term lease. Forget long-term, short-term lease. They are taking the rate as per sale of properties in the prime location. New building, that too of a new building, not a 52, 55-year-old building. So, my lord,
This is your case, yes.
This is my case. Now, my lord, page 105, my lord, is, my lord, from 105, my lord, to, my lord, 114 is, my lord, my valuer's report, which I have annexed, which shows, my lord, more or less a fair value of the premises, my lord, would be, my lord, kindly gives me a moment. Page koto bolto? Kindly, my lord, see, my lord.
So your argument, Mr. Ghosh, is that they should stick to their original schedule, that clause. But the undertone is we can go up to an extent. Even.
Reasonable extent, because 15 rupees is what we are paying. So, my lord, 3%, 5% from 15 rupees is understandable. My lord, page 108, if your lordship kindly comes out, that is our valuer's report. My lord, second paragraph at page 108, I would judiciously consider an increase of the monthly lease rental from 10% over the existing monthly rent, the rent of 11.58 to 11.58 into 10% plus, my lord, 12.74 per square feet per month will all other terms and conditions of the first agreement of September 2003 remaining unchanged. Hence, the monthly lease rent will be 12.74 into 3716 equal to 47,341. That is at the rate of 12.74. We are paying 15 rupees already. And they are accepting, they are giving me a rebate for good payment. These are admitted position. And even after the expiry of lease. My lord, so my case is, my lord, what we really wanted at the ad interim stage, that do not dispose us at least, because
Mr. Ghosh, please place the renewal clause once before me.
Yes.
Once it is. That may be
yes, that will have a bearing.
Compulsion.
Yes, my lord, that is clause 7,
page 60.
page 60, my lord.
Yes.
May I read, my lord? Should the lessee duly pay the installments of rent and interest and other dues, if any thereon, and faithfully perform and observe the conditions herein on the part of the lease, in that event, the lessee will be entitled to renewal of the demise for a further period of 15 years on such terms and conditions as may be agreed by and between the parties hereto, upon the lessee giving notice of such intention of such renewal at renewal at least 6 months prior. It should be at least 6 months prior to expiration of the period demise, then subsisting.
Now, Mr. Ghosh, doesn't this such terms and conditions as may be agreed open up the issue?
Lord, I would say no, because, my lord, such terms and conditions. First of all, he is a company, is a organization is a state organization. It has to act fairly, even in contractual terms. That this issue is no more, my lord, up for arguments. In contractual terms also, in contractual realms also, it has to act fairly.
And particularly keeping in view its purpose.
Yes,
I mean, that is also
that is why I placed the purpose first.
Right.
That if that is your purpose, you cannot be a land builder or a developer who can claim exorbitant rates at the market value for sale of property.
Make a profit out of it.
Yes. You are to, first of all, it's the sale of the rate for sale of a property of a new building can never be the rate for lease. That too, my lord, not a long, I can still understand 99 years lease, which is almost akin to sale. But here you are giving me 15 years, short term. You promised me long term, short term, and you are putting me onerous terms. So a state organization has to act fairly even in contractual realm.
Right.
You cannot be a Shylock. Already a formula is provided and agreed to by and between the parties, which gives at least your lordship. But I could have understood there is no terms whatsoever regarding escalation. That would be one situation. But here, in this case, in the main allotment letter, this is not the lease. Mind you, this is not the lease which has expired. This is the allotment letter, which really governs the party till the party is actually ousted out of the property. I could have understood this being a part of the lease, which has expired and hence not binding. Because this clause of renewal I am reading is from the lease. But the allotment letter is very important. The allotment letter really, my lord, forms a covenant between the parties, which is going to bind the parties till the party leaves the property. Because those are the terms for allotment. Those are still subsisting. So my lord, that says, it gives a insight into the minds of the parties as to the escalation. And that says 5% for every 3 years. And as your lordship has rightly said, my lord, any figure thereabouts is also, my lord, understandable. But my lord, 600% increase. And I will show from the records in the reply I have used, my lord, their own, my lord, valuation report, based on which the board has taken a decision. My lord, we'll see it with surprise, my lord, how they have gone ahead with the valuation. What are the parameters they have used? They have used parameters like, my lord, 40 feet road, whereas the road is actually 15 feet. They have used given the age of the building as new, whereas the building is 55 years old. My lord knows these small little my lord, instances make a huge difference in the outcome. Then, my lord, they have taken the figures from the registry office with regard to sale. That is the biggest, my lord, telltale sign that the valuation is wrong and cannot be my lord, imposed on a short-term lease of 15 years. So, my lord, 110, my lord, I was, my lord, humbly relying on my valuer who has, my lord, valued it at, my lord,
12 point something.
No, just give me a total. 110 and 112, my lord, we are finally coming to, my lord, 13.90.
Which is still less than 15.
Yes, still less than 15. But I am paying 15. Agreed rate, at agreed situation. Now, my lord, kindly comes to the opposition. Opposition primarily, my lord, Mr. Kaur, of course, will address your lordship. Primarily, they have taken 2 points. Writ is not maintainable as it is a contractual matter. And, my lord, it's a question of the rate of rent has to be as per the mutual agreement. This is what their decision of the board is. This is what they are getting at the prime locality as per the valuation report. So they are charging that. The 2 points they have taken. One, it's a contractual matter. It's not for the writ court to interfere in this issue. And second is that this is the valuation. This is what they are getting. So why not from you? And third point, of course, that everybody else in that Shilpa Bhavan, all the lessees have agreed. I am the only odd one out who is not agreeing. Now let me take all those 3 points one by one. Let reply what? May I file the reply, my lord, in this? Will your lordship's pleasure be that I place the affidavit and point out these points where they are taken?
For the time being, no.
Yes,
not
let
necessary.
me just.
Yes. If something else is sought to be portrayed by Mr. Kaur, he will be portrayed and in your reply.
I don't think over and above this, maybe your lordship
very well,
here,
yes,
Mr. Kaur.
You
But
can
my lord,
reply
in
then.
the reply, my lord, kindly takes the reply once. Reply to what? 18th. Kindly takes the reply once, my lord. My lord, the reply, my lord, we have, my lord, essentially annexed, my lord, documents which are, my lord, the valuation report which we, my lord, obtained. Unta bhai. Page, my lord, 40 is the, my lord, 40 na. 43, my lord, is the RTI that we made 22nd March 2023, my lord, seeking the information. And my lord,
47 probably maybe.
Yes, my lord, 47. No, my lord, 47 is our documents. My lord, but kindly gives me a moment, my lord. नहीं बोला है. Oh, my lord, kindly takes that from the opposition filed by them, my lord. Yes, my lord. The opposition, my lord, kindly takes their opposition, which is, my lord, which is their valuation report, my lord. It will start from page 30, my lord. In fact, my lord, kindly, my lord, takes from page, my lord, 16 onwards.
Yes.
In 14 is the valuation report, which starts at page 14. Now, my lord, kindly, my lord, come to
Page 19 says.
Yes, page 19, my lord. Your
12,000
lordship, my
per
lord.
square feet.
Yes. Finally, they have, my lord, come to a conclusion, which is, my lord, at, my lord, page 21. This is where they get, my lord. Therefore, 860 per square feet is ANI, or say rupees 71.66. That is rupees 72 per square feet per month is the fair rent to be paid by the occupants. And then they make a distinction, ground floor and upper floors. For 99 years, for 50 years, for 30 years, for 15 years, and last, my lord, monthly rent of building space stall at upper floor for 15 years, rupees 72 per square feet per month. This is what, my lord, is applicable to us. Now, my lord, kindly takes my reply. This valuation, my lord, I have, my lord, challenged this valuation in my reply, which your lordship will get, my lord, from, my lord, page 12 onwards, paragraph 14. But kindly come to page 13 in my reply. The said purported valuation report to the said affidavit is illegal and bad due to the reasons stated hereunder. 1. If one takes a look at page 23 of annexure R1 or 1, the page of the annexure.
So since we cannot finish today in any event, so let us come back tomorrow with this. I'll keep it part.
Well, instead of tomorrow, can it be Monday? Well, I mean, some difficulty.
Whatever, if it suits Mr. Kaur.
No problem. No problem. Monday, no problem.
Thank you. Hard in part for further hearing on June 19, 2020. Reply file today be kept on. Reply file today be kept. Thank you. Yes, Mr. Chakravarti will say something.
I was only praying if it can be taken up tomorrow. The disconnection matters, man. Tomorrow, today after 12 p.m. they can disconnect. So I was hoping if the 5 investors.
Which is the item number?
54, 56 and other numbers. I was only praying. One matter,
You cannot give precedence to that. The difficulty is.
I understand the pardon, my lord. I have so
egalitarianism comes in the way.
But sometimes, well, there are matters and there are matters.
Disconnection,
demolition, disconnection, tender matters. We have always seen your lordships also.
There are Mr. At least that is not the problem that this is a demolition. There are at least 100 demolition matters. Disconnection more than 100. I can assure you. I mean, I know.
I can.
As going through some of the files, it's impossible.
We can come tomorrow at 1 p.m. 10 minutes and 5 minutes of your my lord's lunch time.
Mr. Chakravarti, my time is not the factor. Even if I sit through lunch, I would be able to hear at least 3 matters.
I know that. My lord has already.
And the speed at which it is progressing, then not even 3, I suppose. Only 1 maybe.
I can only.
Every matter is contested, obviously. So that's why, Mr. Chakravarti, we cannot do it even if we sit overtime. And that will also deteriorate the quality, which may go against you also. Personally.
The veil thread.
Last chance.
Mr. Chakravarti, is not a question of your persuasion. You are not failing in your persuasion. I am persuaded. But my hands are bound literally, proverbially and literally.
We have to pay about 10 crore rupees on security. We will make the payment to the
Mr.
register.
Chakravarti, let me be very candid. You are on 10 crores. There are people who cannot pay a few thousand, 1 or 2 thousands for that. Their connection has been disconnected. They are on a worse footing. Because you can afford some alternative. They cannot. I'm being very candid. I'm not being liberal or something like that, some pseudo thing. No. Practically, I'm saying.
Can we deposit it before the register? At least once it goes to DVC, we'll never get it. That is our difficulty. That is the difficulty.
Why will you never get it? Mr. Cord is there.
I'm not there.
DVC is DVC.
For this matters,
Mr. Chakrut, I cannot.
I've been trying.
I'm giving this time to you to convince, try to convince you. If I fail, then I fail.
No, but that's
Chakrut, I cannot make an exception for you.
no. I'm not asking. I'm asking.
You are precisely asking for that. No, I'm sorry, extremely sorry. But today at 2 p.m. I fixed a matter probe. That is regarding nomination also. Other people here.
Can we come at 2:15? If it is over by 15,
I have a division bench as you predicted.
2:30.
You predicted yesterday, actually. Yes, I was not sure. 2:15, what will I do?
If it can be taken.
I'll be pulled by my ear by the Chief Justice. Maybe literally also.
The order and go.
Master of the roster and the year.
But still the disconnection. Kindly then go. I'll come at 2:15. Kindly.
That would not be feasible. That would be childish.
I'll
Keep it at 12.
May I only say this, I'll give a notice to DVC. If they can at least restrain themselves for 2 or 3 days, before which my lord may take up the matter. That much protection I'm seeking, my lord.
Mr. Chakraborty, no. I will sit at 2 for 5 minutes, but since I've fixed a matter at 2, that's why. Just for 5 minutes I'll sit, and whatever I can do in that 5 minutes I'll do. But your matter cannot be in that. Be there at 2, give a notice to the other side, you will mention at 2. I'll refuse at 2. If I can take up at 2, Mr. Chakraborty, if that matter fails, then I may. But this is just I'm not, don't put any hope on that. I'll be there for 5 minutes only. I can be there for 5 minutes.
I'm grateful, my lord. I'm grateful. Yes, sir.
Appellate side, matters at 2 p.m. Item number 83.
Lordship, I have the petitioner, my lord. On the affidavit service.
Lordship, I beg to be intervener on behalf of the and my submission, my lord. Petitioner has come before this lordship several times with distorted.
My lord, let me place my own place, my lord.
No, you are a party to the litigation?
No, he's not a party.
Yes, my lord. I was the party. The case has been disposed of by the DPRDO. Just I had the copy yesterday evening, my lord. And in this situation, if
My lord,
I am
he is
not
the
heard, my lord.
answering respondent, my lord. He
In
is the
this situation,
interested party.
my submission, I have already
Is
filed
raising an
my lord.
objection.
You are a respondent here in this
Yes, yes,
petition.
No, sir, I have not been made response for which I am my submission for.
Let me hear him first. Let me hear what is the matter about. Yes.
Lordship.
Please take your seat. Yes.
My lord, I am born and brought up in West Bengal. And sometimes, my lord, I went to the Telangana for my own personal work. That's a petitioner number 2. And petitioner number 1 is the wife of the petitioner number 2. My lord, there I have what happened, my lord, when I have decided that I should come back to my West Bengal once again. Lordship, page 4, paragraph 6, I have stated on 17/9/2022, I have surrendered my voter card and voter right to the Telangana. And that was accepted on 24/4/2022. Lordship, kindly come to page 19 of annexure P3.
Yes.
Lordship, it was submitted 17/9, accepted 24/9/2022.
You have served on the respondent.
Yes, yes, we have served.
Respondent
Through mail. Through mail, we have served.
Very well. Let us continue. Yes.
Then, my lord, what happened?
Page 19.
Page 19 is the application where when I was there, Telangana, I have the right to vote over there. And when I returned back, I surrendered my voter right.
What is this? Page 19. What is
And
page
this is the status that I have been submitted over there, my voting right, and it has been accepted by the Telangana government.
This is from the website.
Deletion of the name. Deletion of the name.
This is from the website. What
Yes,
is this?
yes, this from the website.
In that event, it has to be disclosed. The website has to be there. It's not there. Anyway, so
yes,
let us proceed on that premise. Yes. Then what happened?
Then, my lord, when I have come back, that is the Malda district, 49 Manikchok constituency. And there, my lord, when I came back, I want to enter my name as in the electoral roll. I have made the representation initially, and that was not considered. And as it was not considered, my lord, I have.
What was the representation for? What did you want to do?
That I have come back to incorporate my name in the West Bengal constituency to incorporate my name. And it was not considered by the authority concerned.
Mr. Chatterjee, do I have jurisdiction being the writ court? Election Commission has the jurisdiction probably.
Yes, my lord, for that very reason I have come, my lord. Election Commission, there is no mandatory order I am asking, my lord. Only I am asking, my lord, my name has been incorporated in the list, finally.
Then?
Private respondent that who has been supported by the present Pradhan. I don't know upon which locus standa he is moving application earlier.
He says he's not a party. Your Honor,
No, no. This matter is not a party.
This private respondent who has been implicated, you are
Yes. My lord, then my name has been incorporated, and when I have preferred the application to submit 7A, that is the incorporation my name, that application was initially pending. Due to that pendency, I could not cast my right that I want to intend and appear as a contesting party. My lord, what happened? Just day before yesterday, that portion, the authority concerned passed the order where my learned senior's client preferred one writ application, raising objection that when I was in Telangana, I did not leave my voting right, as well as I am also claiming in the West Bengal. And during vacation bench, my Lord Justice Vivek Chaudhary was pleased to send for consideration, and that consideration order was passed in my favor by dismissing the application of his.
Then you don't have any cause of action here.
No, my lord, there. Lordship, kindly come to prayer portion, my lord, for once. That is at page 10. That is the prayer A. I am not pressing.
Page
10.
10.
Lordship.
Yes.
Prayer B, I am not pressing because it has been already mitigated with. So for the prayer C is concerned, when I want to put the
2A form for incorporate by name as intending candidate, that they are standing in the way. Why they are standing in the way, that is not known to
Who
me.
is standing in the way?
The authority. In spite of there is an order in favor. And it was passed on 14th.
You means both of you want to file a nomination?
That is a number 2, the Parvin.
One.
One.
So why is petitioner number 2 a party here?
No.
Because the original challenge
Originally it was challenged. But only that order I am taking before your lordship. My nomination can be filed. It may or may not consider or rejected by the authority. When this order has passed, my lord, why they are standing in the way, my lord? I'm asking to myself.
What is the finding in your favor in this order?
My lord, that is the last portion, my lord, of the order portion. Order copy. Lordship, page 8. Last part, second paragraph. Now it is clear, respondent number 9 and 10, that is my clients, are citizens of India, and as per the inquiry report forwarded by the BDO, English Bazaar, and AEORO 49 Manik Chowk, such and such, the wife of such and such. Hence, my lord, from 4-5 lines skip, my lord. Hence, there is no bar statutory to prevent their name to be enrolled in the electoral roll under the Malda district. And the last paragraph, my lord. So the application form 7 filed by the Jahidul Sheikh, that is the interested party. What is his locus standi? I don't know.
Form 7 was the objection regarding electoral roll.
And last occasion, they have come before this honorable court because he was not present at the date of hearing. So he raised objection that I have manipulated.
Chatterjee, what is your cause of action on prayer C?
Lordship.
Where have you disclosed the cause of action on prayer C? Prayer C is to file their nomination. What was the occasion of refusal? Why were you refused initially?
That is not known to me.
Where have you stated about that refusal? There has to be a cause of action disclosed.
Yes, my lord. Initially, it was that. Yes, I'm not kindly come to page 8.
8, yes.
Page 8, paragraph 17. I'm placing a lordship. The petitioner state that the respondent notary in the meantime have declared the scheduled Panchayat election 2023 and they're vexed that the date of filing nomination, there are some mistakes, my lord. The candidate from 12/6/2023 to 15/6/2023, the petitioners having valid identification.
That was on the ground that the objection has been filed with.
Yes. And my lord, as it was not over, so I cannot file. But
so,
now,
Mr. Chatterjee, why didn't you? Oh, this respondent number 9, Jai?
9.
He has been served in this writ petition.
Yes.
You have checked up.
I have hand over the lordship.
You have checked up the.
Yes. It lordship kindly.
Just check up once whether 9 has been served and.
Respondent number 9 ta dekho to bhai. Jahidul Sheikh.
প্রধান ফুলবেড়িয়া কেয়ার অফ দি ওনার ওয়াইফ হচ্ছে প্রধান পঞ্চায়েত প্রধান
জাহিদুল শেখ
শেখের
আচ্ছা my lord, the respondent number I have been instructed that respondent number 9 is the husband of the pradhan.
Who has received? He has received.
That's not received.
Pulveria
Gram Panchayat has received it, my lord.
It is not good, sir.
No, my lord, she was represented by. That was the reason, my lord.
You say that his objection has been turned down.
Lordship. And I believe, my lord, that that lady or that person was present at the date of hearing, my lord. Because, my lord, my learned junior over there at the date of hearing, and we have submitted our written objection, they have appeared. After this order has been passed, my lord.
Yes, both filed Hazira.
Lordship.
Appeared and filed Hazira.
Appeared and filed.
Who are you? Let me hear him now.
My lord.
You want to be to intervene in the matter.
I am Jahidul Sheikh. If I am already implemented, then
you are there as 9.
But I have not been served with a copy of the writ, my lord.
I don't know the email ID of that person.
Then in this contradiction, my lord, my humble submission, whatever my private relationship may be, my wife is Pradhan, that is a different issue. I am a private person, I am a private citizen of India, and I am the intervener in this issue. My submission, if I am already implemented, then I am before this lordship, and I want to lay.
Your objection has been turned down by
No, my lord. Here lies the fallacy, my lord. Here lies the fallacy.
How?
How? That is the thing I am talking. My lordship.
Have you got an extra copy, Mr. Chatterjee?
Yes,
Please,
Lord. I
please
have.
hand over to your learned friend so that he can have a copy.
He has received it.
Oh, you have a copy.
Lordship, I have filed a can.
Can?
Yes, only I implemented.
You are there already.
Okay, ma'am.
Some documents are here.
Yeah, some documents are there. It is taken. It is already filed.
Tell me first what are the documents. Let us see.
My lord.
Can I cannot take because you are already a party.
Yes, my lord.
But the documents, what are the documents? Indicate to me, please.
Yes, my lord. My lord. Firstly, they came before the lordship in 8296 in their period.
WP.
My lord. My lord. And very interesting, my lord. Entire issue with regards to their residing at Andhra Pradesh, recently in the Telangana, they totally suppressed the entire fact in their writ petition. I am copies with me, my lord. In entire petition.
Then what happened after that?
After that, it was not within that. We have not implemented. No of the not Pradhan, not MNB, none of the parties. And after that, somehow we see that his.
What is your locus standi? You had taken that objection at that point of time.
Yes, my lord.
You had already objected.
Yes, my lord. No. My submission, my lord. This is the duty of the Election Commission of India.
To serve everybody?
No, my lord. My submission is
to serve the Pradhan's husband.
No, my lord. When the Election Commission of India notifies that the electoral roll will be rectified, revisional mechanism will be introduced, then it is made open to each and every Indian and each and every elector to file objection if there is some error in the electoral rolls. And it is the duty of the Election Commission to go for correction in electorals. And there are 2-3 aspects they take into consideration. One is migration issues, another is death and everything. And these are the issues. And 2 other very important issues. The person concerned must be citizen of India. And secondly, he must be having 18 years of age. This is these 2 basic criteria. My submission is in 2 basic criteria. I don't have any objection, my lord. My submission is someone in his early life, otherwise for some settlement, better fortune, who shifted to Andhra. Naturally, his name appears in the Andhra voter list. And Election Commission.
Both of their names or only 2? Husband, her husband.
I am firstly my submission firstly on her husband, and it is the general standard that when the head of the family's name is there, other family members' name will be included in the.
Nowadays, husbands are not heads of the family. That's a wrong notion.
They
also have a right, also ran sort of thing.
My lord, but problem is that any person cannot.
That concept has gone. Husband is no longer the head of the family.
The spouse's name shall be with the family. That is it's still the.
Maybe she may not have gone with him.
Yes, my lord.
Yes.
My question is, that any person cannot have. He may have several places of residence, but he must have only one place where he will
voters.
Have,
yes,
definitely.
Definitely.
Is the only criteria.
Definitely.
In last 5 years duration, if I check any of the electoral rolls in throughout the West Bengal, the name of HON'BLE does not appear in any of the electoral rolls. Naturally, when the issue came and they notified for rectification of electoral rolls in a revisional process, it happens in sometime early September every year. In the last September, in 22, when the Election Commission notified, his name was not there. Naturally, there is no opportunity for raising any objection because his name is not there. And we show
his permission with my line. May submit one line submission.
He's not permitting. He's not permitting. Are you permitting him to make one line of submission?
May I conclude, my lord?
He's not permitting. Take a seat. Yes.
My lord. His wife's name also was not there. It was shown deleted. Naturally, there was no objection, everything. Voter list was published on 5th January with effect from 1st January 23. In this case, my lord, interesting is the election commission, state election commission, when they went for panchayat election, they adopted of the electoral rolls of 1123, which has been standing in the case. They adopted that, they created their own serial number, own everything, polling station number and everything.
No, but your issue has been decided now by the.
Now, my lord, issue is when this issue came before the court, as per election commissioner's latest notification, they go for.
Who is this officer? ERO?
ERO is the DPRDO Malda, my lord.
Pardon?
Electoral roll officer. Electoral registration officer. And he is officially district panchayat election, district panchayat and rural development.
I am appearing for Election Commission India, my lord, but no brief has been served, my lord. But I just saw it in the list and thereafter I appeared before lordship.
So what? What is your stand in the matter?
My lord, what I have been communicated, the order has been passed and this petitioner's name has been there in the list. He is a resident of this locality.
Obvious, and your order is also.
Yes, my lord, order has been passed in her favor.
So now what is your after this order? What can remain?
My lord, electoral roll, there is name already against which I raised the complaint. And interestingly, the name has been incorporated with effect from 1st April 23. This means he is the elector of 23 and afterwards, not before the date of 1/1/23. That is my question. Second, my lord, at the present stage, throughout the West Bengal, what panchayat election mechanism is going on? Any elector, delimitations, selection of seats, reservation, everything is done on the basis of the position of the electors as on 1/1/23. This is the stand of the election commission, that his name remains there, but after 23. Naturally, he cannot be an elector and participant in the panchayat election mechanism at this stage, my lord. This is
I have only one question. After this order, do you have this right to agitate?
No, my lord. This order.
He has been directed to be included in the electoral roll.
He is already included, my lord.
Already we have been included.
It's all right. Then what is your grievance, objection to this?
My objection is
he can file a nomination paper.
No, my lord.
Why?
My submission is he remains included after 1st January and his name is already included. For which I raised the complaint.
Take your objection before the election commission if she files a nomination. You have
no, my
right.
lord. There are two issues, my lord. Election Commission of India, there is a different organization. Now, what election commission is going on? The state election commission.
You have to file objection before that authority.
No, my lord. My submission is, my lord. My submission, my lord.
3 PM or CPM? What did you say?
3 PM.
Yes.
My lord, when they raised the issue, there was direction issued upon the parties, and there is advice was issued. The what rest mechanism is left with.
Yes,
and this is the advisor on the advice on the part of the additional district magistrate Malda upon the petitioner.
Yes, suppressed it.
This advice is not binding on.
No, my lord. This is the very legal point for which I am subject.
Additional district magistrate, who is bound by that?
Now
electoral registration officer.
Yes, my lord.
He has adjudicated already.
No, my lord. Elected registration officer and panchayat elected registration officer, two are the different authorities.
If she has her role, name in the roll, electoral roll, she is entitled to file a nomination paper.
My lord.
You have a dispute that she was not here, she was not a resident here.
No, my lord. This
before
is
a particular cutoff date. If that be so, take that point before whoever election commissioner is applicable.
My lord, now the appeal will be preferred before the district election officer, that is DM, my lord. If he is not satisfied with this order.
Against this order, as well as in general, he can take an objection.
My lord, when the election commission, panchayat election.
No, I've heard you enough. No.
My lord, election commission, when state election commission adopts some role, there is mechanism, my lord. In case of any grievance, he can afresh file the for name inclusion, and that process he has not adopted. My submission, I am here with the rules of the state election commission. This is the rules of the panchayat election, my lord. Where is their provision, and that they have not followed, and this advisory was issued upon him.
What was Justice Bhattacharya's order? Which authority was to decide?
Yes,
here an order of Justice Bhattacharya has been quoted. Justice Moushami Bhattacharya has been quoted.
Yes, my lord.
What was her ladyship's direction? Which authority was to?
Yeah,
Which
electoral
authority was to decide as per her order?
district magistrate, most probably, or additional district magistrate. In that case situation, we were not there.
Acha. And this relies on that. That is the difficulty. Do you have a copy of that order?
Yes,
Annexed.
my lord. 31.
And that order prescribes the procedure how the name can be included. And that procedure has not been adopted.
District election officer was to consider. ERO is the district election officer.
No, my lord.
No. ERO, my lord.
If that is not so, then this order was not complied with.
No, it was subsequent, my lord. There was another application filed by my learned.
The next page.
Yes, my lord. In the vacation bench, it was passed, my lord.
Justice Chaudhury's order.
Yes,
as well
my,
as-
yes, my lord. Yes, my lord.
Let us see that.
Also, that is the last page, 35.
So this was a subsequent event.
Yes, my
Justice
lord.
Chaudhury.
Yes, my lord.
Yes. Page 35, respondent number 6, ERO. There is the direction given by.
Electoral. My lord, may I submit the electoral roll?
Justice Chaudhury's order is very specific.
My lord,
Page
Justice
31 of this, page 35 is the ordering portion, 33 it begins. Please look at your copy of the writ petition.
I have not been served with the writ petition. my lord.
Order is with him, my lord. It's his application.
Chaudhury's order, he was a.
That is their application, my lord. We were
Yes, you had the petitioner there.
Yes,
My lord,
I think she was the petitioner there.
My lord, I am drawing attention of the very serious issue, my lord.
No, I'll decide this.
It is the grievance, my lord. It is the grievance of the petitioner. The person cannot enter his name as a voter more than one constituency since respondent.
Learned counsel for the petitioner argues that the last, what is the cutoff time?
15 today, 3 p.m.
3 or 5?
3.
The cutoff time for filing nominations
My
for
lord,
the
one sub-
oncoming panchayat elections is 3 p.m. today. Full stop. Next para. It is submitted that pursuant to the order of a coordinated bench of this court dated May 25, 2023, comma, the electoral registration officer within bracket ERO,
My lord, ERO is not the authority.
who
my
was
lord.
the respondent number 6 in the writ petition before the said coordinate bench, that is WPA 11770 of 2023, comma, which was filed by the present respondent number 9, comma, was directed to dispose of the grievance of the petitioner therein by treating a copy of the writ petition as a representation / application under Form 7. Full stop. Next para. It is submitted, comma, by handing over a photocopy of a certified copy of an order passed by the ERO pursuant to the said direction on June 9, 2023, that the ERO considered the objection of the private respondent herein and thereafter went on to observe that there is no bar statutorily to prevent the name of the petitioner to be enrolled in the electoral roll under Malda district as resident of village Notun Naghoria. Full stop. Next para. It is submitted that in view of such development, comma, there is no impediment in the petitioners filing their nominations for as candidates for the oncoming panchayat elections of the state of West Bengal. Full stop. Next para. Learned counsel appearing for the private respondent opposes such contentions and hands over a copy of a purported advisory by the learned additional district magistrate within bracket PGE bracket closed Malda, comma, for advancing the proposition that as per section 36 of the West Bengal Panchayat Election Act, comma, 2003, comma, the Panchayat electoral registration officers are empowered to have limited applications, and in this case the concerned subdivisional officer is the electoral registration officer. Full stop. It is submitted that the ERO did not have jurisdiction to pass the order as passed by the said authority. Full stop. Next para. It is further contended that the petitioners are not entitled to file their nominations, comma, in view of the fact that the petitioners' residence in West Bengal, comma, after coming back from Telangana, comma, started subsequent to the cutoff date necessary for filing such nomination papers. Full stop. Next para. It transpires from the copy of the order of the ERO dated June 9, 2023, that it was specifically observed by the said authority, comma, in terms of the direction of the coordinate bench of this court, comma, that there was no bar statutorily to prevent the name of the petitioners to be enrolled in the electoral roll under Malda district. Full stop. Next para. Accordingly, the application in form number 7 filed by the present private respondent was dismissed. Full stop. It is rightly contended by the respondent authority through counsel that there is an appellate forum provided in law against such order. Full stop. Next para. That apart, comma, since the present private respondent was the applicant before the ERO and was present at the relevant juncture when the order was passed, comma, without there being any reflection in the said order and or the order of the coordinate bench, comma, where the private respondent was also the writ petitioner, comma, regarding the objection of the private respondent in respect of jurisdiction of the ERO, comma, such question cannot be permitted to be raised by the respondent number 9 for the first time before this forum. Full stop. Next para. Since the present private respondent not only participated in the hearing before the ERO, comma, but was the very applicant therein, as well as in the writ petition before this court, comma, where the direction in question was passed on the ERO, comma, there cannot be any occasion to reopen the order of the ERO merely on the ground that the said authority did not have jurisdiction. Full stop. It is ridiculous to place reliance on an advisory by the additional district magistrate within bracket PGE, comma, Malda, comma, which is not only contrary to the direction passed by the coordinate bench, but also to the order passed by the ERO, comma, for the purpose of entertaining the arguments made by the private respondent. Full stop. The private respondent apostrophe S case is further weakened, Turbal. Weakened in view of the admitted position that the private respondent, comma, although independently a citizen of India, comma, is the spouse of the Pradhan of the area, comma, who has a vital interest in the participation of the present writ petitioners in the election process. Full stop. Next para. In such view of the matter, comma, since no dispute regarding election is involved, comma, the writ petition is entertained and is being decided. Full stop. Since the petitioner has, comma, as discussed above, comma, made out sufficient reason for there being no impediment for the petitioners to participate in the nomination process as candidates in the oncoming Panchayat elections of West Bengal, comma, the respondent authorities have no jurisdiction or authority to prevent the petitioners from doing so. Full stop. Next para. Accordingly, WPA 13990 of 2023 is allowed, comma, thereby directing the respondent authorities to accept the petitioner's application for nomination as candidates in the oncoming Panchayat elections of West Bengal, comma, subject, of course, to the said applications being otherwise in conformity with law and procedure. Full stop. Next para. The respondent authorities shall act on the communication of the learned advocates for the parties without insisting upon prior production of any certified copy for the compliance of this order. Full stop. No address to cost.
Liberty may give us the gist of the order, my lord, to communicate the gist of the order, my lord.
They will act on your communication itself.
Lordship.
Lordship, one line, my lord.
Grateful.
Lordship, one line. Lordship, their name. Lordship, their name does not appear in the electoral with effect from 1st January 23. This is my only submission, my lord. That make my lord taking record, my lord.
Nothing else. Yes, call on the rest.
My lord, taking record at least my submission. This is the court submission, my lord.
No.
And that is stands.
Dako jeta Port Blair matter. Bujhte paro naki?
My lord, that is the very
Port Blair matter. Item 1.
You're appearing in the Port Blair matter.
My lord,
Move the matter.
My lord, I beg to appeal for the.
For you, yes.
My lord, I
Because
beg,
beard you are unrecognizable. Yes.
I beg to appeal for the petitioner. my lord.
Mr. Mitra, I'll be continuing to sit.
No.
Quickly, now.
I was told, my lord, must be misguided by Mr. Chakraborty.
That is there. Whatever he said, he has misguided you, but otherwise, what were you?
That your lordship wanted or informed him that your lordship will be taking up.
Yes, yes, I'll take up your matter. After this, these are to pay fixed matters. Yes.
My lord, I have spoken to my lord.
Clear matter?
No, my lord, Mr. Mitra.
Same matter.
Same matter. My lord, can it be taken up tomorrow? My lord, the notice of disconnection.
Yes, I can take up tomorrow. Subject to Mr. Mitra agreeing.
No, I'll be there, but the only thing is, according to our calculation, disconnection would take effect today.
And our calculation says it will.
I'll record your calculations. Let me call on this matter. Let me hear out this matter then. I'll take it up tomorrow if necessary, Mr. Mujumdar. After recording that.
Yes, yes.
My lord, I beg to appeal for the petitioner, my lord. My lord, before moving the matter, my lord, I've been led by Mr. Shijib Chakraborty. If my lord be pleased enough.
Apart from that, any other point against you?
There is no other point. There are many points in favor of me, my
What
lord.
are your points?
My lord, if can
You want to do the matter or I'll take it up then on some other thing?
some other day.
This is a Port Blair matter.
Port Blair matter. And
Are you suffering any?
No, this is coming for the first time, my lord.
Then
I'm
next month
suffering.
it is. Next month.
My lord, then let me move.
No, it will be moved before the regular bench.
Point out.
My lord,
From Monday.
Monday. No,
my lord, kindly, my lord, kindly, my lord, kindly.
It's urgency.
Urgency is that they have already they have removed my name for the enlistment list, and now they are trying to put another name over there, my lord.
What is the composition of the bench which is to commence?
That I am not.
My lord, it's not about the composition, my lord. There is an urgency, my lord.
For that.
My lord, can I beseech something, my lord? Humbly prayer, my lord. Kindly give me a stay for a limited period. Then I will try my luck over there.
Application for a limited period, subject to whatever.
29 May impugned order.
Let's do that. No, not.
My lord, kindly, my lord, please, my lord.
You will move the matter.
Yes, my lord. I will move the matter.
Even if Mr. Chakraborty does not come,
I will.
have to complete it.
I will.
You have a right to move then. Yes.
Grateful lordship. My lord, the petitioner here has filed this petition.
Chakraborty, take your seat. You also have a right of hearing after him.
My lord, the impugned order is from page number 46, my lord, which is an order passed on 29th May 2023, my lord, wherein, my lord, they have alleged that there was a work has given to the petitioner for putting off reflecting road signs back in 2005 and 6, my lord. That work was completed and all the monies, bill paid, everything has been done. Thereafter, in 2021, they found the anti-corruption unit, the deputies A of anti-corruption unit, my lord, have filed an inquiry report before them, wherein they have found that they're alleging that they have found that I have not done the work in terms of the agreement of the tender matter. Then they have show cause to us, and we have filed our reply to that show cause, my lord. And in our show cause, we have also requested them to kindly give us all the documents pertaining to this tender and kindly give me an opportunity of hearing. That reply was given to them 1.5 years before passing of this order. When they passed this order, my lord, they have passed this order without giving us any opportunity, without giving us any documents, nothing as such. They have just relied on 2 or 3 points of our reply in their order, and have just delisted me, my lord, from the enlistment list. I have, my lord, three limbs of submission regarding this and why this enlistment order is not maintainable in law, my lord. First of all, their allegation is time barred.
They had filed an objection to that.
My lord, yes, my lord. My
reply was filed to the show cause.
Yes, my lord. It is appearing
No
in page
hearing
number
was
40.
given. That is your grievance.
No hearing was given, neither any document. Man, that is my first grievance.
Hearing or document. Very good. What is
my
the
first- other grievance is that their allegation is completely time barred, and neither the inquiry report was given to me, neither I was part of the
time barred
inquiry.
under which provision of law?
My lord, the fact is that in back this the work
Corruption is never time barred.
there is no allegation of corruption against me. my lord.
Anti-corruption?
Anti-corruption has filed the inquiry report, but there was no allegation of corruption. Their allegation is, kindly come to page number 46. The order impugned, my lord. My lord,
Yes.
it says that a complaint was received from EO to CE, C's office along with.
What is EO to C?
My lord, unfortunately, even I have no idea.
Yes, what is EO to C?
Executive officer, I.
Yes, my lord.
EO, apparently executive officer. What is C?
C will be the chief engineer.
Right. Yes.
The C's office along with his enclosure as A's, not noting extract of secretary to learned governor, lieutenant governor, my mistake, my lord, dated 9 August 2021 regarding action proposed by the anti-corruption unit against agreement number 35 of 2005 and 6, and a copy of inquiry report received from deputy superintendent of police anti-corruption unit by such and such, dated 5th November 2018 regarding appropriate action to be taken on the contractor as per enlistment rule of the contractor APWD. Now the allegation was that, my lord, that, and this is in the next paragraph, in the complaint report it was mentioned that in description of items of agreement number such and such, it is to provide retro-reflective signage board with messages bilingual and as per IRC 67/2001. But during inspection of material, it is found that the messages written in the signage board are in unilingual, and that is English only with blue background. It has been fulfilled in the inquiry report that the government contractor related to the work did not perform their duties as per the provision contained in CPWD manual. There is no allegation of corruption against me, my lord. My point is simple, that this work was completed under the supervision.
Yes, they have obtained pecuniary advantages by providing materials.
Yes, my lord, that's there. But their main object is that I need to put an bilingual reflective signage, while I have only put a unilingual reflective signage. That's their main objection, my lord. This work was done under their supervision. They have paid all our bills. They have even released the security money, my lord, back in 2007 to 2012, my lord.
So now they are retrospectively taking up this.
Now they are
After how many years? 16.
2000, my lord. The work was of 2005 and 6, and we have completed it within time, my lord.
Well, let me hear them.
Just another
yes,
point,
yes,
my
make
lord.
your points.
And I have even judgment pertaining to that, my lord.
Pertaining to what?
Pertaining to the fact regarding the laws related to backlisting, my lord. If I may.
Hearing is to be given.
Yes, my lord. And
that premise.
On that premise, other words also, that there need to be they need to show the reasons also to why they are delisting me from the enlistment. And for that reason, they need to provide me documents, as well as they need to provide me an hearing, my lord. I have requested in my reply to the show cause notice that no
document is there in that judgment. Documents are to be provided also.
My lord, hearing, my lord, hearing also pertains documents.
No, that is different. You are arguing that, definitely I accept that. But
no, it's not there, my lord.
Hearing is there in that judgment, and
yes, my hearing is there. And my lord, the fact is that they have released my payments, my lord, and also they've released a security bill. They have given me show cause back in 2020.
Release?
Man, I mean, back in 2010, long back, my lord. They have given me show cause. I have given reply to their show cause. And lastly, my lord, the person who has issued the impugn order does not have jurisdiction in my submission.
Why do you say that?
My lord, kindly come down to the page 48. The order has been issued by finance officer to chief engineer, my lord.
Yes.
My lord, I will beseech your lordship to kindly come down to page number 34, where 33, my lord, where the as per the enlistment rules of the respondents of 2017, my lord, the disciplinary action, the procedure has been laid down, my lord. I will just beseech you come down to 23.2, my lord, which is actually applicable to my case. And even their show cause notice was also under rule 23, my lord. If I may read, my lord. Suspension of business. Whenever adverse report related to adverse performance, misbehavior, direct or indirect involvement in threatening, making false complaints, filing legal suits for frivolous reasons, hampering tender process or execution of contractor, any act, omission or commission, etc., damaging the reputation of department/officer or any other type of complaint considered fit by the enlistment authority are received from more than one officer or at more than one occasion from individual officer of APWD, CPWD, and etc. Works for the various class or categories of contractor and sale of tender to such APWD contractor shall be suspended immediately by the enlistment authority pending full inquiry into allegation after the decision by the empowered committee, my lord. Here the finance officer.
So enlisting, this is the enlisting authority, finance officer.
This is the, my lord, the enlisting authority is the, my lord, the empowered committee, my lord. My lord, kindly come down to the next
empowered
page.
committee is a different entity from enlisting authority.
My lord.
This finance officer to chief engineer is the enlisting authority or the chief
My
engineer?
lord, when they have enlisted in class 1, my lord, at that notification, it was issued by the finance officer to the chief.
But
same
enlistment
person.
committee has empowered committee has not been considered.
Considered, my lord. The next page, who is the empowered committee of class 1? That is
There
given,
is a
my lord.
reflection in the order that they have been consulted.
My lord, my lord. And who are the empowered committee in my case, my lord, will be the chairman, will be commercial cum secretary PWD. That is
Other
in the next
people,
page.
not the finance.
Not the chief engineer to finance officer, my lord.
Let me hear them.
My lord.
Yes.
My lords, in identical circumstance, almost identical, I wouldn't say identical is a dangerous thing to say, but almost identical circumstances, my lords, the coordinate bench of this court has passed an order. My lords, I'll not make it I'm not making a concession. I'm just placing this order before your lordship. My lords, in my humble submission, in all fairness, my lords, it can be disposed of in terms of this. My lords, may see the operative portion. Facts are almost identical. My lords, may come to the second last page. In fact, if my lord sees the third last page,
yes.
Having heard the learned advocates representing parties around perusal of the impugned decision of the enlistment authority as contained in office order dated such and such, this court finds it apt to grant an opportunity to the repetition.
So fresh hearing and then decision.
Until then, it will not be acted upon. My lords may see there is a further injunction granted.
This will have to be set aside then.
My lords may see
that
the
would have
next
been my
page.
submission.
My lords may please consider the
Let
second
us see
last
that
page.
portion. Yes.
The decision, fourth paragraph on the second last page.
Yes.
The decision to suspend business of the petitioner as contained in the office order dated 15 December 2022 shall be kept in abeyance till decision is taken by respondent number 4 in terms of the direction passed. However, it is made clear that if such no representation is preferred within aforesaid period, respondent shall be free to implement the decision.
No, Mr. Chakraborty, here the representation was not given by this person. Here they have given a reply. Consider that, give them a hearing.
My reply, I have requested them from some documents also. The whole document.
If the documents, hear them.
This is also a case, identical. My lords may see the submissions also.
Reply was given.
Yes, my lords may see. In fact, in this case, they specifically asked for Mr. Tabria's learned advocate representing as contended pursuant to show cause notice. APWD with a letter, petitioner requested authority to supply certain relevant documents in order to respond. Subsequently, with a memo dated such and such, refused to supply as sought for on the score that.
No, Mr.
In my case, my lord,
satisfy me why I should not differ from this.
Oh, my lord, I'm just placing.
Not differ because of not differing for the reason of differing. I mean, here no ratio was laid down. In that case, that was done undoubtedly. That was one of the acceptable views. The other aspect of the matter is that the reply has already been given. Now, I will in addition to this, I'll direct you to furnish the documents. Not only that, they'll be given a hearing on that. No further representation by them. One, secondly, that order has to go. They have been without hearing them. They have been. This is delisting.
I bow down. My lords may say that it will be fresh order will be passed. My lords, then they can.
That has to be that always you can without being prejudiced by any of the others.
Say that merits have not been gone into that.
Definitely, sure. Thank you very much. You still retain your fairness, Mr. Chakraborty.
I hope so.
Learned counsel for the petitioner, please both of you take your seats. If I am wrong somewhere on facts, just point out. Learned counsel for the petitioner argues that the petitioner, a contractor who worked for the respondent authorities long back in an assignment during the year 2005-2006 and was duly paid the remuneration, therefore, as well as refunded the security amount, was delisted on the allegation that the petitioner had not adhered to the rules and regulations in completing such work. It is contended that the said decision to delist the petitioner is hopelessly belated, being passed only on May 29, 2023. Full stop. Next para. It is further argued that the respondent authorities did not give any hearing to the petitioner before such order of delisting, although the petitioner had given a reply to the show cause notice issued in that regard by the respondent authorities. Full stop. Moreover, despite the petitioner having specifically sought for the documents on which the respondents seek to rely, were not given to the petitioner at any point of time. Full stop. Next para. Learned counsel appearing for the respondent authorities contends that in a similar factual situation, a coordinate bench of this court, vide order dated January 24, 2023, passed in WPA 95 of 2023, had passed certain directions, keeping the suspension order in abeyance and directing a fresh representation to be considered by the respondent authorities. Full stop. It is contended that without considering on the merits of the present allegations of the petitioner, the respondent authorities are agreeable to follow such a course of action in the present case as well. Full stop. Next para. However, it is seen from the said judgment of the learned single judge that no ratio of law had been laid down. Full stop. Although facts were somewhat similar in the said case, there are certain distinctions that catch the eye in the present case. Full stop. Next para. In the present case, for example, it is seen that the petitioner has, in addition to taking the other points, raised the issue as to the jurisdiction of the finance officer to the chief engineer, APWD, Port Blair, to pass the impugned order of delisting. Full stop. Quite rightly, the petitioner has placed reliance on clause 23.2 of the notification dated June 19, 2017, issued by the Andaman and Nicobar administration itself, subclause 23.2 of which stipulates that the suspension order may be passed by the enlisting authority pending full inquiry into the allegations and decisions passed by an empowered committee. Full stop. Unless such an empowered committee is formed and gives an opinion in that regard, there cannot be any final order of delistment by the enlisting authority. Full stop. It has also been pointed out that there are several officers, as stipulated in the notification itself, of whom the committee would be comprised of. Full stop. In the present case, however, no reflection of any consideration by the empowered committee finds place in the impugned order of delistment. Full stop. That apart, in the event the impugned order is allowed to remain, even in suspended animation, the same would not serve any worthy purpose, since the petitioner was finally delisted by way of the said order, which has to be set at naught, set at naught for the purpose of a new hearing being held. Full stop. In any event, since the petitioner was not served with the relevant documents and was not given a hearing, the order itself was vitiated. Full stop. Accordingly, WPA 732 of 2023 is disposed of by setting aside the impugned order of delistment of the petitioner dated
9th May 2023.
May 29, 2003, VD Office Order number 24/73, and directing the respondent authorities to give to serve copies of the relevant documents on which the respondent authorities seek to rely for the purpose of considering the proposal of delistment of the petitioner. First up, next para, that apart, the respondent authorities shall, upon sufficient advance notice to the petitioner, give an opportunity of hearing to the petitioner, and only after giving such opportunity and considering the reply and the arguments made by the petitioner, shall decide the issue afresh and in accordance with law. First up, it is made clear that the respondent authorities shall also consider the question as to whether such belated reopening of the issue against the petitioner could be undertaken, particularly keeping in view the fact that the petitioner had already been paid his dues and the security amounts released in his favor. Full stop. However, it is made clear that nothing in this order shall influence the respondent authorities, insofar as the merits of the allegations against the petitioner and counter allegations are concerned, which will be entirely within the domain of the respondent authorities to decide by following due process of law. Full stop. It is expected that the entire exercise shall be completed by the respondent authorities at the earliest, preferably within 3 months from this date.
My lord, one indulgence, Mr. Chakraborty has joined, my lord.
Yes, his name will also.
Just one request.
Yes, Mr. Bijay.
Another thing, my lord, I have sought for some documents in my reply dated 17 September.
No, I cannot confine them to your documents. Whatever are the relevant documents they want to rely on, they'll hand over. If we find later on that they have relied on some other documents, then you have a valid point. Yes, Mr.
My lord, I'm grateful to notice that respondents agrees, my lords. My lords may not record that, my lords. That respondent agrees, my lords. Those two words, my lords, may not say. I'm relying on the order as a judgment, my lords, not as a concession on facts.
The percentage. না আরেকটু আগে তার আগে ওই সেন্টেন্সটাই কমপ্লিট করি এই জায়গাটা কেটে দাও রেসপন্ডেন্ট অথরিটিজ আর এগ্রিয়েবলটা কেটে দাও without considering on the merits of the matter বললাম present কি merits of the present allegations in the matter, it is submitted by the respondents that the said order of the coordinate bench has binding effect.
No, my lords, has placed reliance.
Be considered.
Just one other request, my lords, since affidavits in opposition have not been filed, my lords, that
since no affidavits have been invited in the matter, it is deemed that none of the allegations made in the writ petition are admitted by the respondents.
Grateful, lordship.
No, thank you.
But I'm grateful to Lordship. Not, I'm sorry I could not join in.
You argued very well. You should give him more chance, Mr. Chakraborty.
My lord.
Next matter.
My lord. I will start.
Item number 1.
Mr. Mitra, your matter was item number? Is the other side there?
Yes.
Mr. Mujumdar is there. Item 4 target ako, tarpor 1 e jabe. 54 target ako.
Item 54.
Yes, Mr. Mujumdar, you are saying yes.
I'll tell you, Lordship, my lord, the disconnection notice is dated 17th of May, 2023. It says that It may please be noted that if security deposit as mentioned above is not submitted within 30 days from the date of issuance of this letter, notice. So my lord, if the date of issuance of the notice is 17th of May, 30 days expires today.
30 days expires tomorrow.
31st May গেছে না মাঝখানে?
31st, one day.
1 day.
Anyway, I'll record your submission, Mr. Majumdar, that is given as per the notice.
Instruction I'm submitting, so far as our understanding goes, my lord.
I
the
was
notice-
calculating, my lord.
Notice will take effect.
Literally.
Literally.
Notice will take effect on 17th.
I'll record that.
You sure?
30 days is not 17th.
No.
There was a 31st month.
Within 30 days, within 30 days, it has to be paid. And my lord,
From the date of
thereafter the
notice.
disconnection will,
Tomorrow you are saying.
yes, tomorrow. Tomorrow, my lord, anytime subject to your lordship's kind.
Tomorrow before 2 p.m. it cannot be because I mean the appellate origin set matters are there in the morning.
Then first item at 2 p.m. my lord. I think they will be also interested because
2 p.m. আর
after
কিছু fix
tomorrow,
আছে?
this will take effect.
কালকে খাতা খুলে বুঝতে হবে। একটা আছে 2 p.m. One matter has already been fixed. After that, the second matter I can keep it.
But tomorrow is Friday. My lord, the petitioner may take chance. Tomorrow is Friday, my lord. Friday is a different kind of day, my lord.
I've become equanimous on that now. Rather, Friday is a more hardworking day for us because we have to conclude the judgments and all because the next 2 days won't be good. So we have to wind up everything. Should wind up everything.
But we wind up early, my lord.
No. Let us see second matter tomorrow then.
Second matter, correct.
So I'll record an order.
Yes.
The matter is taken out of turn on the mentioning of urgency by the petitioners. First up, next para. Learned senior counsel appearing for the petitioner contends that as per the understanding of the petitioners, the time stipulated for payment by the petitioner, which itself has been impugned in the present writ petition, expires today. Full stop. However, learned senior counsel appearing for the respondent authority submits that as per the respondent's calculation, there is no scope of disconnection before June 17, 2023. Full stop. Next para. In such in such view of the matter, let the matter stand adjourned on the prayer of the respondents till tomorrow, when it will be listed as the second item to be taken up at 2 p.m.
No, on instruction, madam. Kindly record that I'm on instruction.
দুপক্ষের আগে on instruction ঢুকিয়ে দিই। What is this, Mr.
Same issue, same issue.
Keep it with you. Hand it over tomorrow.
Same issue.
Same issue means other matters. You want to?
Yes, it is in the list. It is in the running in the list. It is running in the
Madam,
list.
Mr. Chakraborty is there.
May
There
I,
is
my
several
lord,
matters which
have your
So is appearing in all the matters. Then I won't take it.
then
He has to appear in all the matters
Yes.
for the petitioner. If he appears in all the matters, I'll take it. Otherwise, I won't. You cannot take chance. Like.
that should be the
My lord, may I take leave, my lord? I have a matter fixed at 3
The
p.m.
same issue, same order. That's all.
No, next matter. Next matter, regular matter.
I'm just handing over.
No, Mr. Chokwa.
56 in the same company.
No, there are others waiting, Mr. Chokwa. Refused. Yes.
Item 1.
My lord, I am for the petitioner, my lord. My lord, I beg to appear on
Yes.
behalf of WPSCTC. My lord, I am my lord, a joint owner of a joint property, my lord, co-owner of a joint property, my lord. There was an existing electricity connection which was disconnected by the other co-owners, my lord. I applied for a
All served.
My lord, I have.
Good service and all.
State.
দেখতে দাও। Ask your junior to check up.
Item delivered.
There has to be a private respondent then.
Yes, two private respondents are
Served.
there. Yes, my lord. Item delivered.
So then what happened?
My lord, thereafter I applied for a new connection, my lord. Inspection was done. And my lord, the impugned decision is at, my lord, page 23, annexure P4, dated 11th of May 2023, whereby they are saying that since the property is not demarcated, since I have not submitted a title deed, my lord, that is why I am not entitled for
No,
a
splitting of load has been apprehended.
I beg,
Splitting of load has been apprehended by them. Page 23.
my lord, I am kindly appreciate, my lord, I am asking for a new connection, new meter with new load. Not, my lord, extending the load in the
That
existing.
will give rise to a splitting of load. The same premises from 2 meters, the same premises will be given
Not a
electricity.
separate meter for that.
Obviously, otherwise there won't be any splitting.
My lord, for that, whatever the cost, my lord, I am agree.
Cost is not a factor. The rates of electricity charges go down if you split the load. That is their apprehension.
My lord, I will not split.
Then you have to go before the grievance redressal officer. It will be easier for the court to decide that.
But my lord, I will be without connection, without electricity.
But with a remedy before the GRO. That is the remedy stipulated under the regulations. These regulations have been framed also for the High Court. I'll give you that liberty, let them go before the GRO. Splitting of load is there. But your case is that your connection was. Achha, is there any civil suit pending?
No, my lord. So far as mine, yes, my lord, there is I stand
civil
corrected.
suit is pending, we can consider that. Eviction
there
suit
is a-
against you.
No, my lord, partition suit maybe.
This is a dispute with.
You are not a party there.
I am.
You are a co-owner.
I am a co-owner of the property, my lord.
Dispute between mother and son.
Then all the more. If you are a tenant, I could have understood.
No, I'm a co-owner, my lord. Co-owner of the property.
Paragraph 2 is category.
Learned counsel for the petitioner contends that when the petitioner sought for a new electricity connection in his name, in view of alleged disconnection of electricity to the petitioner's portion of the premises by other co-owners, the new connection was refused by the distribution licensee inter alia on the ground that there is no separate establishment or demarcation in the building from the existing one, and that there might be splitting of load of electricity. Full stop. Next para. Learned counsel appearing for the respondent, learned counsel appearing for the distribution licensee submits that the apprehension of splitting of load has been specifically raised in the said objection, which has been annexed to the present writ petition. Full stop. As such, the grievance is to be redressed before the grievance redressal officer. Full stop. There is justification in such contention of the WPSCTCL. Full stop. Since there is an alternative remedy with greater scope of canvassing facts, WPA 13166 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer with the dispute as raised in the present writ petition. Full stop. If so approached, the GRO shall decide the issue in accordance with law upon giving adequate opportunity of hearing to all concerned as expeditiously as possible, positively within 6 weeks from the date of such reference being made. No address to cause urgency.
Only prayer instead of, my lord, 6 weeks, if
No,
4
no,
weeks.
it is not possible for the GRO
I'm
because of my previous orders.
I'm grateful, my lord.
Item
Next.
2.
Yes. 2 who is appearing for the petitioner? None is appearing for the petitioner.
I victor on behalf of the respondent 1 and 2.
Respondent.
1 to 3.
You are not suffering an interim order.
No.
None appears for the petitioner, although the respondent number
1, 2, and 3.
respondent numbers 1 to 3 are
1
represented.
to 4. I'm sorry. 1 to
All the respondents.
1, 2, and 4.
Although the respondent numbers 1, 2, and 4 are represented through counsel, full stop. Let the matter stand adjourned and shall next be listed in the monthly list of July 2023.
And even the writ petition is not maintainable for some other.
Not maintainable, take it for the next action.
Grateful.
In their presence, it will be better to hold it's not maintainable.
Item 3.
Yes. Yes, Mr. Ghosh, what is the matter? What about service on the respondents? Satisfy yourself first, then.
All of the state respondents. This is
What is that?
cancellation of my schedule caste certificate. Not petitioner belongs to Kormokar community. Not initially OBC certificate was granted to him. Not he applied for schedule caste certificate on the ground that the other Kormokar and Lohar is the same community and he is entitled for the schedule caste certificate. Pursuant to his application in 2016, schedule caste certificate was granted to him. Subsequently, in the year 2021, he has received a notice that you have obtained the schedule caste certificate by a misrepresentation and fraud. You deposit the certificate and proceedings were drawn up against him by the SDO, sub-divisional officer. After hearing, SDO passed an order considering an inquiry report submitted by the inspector of lordship, the backward classes. We prayed for the inspection report that was not given to me. We preferred an appeal on twofold ground that the SDO has lordship gone through a report and
What is the appellate authority? Which is the appellate?
The district magistrate.
Then
under Rule 7F. I've challenged the SDO report on the twofold ground that I'm Karmakar. Karmakar is belong to a Lohar community. I also relied certain census documents and others. And secondly, the SDO, while passing the impugned order, he considered an inquiry report that was not subbed upon. That was the specific ground before the.
What was the result of that
appeal? Appeal has been initially rejected by the backward class department, inspector backward class department. I prefer a repetition for this honorable court regarding the jurisdiction of the particular authority who has passed the order. Well, this honorable court pleased to set aside the order passed by the backward class department and direct to the DM to pass an order. The district magistrate pass an order upholding the order of the sub-divisional officer. Now, if your lordship,
how did you deal with these two allegations of your first Karmakar and
in the order of the SDO, nothing will find out that I have misrepresent or I deposit or I relied on some false document or like nothing. If you also can look into the impugned order of the SDO, that is page 54.
He redecides the issue, saying that Karmakar is not
Lohar. He says that Karmakar is not Lohar and he is not entitled to be to be declared as scheduled caste. My respectful submission is that these issues required to be sent before the scrutiny committee under section 8A of the Act. Your lordship has already decided that the issue. If you lordship kindly come to page 55, the order in portion. Now this says starts with presence of the inspector BCW being put to block. The Shubhankar Pal, Sri Minmal Karmakar and Manasi Karmakar, both sons of such and such, submitted written reply and tried to justify they originally belongs to scheduled caste community by caste Lohar as their ancestors were engaged to iron work. Though previously taken OBC certificate as subcaste Karmakar and possessing both the certificate, they submitted report of Census of India 1931, page 498, report of Census Bengal 1872, Census of Bengal 1881, Census of India 1901 and Census of West Bengal 1951. Relevant few pages regarding clarification of Karmakar for their claim on SC Lohar, but could not able to submit any document for their ancestors showing caste as Lohar. It may be mentioned regarding clarification on Karmakar as OBC, as described in the brief note on communities enlisted as OBC published by the Backward Class Welfare Department. The Karmakar is the metal worker caste of Bengal and Bihar, distinguished from their Lohar by not conflicting themselves to the fabrication of iron implements and by having no scruples about working with any kind of metal. A small number of Kamar have taken to agricultural and trade, and among them, if you hold the position of Jamindar or Tender, let's come to the conclusion. On the basis of the fact and evidence presented beforehand, inquiry
Why
report.
two petitioners, Mr. Ghosh?
Both are considered subsequently.
These are separate causes of action.
But order passed single.
Let us continue. Yes, from where we left.
On conclusion, on the basis of the fact and evidences presented beforehand, inquiry report and submission in the hearing by Sri Minmoy Karmakar, Dr. Babulal Mahato or WBCS Extension Subdivisional Officer Jhargram Caste Certificate Issuing Authority came to a conclusion that alleged certificate holder Sri Minmoy Karmakar, son of Sri Sanatan Karmakar and Manasi Karmakar, daughter of Sanatan Karmakar, such and such, do not belong to lower community which is recognized as scheduled caste. Rather, they belong to Karmakar community which is recognized as OBC and satisfied the alleged person, Sri Minmoy Karmakar and Manasi Karmakar, such and such, received their scheduled caste certificate as subcaste Lohar. Knowledge misrepresent a fact, knowledge furnishing false information.
It was said that you fall under the OBC category.
He said I'm falling in the OBC category. But my contention is that I'm not.
This was an adjudication on merits.
No,
and he has the authority to do this because
my contention is that
misrepresentation of facts.
I showed to your lordship the views, the observation of the SDO. from the observation, nothing came out that there's a misrepresentation of fact, there's a misrepresentation of false information, there is knowledge of suppressing material fact, knowledge of suppressing material information. If this ground not came, Lordship, the authority who has passed the order.
Probably you're representing yourself to be a part of the Lohar community.
Yes.
That was taken to be the misrepresentation.
That cannot be, Lordship. If it is come to
it's a part of the adjudication.
It is part of the adjudication before the social status scrutiny committee, not before the SDO.
Which
SDO
was there in your case when you were awarded the certificate.
I've been awarded by after inquiry.
And now there has to be a social security.
Now, my contention before his Lordship is that the SDO can cancel my certificate only if there is knowledge of misrepresentation of fact or knowledge furnishing the false information, knowledgeably suppressing the material fact.
So how did the district magistrate proceed? Let us see.
Kindly come to my appeal.
Let us see the order first.
Same thing, just a copy paste one.
So he did not consider about your not having the copy of the report.
No, not even. Not even. Page 93, the order of the district magistrate. My lord, if you also kindly come to 1, 2, 3, 4, 5. My lord, paragraph 5 from the top.
Yes.
Applicant Nilkamal Kormokar submitted land deed of Sri Paresh Chandra Kormokar and Ramesh Chandra Kormokar of the year 1981 from ADSS Silda, and that of Solil Kormokar of the year 1987.
This is
from
which page?
Page 93, my lord.
93, yes.
1, 2, 3, 4,
Right,
5,
right.
6 paragraph.
Yes, applicant. I'm ready.
My lord. In support of his claim of belonging to Lohar subcaste, which were duly examined, it is noted that the caste status of Paresh Chandra Kormokar, Ramesh Chandra Kormokar, and Solil Kormokar, status of Paresh Chandra Kormokar are mentioned as belong to Lohar subcaste in the aforesaid deed of 1991-1997. He submitted certificate of Pradhan Silda Gram Panchayat attesting that they belong to Lohar subcaste, which is not conclusive document to ascertain caste status as per the entire.
You had received an OBC certificate, you did not return that?
No, that's what I've returned. I've deposited. He says, since I obtained OBC certificate, I should not have the civil caste.
No, he could not produce any satisfactory proof or explanation why he did not return back the OBC certificates. Once they received, that has been found.
Not it's true, my lord, it's written, but I have deposited. But it was written in the subdivisional order. Subdivisional.
To go by that, the presumption is that is correct regarding of fact.
But there is no Lordship of fact. There is no suppression of fact that have suppressed something. Unless there is a suppression of fact or misrepresentation, SDO do not have any jurisdiction to cancel my certificate.
Show me the relevant provision once.
Yes, madam.
Rule 4, Rule 3.
Rule 9, Lordship. Section 9. More precisely, Section 9. Power to cancel and impound of revoked certificate. Rule 9 of the 94 Act. But it starts with the certificate issuing authority is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery. It may cancel, impound or revoke such certificate in such manner as may be prescribed. But unless there is a misrepresentation or fraud or forgery,
No, district magistrate has also taken into consideration that you did not surrender your OBC.
but kindly see the order of the subdivisional officer. In the subdivisional officer,
you obtained an OBC certificate
initially
first.
Obtained the OBC certificate.
Then what was the occasion to file for a...
Since I am a civil caste certificate, I deposited I filed an application to treat me as a civil caste certificate. I am not OBC. And after inquiry, it was granted. This is not the case that I'm not after any inquiry, it has been granted.
What was the committee of which the report was considered?
Kindly come to section 8A.
No, the SDO considered.
Yes, my lord.
The
That
report
is
of which committee?
Kindly come to page 54.
54 years.
In terms of sub rule 3(1) of West Bengal scheduled caste and scheduled tribe identification rule, a team comprising of Sri Devashish Manna, WPCS extension, deputy magistrate, and Deputy Collector Jhargram, Shri Alok Purohit, WBCS Extension Deputy.
order record.
Number, if you also kindly come to.
I'm allowing it. Learned Counsel, despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. The petitioner has challenged the cancellation of the petitioner's caste certificate initially by the concerned subdivisional officer, which was affirmed by the appellate authority, that is the district magistrate, Jhargram. Full stop. It is contended that within the provisions of section 9 of the West Bengal Scheduled Caste and Scheduled Tribe within bracket Identification bracket closed Act, 1994, only if the certificate issuing authority is satisfied that a certificate has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or producing any document which is an act of forgery, it may cancel, impound or revoke such certificate. Full stop. Next para. In the present case, it is argued that the petitioner was duly issued a scheduled caste certificate, which was subsequently cancelled upon a virtual rehearing on the merits of the issue, which was dehorse the powers conferred on the authorities under section 9. Full stop. Next para. A perusal of the annexures to the writ petition indicates that the subdivisional officer as well as the appellate authority entered into the merits of the question as to whether the petitioner, who belongs to the subcaste Kormokar, is equivalent to the Lohar community, which is a scheduled caste, and thereafter went on to cancel the certificate initially issued to the petitioner on a valid inquiry. Full stop. Next para. However, nothing transpires from the orders of either of the authorities below to the extent that the petitioner had suppressed any material information or furnished any false information or produced any forged document at any point of time. Full stop. That apart, an inquiry on merits was undertaken before issuing the caste certificate to the petitioner as long back to the petitioner's survey, as long back as in the year, which year?
2016, my lord.
To 2016. Full stop. Next para. Moreover, it is also palpable that a report, which was purportedly relied on by the first authority for cancelling the caste certificate of the petitioner, was never handed over to the petitioners for the petitioners to consider and address on the same. Full stop. Next para. Hence, even on a prima facie perusal of the records of the impugned orders, it is evident that the prerequisites of section 9 were not fulfilled in the present case. Full stop. Hence, the impugned orders cannot stand the scrutiny of judicial review. Full stop. Accordingly, WPA 13372 of 2023 is allowed, thereby directing the respondent, thereby directing the subdivisional officer is a party.
Yes, my lord.
Thereby directing respondent number 6, the subdivisional officer of the Jhargram Sodor subdivision to rehear the petitioners, upon giving a fresh hearing to them and upon service of copies of the inquiry report and other documents on which the subdivisional officer intends to rely, to the petitioners. Full stop. After such rehearing is given, the SDO shall decide the issue afresh, as to whether the criteria stipulated in section 9 of the 1994 Act are satisfied in the present case or not. Full stop. Accordingly, the SDO, upon giving due opportunity of hearing to all concerned, shall decide the issue afresh in accordance with law, preferably within 3 months from the date of communication of this order to the respondent number 6. Full stop, next para. It is, however, made clear that the merits of the matter has not been gone into by this court, and it will be open to the subdivisional officer to decide on all issues involved independently and in accordance with law. Full stop, however, since the petitioners separate caste certificates were cancelled by the same impugned order, it was for the petitioners to file 2 separate writ petitions, having different cause of action. Full stop. Such technical defect, however, can be cured in the event the petitioners deposit the equivalent of the stamp duty payable for filing another writ petition by tomorrow before the concerned department of this court. Full stop. It is made clear that this order shall stand conditional to such deposit by the petitioners. Full stop. In the event such deposit of additional court fees is not stamp duty to court fees, stamp duty. Additional court fees are not paid by the petitioners by tomorrow, this order shall stand automatically revoked and cancelled without further reference to court.
Much obliged.
I'll come back in 5 minutes and take up the next.
Item 4.
Yes, what is the matter?
Your Lordship, in this, we filed our section 14 on 9th of September 2022. And there has been no order passed.
You have not implemented the party against whom that section 14 was levied.
We have implemented them, Your Lordship. The assigner bank sanctioned a 6 crore.
Yes, the debtor has to be implemented as a party to this. Why didn't you implement? They will be the worst affected if the section 14 is implemented.
Yes, Your Lordship.
Implement them, give a copy, come back whenever you like.
We'll implement them as a party and then.
I'll give you that liberty.
Your Lordship, actually the whole issue has happened that I do not have the file. So if you can give me, like, if this matter can be taken up at the end of the board. I just came back running from the NCLT and I could not.
Very well. It appears from the records themselves that only the district magistrate and the state has been made parties. So I'll give you that liberty today instead of wasting further time for you.
Your Lordship, still I would be in a difficult position then.
An adjournment is sought, I'll say that. An adjournment is sought by the petitioners, full stop. In any event, it transpires that the application has been filed primarily for expediting an application pending at the behest of the petitioners before the concerned district magistrates under section 14 of the SARFAESI Act 2002. First up, since the borrower has not been implemented in the present writ petition, but is a necessary party thereto, leave is granted to the petitioners to implement the borrower and to effect the necessary corrections to the cause title to that effect by tomorrow.
Yes, Your Lordship.
By tomorrow, full stop. Such liberty is given to the learned advocate on record for the petitioners. Full stop. Immediately thereafter, a copy of the amended writ petition shall be served on the added respondent, indicating that the matter shall next be listed on July 4, 2023, when the petitioner shall file an affidavit of service to that effect.
Obliged, Your Lordship.
It goes one step further instead of wasting.
Agreed.
Thank you.
Item 5.
Item 5, my lord, I am for the petitioner.
Yes, what is the matter?
My lord, this is regulation, my lord, relating to the billing dispute, my lord. The petitioner is a cultivator, my lord.
Billing dispute, you have to go before the GRO.
Yes, my lord, I made representation to the RGRO, my lord, but they had not taken any step till.
What is the representation?
My lord, the first representation, representation, my lord, on page 20, my lord.
The grievance of the petitioner is limited. Full stop. The petitioner has raised a billing dispute with regard to electricity charges, which, according to the petitioner, has not been resolved as yet by the concerned grievance redressal officer, that is respondent number 4 herein. Full stop. The petitioner, accordingly, seeks an early disposal of such representation. Full stop. Next para. Despite service, none appears for the respondents. Full stop. In view of the innocuous nature of the prayer, further service of notice is not being directed. WPA 13428 of 2023 is allowed, thereby directing the respondent number 4, that is the regional grievance redressal officer, WBACDCL, Murshidabad regional office to decide the representations given by the petitioners, copies of which are annexed here to, as expeditiously as possible, preferably within 8 weeks from the date of communication of this order to the respondent number 4. Full stop. The said disposal shall be done in accordance with law and without being influenced in any manner on merits by any of the observations made herein. Full stop. Next para. The grievance redressal officer shall give adequate hearing to all concerned prior to concluding such hearing. Full stop. The petitioner shall serve copies of the server copies, shall serve a server copy of this order on the respondent number 4 within a week from date to ensure due compliance of the same. No address to cause urgency required.
Leave application.
Item 6.
Your Lordship, I'm praying for an adjournment on behalf of petitioner
I'm not suffering an interim order.
due to incompletion of service. Your Lordship, I'm praying for an adjournment for 1 week.
You are for which respondent?
I'm for the state respondents, my lord. Here, all the state parties are here, my lord.
All the parties are here. State is appearing.
Then your Lordship kindly
An adjournment is sought by the petitioner at the outset.
kindly short pass over my
No,
Your Lordship.
no short passover. Either you start the matter or I put it in the next
Right
month.
now,
list.
I don't have briefed, Your Lordship.
What is the case about?
My lord, for appointment of Anganwadi worker, my lord.
What is the defense?
My lord, earlier the petitioner worked as an Anganwadi worker, my lord. Subsequently, on the basis of the complaint made by the local persons, my lord, the petition was FIR was lodged and suspended, my lord. Thereafter, on the basis of the order passed by the Chief Judicial Magistrate, they worked. Kindly see page 31 for a moment. Both two accused persons, namely such and such, are found not guilty to the offence punishable under section such and such. Accordingly, they are acquitted from the case.
This
under
this
section
petitioner was acquitted.
Yes, my lord, petitioner.
So after
There-
that, what happened?
My lord, thereafter, the petitioner moved a writ petition before this Honorable High Court. On the basis of the order passed by the Honorable Court, hearing was made by lord. Kindly see page 35, my lord. At the time of hearing, petitioner was unable to produce the original documents such as admit card and ST certificate.
Only for that it was rejected.
No, order was not passed. Thereafter, the petitioner made application several times, but that was not considered since she was not able to produce the original documents, my lord.
Original documents, what about the
ST certificate?
Lordship, kindly adjourn this matter. Lordship, I am not in this matter. Kindly adjourn this matter.
The petitioner has challenged. Now, at the outset, an adjournment is sought by the petitioner. Full stop. The grievance ventilated in the present writ petition is very limited and ought not to be deferred further. Full stop. Next para. The grievance of the petitioner is that the petitioner initially was appointed as an Anganwadi worker, but subsequently she was sacked from the said post due to certain allegations against the petitioner. Full stop. However, subsequently the petitioner was acquitted in a criminal case of the same offense. Full stop. Thereafter, the petitioner sought for being engaged again as an Anganwadi worker. Full stop. Pursuant to a previous order of a coordinate bench of this court, a hearing was given to the petitioner, but she failed to produce her original documents for the purpose of taking a decision thereon. Full stop. Thereafter, the petitioner has made several representations, but unfortunately, she could not produce her original documents. Full stop. Next para. Heard learned counsel for the parties. Full stop. Upon hearing the parties, it is clear that the respondent authorities have not expressed any view on merits to refuse the plea of the petitioner to be engaged as an Anganwadi worker. Full stop. The respondents merely insist of production of valid documents by the petitioner for the purpose of giving such engagement. Full stop. Next para. In such view of the matter, WPA 13473 of 2023 is disposed of by directing the petitioner to furnish the relevant documents required for the purpose of giving such engagement to her as an Anganwadi worker, which are required under the relevant scheme. Full stop. Next para. Upon such documents being handed over submitted by the petitioner to the relevant to the respondent authorities, the authorities shall, as expeditiously as possible, process the said documents and scrutinize the said documents.
Kindly direct the respondent number 6, my lord.
Very well. Respondents respondent number 6 shall thereafter scrutinize the said documents handed over by the petitioner, and in the event those are found to be satisfactory in accordance with the relevant rules, and procedure, comma, engage the petitioner as an Anganwadi worker as expeditiously thereafter as possible. Full stop. In any event, comma, the respondent number 6, that is the district magistrate, comma, South 24 Parganas, comma, shall complete the entire exercise up to engagement of the petitioner as Anganwadi worker within an outer limit of 4 weeks from the date of the petitioner furnishing the relevant copies of her documents. No address to arekta line add kore the parties and all concerned shall act on a server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. No address to cause urgent certificate. Take a server copy, hand over your documents to the magistrate. He or she will consider and within 4 weeks give you the tongue.
Much obliged.
Give your name, but
Your Lordship.
yes. Thank you.
Item 7.
Yes. 7, who is appearing? You are appearing? Yes, Mr. Vajpayee, what is you are for the respondent?
I am for the petitioner here. I am for the petitioner.
Oh, petitioner, sir. Yes.
With my learned junior Kushidan Chatterjee.
Yes. What is the grievance?
My lord, the grievance is against the National Commission for Scheduled Caste and Scheduled Tribes. So, my lord, the basic grievance is that they have stepped into the area where they are not permitted within the scope of their jurisdiction.
Mr. Vajpayee, this is appearing for the first time.
It is for the first time.
I think I should direct affidavits in this matter.
As your
Because
lordship
they
wishes.
have their right to produce whatever documents they have. Why they are stepping in? What can be their defense?
My lord, they are not appearing in the earlier order. In the earlier, the similar issue came up before a coordinate bench of this honorable court.
What happened?
And my lord, they did not prefer to appear.
What was the order?
And the order I have annexed with the, because they made a commitment to the authority that we will not proceed with the matter, the National Commission. So in accordance with their commitment, my lord, we did not press it before the honorable court. That since they are not progressing with the issue, so we will not press it. And now again on the similar point, the question is very short. Short is that the National Commission of Scheduled Caste and Scheduled Tribes are primarily vested with the duties and responsibilities not connected with the service disputes. That is strictly within the purview of the Central Administrative Tribunal
You
Act.
have the affidavit of service. Proper service has been effected.
Yes,
Then I
yes.
can hear out the matter.
Yes.
Please check up whether good service has been effected. Good service has been effected.
Respondent number 2 has not been served.
2 has not been served.
Not yet delivered, Lord Lordship. Respondent
Not yet delivered.
Yeah, tag report shows.
If not yet delivered, Mr. Vajpayee,
Yes,
wait for a
yes, yes, yes.
because they are the main respondents.
No, my lord. In that event, my lord, let it be delivered and your lordship kindly fix it up.
Affidavit of service filed to be kept on record. Full stop. Since respondent number 2 is one of the primary contesting parties and has not yet been served properly as per the affidavit of service, comma, the matter is adjourned till June 26, 2023, when it will be listed again, comma, awaiting completion of service on the respondent number, on the remaining respondents, full stop. Upon such service being effected, comma, the petitioner shall file an additional affidavit of service incorporating the relevant track reports in that regard on the next date of hearing.
My lord.
Affidavit of service niye rekhecho to? Very good. Thank you. Mr. Vajpayee, let us wait for them. We'll hear it and
No
fetch it up.
problem. Unless it is properly served.
Probably
my lord.
affidavit is not
No.
necessary in this matter. Legal question. Wait.
Item 8.
Yes, Mr. Banerjee, what is the matter?
My lord, expeditious disposal of an my lord, second appeal before the West Bengal Information Commission. But my lord, I see that my lord, the service has not been effected upon the respondents. My lord.
Come back when? 26th?
As per your lordship's convenience.
Service has not been completed on the respondents. Affidavit of service filed today be kept on record. Awaiting service. The matter is adjourned till June 26, 2023. Please come back. You'll file an additional affidavit of service. I'm not directing you. Please file that on the. Thank you.
Item 9.
Lordship, the service on all the parties are not yet complete, but there is some urgency. If your Lordship may kindly keep it on Monday.
It is submitted by learned counsel for the petitioner that all the respondents have not yet been served. Full stop. Accordingly, on the prayer of learned counsel for the petitioner, the matter is adjourned till June 19th, 2023.
Lordship.
You are filing your affidavit of service
I'll
today?
file it on 19th, Your Lordship. May it retain its position, Your Lordship.
I appear for
I can assure you it will not.
I appear for a State Bank of India in the matter.
Please
Let
give it.
there be direction to serve me, my lord.
I'll serve.
You have said that is sufficient for them.
Yes.
Yes. Next.
Item 10.
Your Lordship,
Similar.
the next matter, not similar, it's Your Lordship, the advocate on record, it's been wrongly filed. I would like to withdraw this petition. It's not moved yet. It's appearing for the first time. Service is also not been given effect.
So withdraw without leave to file.
With leave to file, there are some defects. That's why I'm just
Very well. Learned counsel for the petitioner submits that there are certain technical errors in the writ petition and, as such, the petitioner seeks to withdraw the same with liberty to file afresh. Full stop. Accordingly, WPA 13668 of 2023 is disposed of as withdrawn with liberty, is dismissed as withdrawn with liberty to the petitioner to file a fresh writ petition. It will be a writ petition. Forum is right.
Forum.
Fresh writ petition on the self-same cause of action. No rest to cause,
We are for SBI in the matter.
Right.
Yes.
Item 11.
I beg to appear for the bank, my lord.
This is my application, my lord. My lord, the petitioner is a CPWD empaneled government contractor, my lord. My lord, his current account number with the PNB, my lord, that is registered with the CPWD authority.
Have you served on the executive engineer?
My lord.
Good service.
My lord, I have been told that they have received, my lord.
I require an
My
affidavit
lord,
of service.
my lord, that is not with me.
Without an affidavit of service, I cannot take.
My lord, Monday, my lord.
What is the grievance against the bank?
My current account suddenly stopped. The account which was transferred from the CPWD authority on 29th March, my lord, they have closed on 29th and the amount transferred 29th evening. My lord, as 31st March is the financial year closing, my lord, they have sent it, my lord. And that matter automatically, it was remitted back to the authority, my lord. My lord, I am suffering. I am without.
What can the
prejudice,
bank
my
do
lord.
now?
My lord,
What relief have you claimed against the bank?
Reopen the account, my lord.
My lord, may I just
It is
point
my
out?
Yes, can it be done?
Without my knowledge,
My lord,
without
may I just
my
point out one
consent,
thing, my lord?
my account was
There is
closed.
no current account lying in the bank in the name of this petitioner, my lord.
this
There
is-
is the overdue account. The
Overdraft
account bank has
yes,
closed.
32
The overdue
years,
account.
Since 32 years it is.
May I will just point
What about the sudden closure of that overdraft current account?
my lord, we have
But
liquidated. There is a queue of 22 lakhs rupees, my lord. That's why we have liquidated the money to the other accounts, my lord. Otherwise, my lord, the entire account will become three accounts. There are three accounts.
How
All
soon
will
can you
become
file your
into this.
opposition?
My lord, opposition is required. My lord, I will bring all the documents.
How soon?
My lord, a week. Within a week, my lord.
Week is very fair. Yes. Thank you. Learned counsel for the petitioner has raised an issue as to how the respondent bank closed the overdraft account of the petitioner with the said bank unilaterally without informing the petitioner. Next para, learned counsel appearing for the respondent bank submits that there was sufficient justification in law for doing so. However, since certain factual disputes have been raised, the respondents are directed to file their affidavit in opposition within a week from date. Reply, if any, shall be filed.
May I show two documents?
No, on the returnable date, let them reveal. Let them reveal their documents. You will file your reply. In that,
This amount, my lord, is kept in a miscellaneous account.
No. We have remitted back.
It is
No.
not.
reply, if any, shall be filed by 3 days thereafter. Full stop.
CPWD authority.
The matter shall next be listed for hearing on June 28th. 28th June.
28th June, my lord. I'm grateful
It
to
is
lord.
lying with
There, the
the
bank, they cannot flee away with the money. They will have to give the money if ultimately I hold in your favor.
Yes.
So it's a bank. I need not secure the amount, your amount. And there is no amount. Actually, it was an overdraft account.
My lord, OD was renewed time to time, my lord.
You are
But
lucky
now-
that they are agreeing to 1 week's affidavit time.
My lord, my lord.
Call on the next matter. Ricky. আচ্ছা একটু এটা সই করে নেয় give me half a minute, there's an urgent order, I'll just sign it in.
Returnable date what? Returnable date?
পেজ 4 আর 5 এ কারেকশন আছে করে দিয়ে আপলোড করে দিতে বলে 4 আর 5 এ কারেকশন আছে করে দিয়ে আপলোড করে কল কর বাট এক্ষুনি যেন আপলোড হয়ে
Item 12.
Yes.
Yes, my lord.
Yes, please.
Part of the service completed, but not.
Service not yet complete. Let the matter
Kindly
stand
brief the
adjourned till,
matter next week, my lord.
till June 19th.
Thirteen.
With 13, Lord, I am for the petition.
Yes, Mr.
But I take your lordship, Lord, to the other facts.
Good
but
service.
Lord, yes, the state government has been served, who is not the concerned respondent.
Very good. Yes. What is
But
that?
kindly come to page 96, the order that I challenge. But I was, Lord, occupying a particular portion from the year 1942, Lord, by dint of a lease granted by Lord DT. Lord, I was occupying that property when Lord, that particular property was Lord sought to be acquired after vesting under the West Bengal Estate Acquisition Act. When it came up before this honorable court, Lord, that vesting order was Lord divested. Lord, it was reverted back to the DT, and Lord, consequently, Lord, the lease that was granted after Lord the vesting to my client for operating a factory there, Lord, that was also not recalled because the lease that was granted could not be continued because the vesting was bad. Now, Lord, it so happened now by the letter that has been Lord impugned before your lordship, Lord, the state has given this letter saying that you hand over possession to the DTs. And if you do not do so within 15 days, the DM has been directed Lord, to take possession and hand over. But how can the government Lord be an executing authority on behalf of Lord a private entity? That is the question I ask myself. But kindly come to page 96.
Was there something in the order of this court that the government has to do
No,
something
Lord,
like
there is nothing. I can show each and every order, Lord, that were passed by this.
You have checked up there is nothing of this sort.
No, Lord, there's no direction for Lord handing over by any of
This is the worst thing that can be argued against you.
Lord, other thing, Lord, I do not know. If your lordship kindly comes to me, Lord, the page 96, the basis of this particular order is, Lord, an observation of the law department VTA under reference number such and such. I do not know, Lord, what is the
direct
Lord,
affidavit stay the operation.
That's your lordship. But we are not even given this, Lord, the observation of the law department. When we have asked for this, they have not provided us the basic reasoning on which, Lord, they issue this impugned order.
The petitioner has raised an issue as to whether the respondent authorities acted without jurisdiction in communicating to the petitioner vide memo number 2279-LP-1 3M-60/14 GE within bracket M dated June 2, 2023, directing the petitioners to hand over the possession of a premises within 15 days of the said order to a particular DT. DT is also a party here.
DT is also a party.
Comma, which is
Three
also DTs, to certain particular DTs, DEITI, comma, who are also respondents in the present writ petition. Learned senior counsel appearing for the petitioner contends that initially the property was vested and a lease was granted to the petitioners. Subsequently, comma, however, comma, the DTs moved this court and by an order passed by a coordinate bench, comma, the land was divested. However, comma, subsequently, the state authority did not have any locus standi to act on behalf of the DTs and direct the petitioners to vacate the premises, comma, that too, comma, in favor of the DTs, comma, whereas the DTs have not taken out any proceedings in that regard to the knowledge of the petitioners. So next para, the petitioners have made out a strong prima facie case as to whether the state respondents had locus standi to direct the petitioners to hand over possession of the property to the DTs, comma, who are also respondents herein, comma, particularly in the teeth of the divesting ordered by a coordinate bench of this court. Next para, that apart, comma, several other questions worth the hearing of the writ petition on merits have been raised by the petitioners. Accordingly, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Replies, if any, shall be filed within a week thereafter. The respondents shall remain restrained by an order of injunction by giving any effect to the impugned communication as indicated above, and or disposes the petitioners without taking recourse to due process of law till disposal of the writ petition. The writ petition shall next be listed for hearing on July 17, 2023.
But there's one wrong submission on my part. The divesting order was by the LRTT, my lord, and thereafter affirmed by the High Court.
আচ্ছা, দুই জায়গায় ডাইভেস্টিং কথাটা মুভড দিস কোড বলেছি। একটু আসুন, একটু আমি একটু পড়ে দিন, আমি বলে দিচ্ছি আপনাকে। Learned senior counsel, second paragraph থেকে, just second paragraph. Learned senior counsel for the petitioner submits that it is moved the LRTT.
But it was filed in the High Court at the time of when the new law came into being. All the documents were transmitted to LRTT. LRTT decided.
আপনি একটা কাজ করুন, এখানে ব্র্যাকেট করে মুভ দ্য হাইকোর্ট যেখানে বললাম, তারপর কি বলেছি বলুন? The land was যেখানে বলেছি, তারপর স্টার্ট দিয়ে একটা পাশে লিখে দিন। না, land was না, সরি, and subsequently কি বললাম একটু আরেকবার। এইখানটা থাকুন, দিস কোর্টের পর, দিস কোর্ট, কমা, the matter was relegated subsequently to the LRTT, which তারপর divested বলেছি। যদি ওটা কন্টিনিউ করে তাহলে কি আসছে? আপনি এটা রেখে দিন, আমি করে নেবো। আপনি যা বললাম এটা ঢুকিয়ে দিন, আর কি LRTT-টা ঢুকিয়ে দিন, আমি করে নেবো। এখানে বোল্ড লেটারে করে দেবো। I'll change, make the change.
Yes, after LRT, High Court not affirmed.
High Court relegated to LRTT directed divesting, affirmed by High Court.
Yes.
Very good.
Grateful.
14.
Please, your lord.
Yes, Mr. Bhattacharya.
My lord, I appeal for the respondent number 2.
Lord,
All
I
have been served? Yes. What
Only
is,
two respondents, the other respondent has also been served.
right. What is the matter? Why by name, Mr. Bhattacharya, competent authority?
Lord, because I have made certain allegations.
What is the matter?
My lord, there is this particular act known as the Petroleum and Minerals Pipelines Acquisition of Right of User Act 1962. My lord,
Forget the name.
No,
What is the year of the act?
1962 Act.
Yes.
My lord, it's a part of the writ petition annexure P1.
Right.
Now, the issue which falls for consideration is as to whether the competent authority, namely the respondent number 1, appointed under section 2A, this particular act, my lord, he has certain specific premise to act on. My lord, his jurisdiction flows from the act. Now, this proceeding, the proceeding before him, was triggered on the basis of a complaint lodged by the Indian Oil officer, whoever, the general manager, there's this known as Haldia Barauni pipeline project. It's a national project of some considerable importance. Now, this project, this land was acquired way back. In 2000, crop compensation was paid. This land compensation was paid. The matter was running. Now, in 2019, we intended to lay the pipelines for this Haldia Barauni project. Now, in the meantime, Milord, what had happened is the land, the nature of the land underwent a change. It became, a fishery. It was converted. The private respondent was a lessee in respect of this entire fishery.
You had acquired the land?
Milord, this right of user. It is not, Milord, acquired in that sense.
The other sense.
The right of user, the act is right of user. It's the,
All right.
the right to use the land.
So acquisition for that purpose.
Yes. Now, my lord, what happened is the entire land measures 9360 decimals. My lord, about 180 bighas or something. Now, we were using a portion for laying down this pipeline. Now, in the meantime, there were certain disputes insofar as the quantum of time that was consumed by us, as to how much time, etc. Good, bad, indifferent, my lord. At that material point of time, an award was made in terms of the act. This is very important. Why I am troubling your lordship? An award was made, 42 lakhs and odd has been paid, admittedly, towards compensation for this right of user now, for crop compensation. There is
to the owner,
to the lessee.
To the lessee.
To the lessee.
Yes.
42 lakhs and odd. The competent authority has declared the award, everything said and done. Now, my lord, in November 2022, a grievance is raised by Indian Oil officer saying, I'm sorry, January 2022, extremely sorry, my lord. January 2022, grievance is raised regarding, my lord, problems created at the instance of the private respondent and his men and agents, my lord. They have, my lord, deployed various, my lord, goods and articles. They are preventing us from entering.
Mr. Bhattacharya, before it was converted to a fishery, the crop compensation was given.
No. After.
So that
Crop,
also called.
it is known as crop compensation.
I was going to ask.
My lord, colloquially or my lord.
So fish is also crop.
Yes,
For
technically.
that purpose.
Technically.
Yes. Get it.
Now, my lord, what happened is,
not crop.
And they had in 2022 this problem cropped up. Now, on 25th of January, this date is very important. 25th of January 2022, this complaint lodged before the competent authority is taken up for consideration by the competent authority. Order sheet will reveal that. He says that one AJ something, AJ Basu or something, someone, he was the AJ Chakraborty. He was the general manager of this project. He has lodged a complaint, served notice on my learned friend's client.
Notice was served.
Complaint regarding what?
Complaint regarding, my lord, the disputes, the disturbances created at his instance. My lord, all are on record. I'll demonstrate prima facie.
Then?
Now, he was served notice 3 occasions. He chose not to be represented. On the 4th occasion, my lord, on the 17th of February 2022, he appears with a written representation. Apropos this notice, in response to the notice served on him by the competent authority, saying nothing on the disturbance created, but my lord, raising an issue regarding additional compensation for protracted use of land.
The work is being stalled.
Work was stalled. Now, my lord, everything is over. Now he says before the competent authority. Now, one thing I must tell you a lot. Prior to this complaint and everything, a writ petition was also carried to this honorable court at the instance of the private respondent, my lord, claiming additional compensation. Now, good, bad, indifferent, my lord, without going into any other question, this honorable court disposed of the writ petition, relegating the entire issue to the competent authority for disposal of a representation which was filed in course of the writ petition, not appended to that writ petition.
So ultimately boils down to that representation.
Representation. 17 February 2022 was
a representation, not a representation.
Representation. My lord, 17 February 2022 was directed to be considered. 17 February 2022 was...
Now that representation has been considered.
No, no. My lord, that is the issue. My lord, we had raised the issue that, my lord, in terms of the act, additional compensation or any compensation which was already arrived at, that issue has to be decided by the district judge in terms of section 10, and the competent authority lacked or inherently lacked jurisdiction.
Who took that point?
We took that point.
Then,
because that point was also there in our writ petition, in our
the
affidavit.
High Court directed.
But even then, even my lord, the High Court did not give a blanket, my lord, leeway to the competent authority to act contrary to section 10. It was always in accordance with law. Now,
then what happened?
my lord, the competent authority decides the point against us and holds that my learned friend's client, for this protracted use for n number of days, my lord, without enhancing the quantum per acre, my lord, has or quantum per decimal, 450 rupees per decimal, without enhancing that, has come to a conclusion that this total amount that he will be entitled to will be more than 6 crores and odd.
What have we paid?
We have paid 42 lakhs.
42 lakhs. Sorry.
Our principal submission before your lordship while agitating this issue is that this order passed by the competent authority is contrary to the act. My lord, whatever the point was taken, it was taken in our written objection, it was taken in the writ petition in the opposition also. My lord, the submission may be that, my lord, the Honorable High Court has passed the order. Not the Honorable my lord, Honorable High Court definitely has directed the competent authority. The competent authority feels that the jurisdiction vested for this additional compensation is with the district judge. My lord, it was incumbent on the competent authority to send it to the district judge.
You can always interpret the High Court order by saying that competent authority means the authority has to be competent to decide this. So the competent authority under the statute may not be the competent authority. You can interpret that. We can interpret.
Lighter way of saying it.
Not lighter. We can interpret it. So ultimately, one is jurisdiction point.
Patently, first and foremost,
first and foremost is the jurisdiction point. And secondly, last and what's point is
issue. This compensation part that has been arrived at today, may not right.
What is the other violation of the statute?
That is the principal violation. That is the principal violation.
That is the main thing.
Yes.
So
your lordship will have to examine the order at page 469.
Only show me the High Court's order first, then come to that jurisdiction.
Volume 2, Millard, it's the first document at volume 2.
You had appeared, obviously you were there.
Yes, yes. Mr. I'm being led by Mr. Dhar.
Your client was there.
Yes.
Yes, by now I understand you were led by Mr. Dhar for several reasons.
For several
reasons beside you, reasons behind you. Yes. Anyway, competent authority being there, let us go through that.
Well, kindly see.
Hmm.
Forthwith pay the entire compensation in respect of the loss and damage suffered by the petitioner during the laying of pipelines.
You're reading which portion?
Paragraph 2 at page 214.
Yes.
In terms of the provision, I
So what was held by his lordship? Only that.
Please see 216, paragraph 8. I read, Milord, it is not in dispute that a sum of rupees this has been paid by the Indian Oil Corporation to the petitioner on account of compensation. But the present grievances of the petitioner is with regard to enhancement of compensation and payment of any further sums in terms of the provisions of the 1962 Act. So,
Oh, you say the initial compensation could be paid by the competent authority.
Yes, that has already been awarded.
But any challenge to the quantum has to be preferred before the district. Very well.
They came by way of a writ petition.
Say this order cannot confer jurisdiction.
Yes.
Unless it is given by law.
Unless, Milord, the statute provides. Admittedly, the pipelines have been laid using a portion of the chunk, though the petitioner has a right to use and enjoy the property as a lessee, he should not be permitted to cause any damage or etc. etc. In view of thereof, this writ petition is disposed of by passing the following orders.
Mr. Bhattacharya, please take me to that provision, the statute.
Yes.
The relevant provision.
Milord, please come to volume 1. It's there.
Yes, give me the section.
Milord, I'll just come, kindly comes. Milord, please come to page 34. At page 34, well, the document, statute is annexed.
34, yes.
Yes. Compensation. Wherein the exercise of powers conferred by section 4.
34 is a different page.
34, page 34, section 10. Has my lord very kindly got it? No?
Oh, I'm sorry. Yes, I got it.
Wherein the exercise of the powers conferred by section 4, section 7 or section 8 by any person, any damage, loss or injury sustained by any person interested in the land under which the pipeline is proposed to be or is being or has been laid, the central government, the state government or the corporation as the case may be, shall be liable to pay.
Seen it, Mr. Bhattacharya, this is your primary point.
So, 2.
Seen it. District judge has the power. If compensation determined is not acceptable, amount of compensation shall on application be whatever.
Now, my lord, how the competent authority has dealt with, if your lordship wants to see, I can.
No, your primary point is it cannot deal with.
No, he cannot.
What about the jurisdiction point?
My lord,
if I'm satisfied on the jurisdiction point, I'll set aside and direct the district judge to do it.
Kindly.
No. Now, my lord, may I tell your lordship?
First, satisfy me on the jurisdiction point.
The entirety on the jurisdiction point, but certain facts are required to be stated to your lordships. Why I say so, my lord? My lord, this is a fishery. So far as, my lord, this kind of compensation cases are concerned at the instance of IOCL, my lord. In case of other crops like, my lord, paddy and other agricultural produce, my lord, there are fixed rates at which fixes, my lord, the amount of compensation, the rate of compensation per quantum.
For fishery, there is nothing.
For fishery, there is no fixed rate.
Very well then.
This transpired during the hearing before the competent authority. That there is no.
Therefore, district judge, instead of district judge, it should be heard by the competent authority.
Then what they do, the IOCL, what they do, my lord, the only method they follow is they enter into a mutual agreement with the lessee or the owner of the fishery. And by way of a mutual agreement, they decide amongst themselves, subject to the satisfaction of both the parties, they come to a settlement. It's like a settlement. And then they execute an agreement. By that agreement, whatever amount is settled, they pay to the party. And that there is another condition they keep in the agreement itself, that if there is, if there is any delay in completion of the project work, further additional compensation will be paid. Why I say so, my lord? In my writ petition before the Honorable Court, the earlier writ petition referred to by my lord and friend, my lord, I have annexed 2 such agreements, which unfortunately are not part of this petition. My lord,
it is a.
No, kota nahi. Reply attached. Writ petition without annexure. Well, those are part of my annexures in the writ petition, my lord. That is not there. I can always use that, my lord, by an affidavit or as scholarship. Now, my lord, what happened in my case? My lord, they took over the land, according to me, on 20th May 2020 during lockdown, which they say, no,
because the Panchnama, because for taking over the land, one has to execute, the IOCL has to execute a Panchnama. This Panchnama, my lord, is signed by all the parties. That is to say, my lord, the representative of IOCL, the representative of the lessor.
So the law, they have to do that.
Yes, yes. The representative of the IOCL, the representative of the lessor or the owner or the lessee, whosoever is the owner of the land in question, then the representative of the competent authority and one respectable person from the locality.
Right.
This was done on 20th of May 2020 during my lord, the lockdown.
Yes,
It
you
was-
said that. Yes.
Lordship.
Yes.
Now, my lord, what happened? It is my specific case that with the execution of the Panchnama, the land was taken over. Because since it is a fishery, I had to drain out the water and hand over. Whatever produce was there, I have taken
Obviously,
that,
yes.
and thereafter I hand over. They say they have taken it over in March 2021. Now, my lord, there was no agreement executed with me. The Panchnama itself does not refer the period for which this land is being taken. Now, my lord, that was my specific case in the writ petition itself. That it's my specific case that they verbally told, the representatives of IOCL verbally told that the project will be completed within a period of 2 months. Now, my lord, that was in 2020. Till, my lord, this order passed by the Honorable Court, the Honorable Writ Court, the land was never, my lord, made over to me. Now, my lord, in 2021, in 2 installments, around 21 lakhs and odd by 2 separate checks over a period of 4 months, they had made over this amount. Now, my lord, the work continued. There were intervening, my lord, flood by reason of cyclones. Yash in 2021, Amphan was in 22, Yash in 2021, followed by heavy monsoon. In such cases, my lord, this is in the district of Pratinidhinipur. And my lord, in such cases, the agreements which I annexed in the I could have shown your lordship, there, my lord, it transpired from them also in respect of the other lessees, similar other lessees who are lessees of fisheries in the district of Purba Medinipur, what they had done. Since the earlier agreement, whatever they agreed, the amount was paid, they admitted that they could not complete the project. And since they could not complete the project within this time as specified, whatever they agreed upon in the first agreement, naturally, my lord, the fishery owners or lessees who were, because they were out of business.
Can you be a bit short on that, on the fact? What is your point?
Yes.
Tell me your point first.
Additional compensation was paid to all.
Very good.
So that was one of the point, one of the ground in my writ petition also.
What about the adjudication enhancement?
No, that's what I'm saying.
Why
So
does the
in
competent
my
authority has
case,
jurisdiction?
yes. In my case,
Yes.
in my case, my lord, there was no such agreement.
Very well.
There was no such agreement. Why I say so? Then, my lord, firstly, there was no, my lord, agreement by and between the parties with regard to what should be the rate of compensation since there is a fishery. Number one. Number two, my lord, what is the quantum of compensation? What will be the quantum of compensation? And what will be period of compensation?
So this was the first adjudication now after the High Court's order, after Justice Bhattacharya's order.
Yes.
This would be the first adjudication.
No, this was before the writ court only. I took this point.
You took a compensation initially. A compensation was given to you.
Compensation was given. I mean, my petition before the Honorable High Court was only that you have to pay me additional compensation.
If that be so, additional means enhanced.
No, the enhancement was two kinds. One is, my lord, enhancement of rate.
Yes.
One is the rate. Because why say, my lord, since it's a fishery, since I don't have these agreements, my lord, I could have shown.
Not
because
yours. I'll take your
they have paid
Yes.
to the other fisheries in the district, my lord, in various rates. Some they have paid as much as 7,000 rupees per decimal. To some, they had paid at the rate of 1,200 rupees per decimal. To some, they have paid at 1,000 rupees per decimal. For me, if I calculate that amount, because my total amount, as my learned friend has said very rightly, the total quantum of land in my case is 9360 decimal. Well, if I divide it, it comes to 450 rupees. But the competent authority will not, in the order which is passed by him, I would like to place that order, because there are certain things, where he has simply said it, that I am not going to enhance. I will not enhance. And since you have already received this amount on division, on simple arithmetic, it comes to 450 rupees per decimal. Since you have accepted that, So therefore, it has to be taken for that. You have accepted that quantum of 450. I said, very well. I agree to that. What I have been given, not an enhancement, but for the remaining period, because they were holding on to my land. Now, this is the first one. Now, secondly, my lord, when I took this point, ultimately they did not agree. Then, my lord, my learned friend refers to, my lord, an email of the general manager of the project. Now, kindly takes that document.
It is a page number.
Yes, I just kindly give me.
Do you want to disclose any further documents?
Well, two agreements I need to put on record. Because
Direct affidavits in the meantime, don't take the compensation.
And then kindly, my lord, a short time and kindly hear out the matter.
You tell me whatever time you say, I'll give you that time.
But one thing, my lord, may I respectfully
Absolutely, yes,
since
why not?
your lordship is saying that, let them at least secure some amount to the Registrar General.
They're the Indian Oil Corporation. If they stop everybody, you cannot come to court even.
I'll tell you, lordship, there's one specific case that today for 3 years I was out of business. I cannot pay even my lease rent. My lease rent is 96 lakhs per year.
How soon can you file your opposition?
Well,
Whenever you say, I'll direct you there.
By next Friday, we'll file a week.
Very well. Learned counsel for the petitioners have raised a prima facie question for hearing the writ petition on merits with regard to whether the competent authority, despite a previous direction of a coordinate bench, which could not confer jurisdiction, decide the issue of enhanced compensation being paid to the private respondent. Full stop, next para. Learned counsel for the private respondent primarily opposes on the ground that although the district judge has the jurisdiction under the relevant statute in case of enhancement of compensation, the present case is not exactly pertaining to an enhancement of the mere quantum of the compensation, but as to further consideration of payment of compensation by the first forum with regard to the remaining period, which was not covered by the initial dispensation of compensation. First up, since the respondents seek to produce further documents which may be relevant for the adjudication of the matter, the respondents are directed to file their affidavits in opposition within June 23, 2023. First up, reply, if any, shall be filed by June 28th. June 28, 2023, the matter shall be listed.
30th. It's IOC.
Pardon?
May I pray
Very
for
well.
30th?
30th, very well. The reply, if any thereto, shall be filed by June 30, 2023. The matter shall be listed for hearing on July 4, 2023. July 4, not the combined list.
Yes, yes.
In the meantime, there will be a stay of operation of the award of compensation by the impugned order by the competent authority till July 31, 2023, or until further order, whichever is earlier.
Great. And matter is fixed on July 4th.
Great.
Thank you. Good.
And affidavit of service be kept.
Affidavit of service filed today be kept.
Great.
15. Yes, my lord. I am appearing for the petitioners, my lord.
What is the matter?
Yes, my lord. That's the, my lord. The writ petition has been filed, my lord, against the encashment of bank guarantee, my lord. Because the law is well settled, my lord, because of facts, my lord, I am placing before your lordship, my lord. My lord, Raghunathpur Thermal Power Stations, my lord, a unit of Damodar Valley Corporations, my lord. They, my lord, undertook a project, my lord, for constructions of phase 3, my lord, of the power plant, my lord. And accordingly, my lord, a letter of approval, my lord, applied for issuance of a letter of approval, my lord, from the Coal India Limited. And it was prerequisite, my lord, that before obtaining a letter of approval, my lord, the corporations, my lord, has to furnish a bank guarantee of rupees 46 crores 45 lakhs. and something, my lord. And my lord, that the bank guarantee was furnished, my lord. Then LAO, a letter of approval was issued, my lord. In the letter of approval, one of the conditions that if there is any delay in commissioning the plant, my lord, within the cut-off date, my lord, then the additional bank guarantee has to be furnished. But this took place in 2011, my lord. Then additional bank guarantee was furnished because it could not be commissioned within the time, my lord. But, my lord, due to adverse financial circumstances and all this, DVC decided, my lord, Damodar Valley Corporation decided, my lord, to abandon the plant, my lord. But ultimately, with the interventions of the Ministry of Power, my lord, and the requirements of power, it was decided that this project should be kept survive, my lord. In the meantime, my lord, a policy, my lord, named Shakti policy came into picture, my lord.
Policy of the government.
The policy of the government, Ministry of Power, Ministry of Coal, my lord. That policy says that those who are the LOA holders, if they are commissioned, their plant, my lord, within a cut-off date, and if they complete all their milestones, and if they agree to complete other formalities, then that should be allowed to those LOA holders. So Raghunathpur power plant, my lord, was also, my lord, as a covered under the scheme and granted, my lord. It was cut-off date what 31st March 2020.
Is there any scope of interim order?
Yes,
Approval
my lord.
directive.
If only, yes, my lord, because I should show, my lord, that under what circumstances, because thereafter what happened.
What are you challenging ultimately? Just tell me that, then proceed.
Only challenge, my lord, that the encashment of bank guarantee, my lord. Having known all these facts, my lord, after that
You are
cut-off date.
seeking a restraint order on encashment.
Yes, my lord. That is why, my lord, it's a heavy burden, my lord, and that is, my lord, as your lordship, because in the latest case, my lord, that the, my lord, that the Supreme Court has made, lord, under three circumstances, my lord, that the bank guarantee could be encashed. One, my lord, that the fraud, my lord, if there is any perpetrated, my lord.
Cite
Second,
that judgment also and distinguish
yes,
those.
my lord. And then, my lord, that the
It will take some time. 10 minutes cannot.
justice, my lord. And second, my lord, I am just, my lord, because I was afraid whether it will be encashed. So I mentioned, despite of all that, because I appreciate your lordship's pressure, my lord.
No, not
But
that, not
still
that.
I-
But I'll have to hear. Well, then I'll continue with the hearing.
No,
Yes.
so, my lord,
Today.
so, my lord, so here, my lord, what happened, my lord, that in this case, my lord, then, my lord, within cannot be commissioned, my lord, within 30
They release the other matters before.
Yes, my lord, yes, my lord.
Other matters are released, Mr. Datta. Yes.
It could not be commissioned, my lord, within 31st March 2023 because of the COVID pandemic, my lord. So therefore, my lord, that the workforce and all this, my lord, there was, my lord, a dismantled positions, my lord, so it could not be commissioned. And, my lord, then thereafter, my lord, the Ministry of Power, my lord, I invite your lordship's attention to that particular letter, my lord, issued by the Ministry of Power. At page 64, my lord. That
64.
undersigned is directed to refer to DVC letter number so-and-so, dated so-and-so, on the subject mentioned above. In this regard, it is stated that the matter has been examined in consultations with Central Electricity Authority. Raghunathpur Thermal Power Stations Phase 2 unit of DVC could not be commissioned within the outer time limit specified in Shakti policy. The reasons for delay which were beyond the control of DVC have been specified as annexed. This is the recommendations of Ministry of Power. In view of the above, Ministry of Power recommends for grant of fresh coal linkage under para B1 of Shakti policy to Raghunathpur Power Station Phase 2 with allocation from the same source and or CIL subsidiary, and to factor in or adjust the deposited commitment guarantee for existing linkage with the fresh coal linkage to be granted under Shakti. This was, my lord, forwarded to Ministry of Coal, my lord.
Mr. Shen, please take your seat.
Yes, my lord. On receipt of these recommendations, my lord, then thereafter, my lord, a coal linkage standing linkage committee of coal, my lord, Ministry of Coal, my lord, that, my lord, held a meeting, my lord, on 8th August 2022, after the, my lord, crossing of the cut-off date, my lord. Then 8th August 2022, in the, my lord, standing committee of the linkage committee's meeting, my lord, but isn't the number, my lord, I invite your lordship's attentions at page, my lord, at page 72, my lord. As page 72, wherein, my lord, under agenda number 7, under agenda number 7, it was decided at page 72. Agenda
Yes.
item number 7. Coal linkage for Raghunathpur Thermal Power Station Phase 2 unit of DVC as per B1 Shakti policy. Ministry of Power by DOEM dated 25th March 2022 recommended for grant of fresh coal linkage under para B of Shakti policy to Raghunathpur Thermal Power Station Phase 2 of DVC with allocation from the same source and a Coal India Limited subsidiary, and to factor in or adjust the deposited commitment guarantee for existing linkage with the fresh coal linkage to be granted under Shakti. Then, my lord, I'm skipping over, my lord, then I'm stating state recommendations, my lord, at page 74. So in the meeting, this was discussed at page 74. Recommendations. Below the second paragraph of the top. Yes. In view of the recommendations of Ministry of Power, that which I have already read out, my lord, Powers SLC LT, my lord's long term, recommended for grant of coal linkage under para B1 of Shakti policy to the Raghunathpur Thermal Power Station 2, Phase 2 of DBC from Coal India Limited. So therefore, my lord, the Coal India Limited, my lord, even after crossing the cut-off date, my lord, on the basis of the recommendations of the Ministry of Power, my lord, the fresh coal linkage, my lord, was allowed to be granted, my lord, to the Damodar Valley corporations, my lord. So thereafter, my lord, what happened, my lord? At page 82, my lord. This meeting, in the meeting, my lord, all the authorities of the Coal India were present, my lord, including the CCL, which is one of the subsidiary. Then on the basis of the recommendations, Ministry of Power granted approval at page, Ministry of Coal granted approval at page 82. The competent authority has approved the recommendations of the SLC Standing Linkage Committee long term, except for the recommendations for agenda item number 2, 3, 4, and 8. So 7 was approved. So recommendation 7 was approved, and that was, my lord, have been approved by the competent authority for a period of 1 year. That means 12 September 2022 to 12 September 2023. That approval was given by the Ministry of Coal, my lord. Having known all this, and my lord, after that, my lord, that the Coal India Limited, my lord, that the chief engineer of, my lord, that then the bank guarantee was, my lord, extended up to 30th June 2023, my lord. In this background, my lord, and the CCL also asked for extensions, my lord, by sending a letter dated 24th May 2023 at page 86. This is to inform you that the bank guarantee number so and so issued on 2nd September 2020 amounted to rupees 46 crores 45 lakh will expire on 30th June 2023 of Damodar Valley Corporation. You are requested to kindly extend the same for a period of 1 year from last date of expiry. Otherwise, process of bank guarantee encashment as per FCA rule will be initiated. So this was extended, my lord. Having known all these facts, my lord, to utter shock and surprise, my lord, the petitioners, my lord, received a communication at page, this is impugned, my lord, at page 6 June 2023, page P13. My lord, all the facts narrated, last paragraph.
Page 87, yes.
Yes, last paragraph.
Last paragraph.
The matter was deliberated by agenda number 7 meeting held on 8/8/2022, which took into cognizance that aforesaid plant would not get commissioned within the outer limit of 31st March 2022 as per para 1 Shakti policy, and therefore recommended for grant of linkage to above plant under para B1 of Shakti policy. Regarding the adjustment of commitment guarantee in fresh LOA, it was deliberated that is a commercial matter of Coal India Limited and its subsidiary and the buyer. This was a subject of discussion, but ultimately recommendations was made on the basis of the recommendations made by the Ministry of Power, where my lord, my lord, recommended for adjusting the, my lord, existing bank guarantee, my lord, with the fresh linkage, my lord. Then, my lord, the subsequent aforesaid discussions and recommendations of SLC were deliberated in the 4th COLO meeting held on 5th April 2023 at CIL, Coal India Limited, through virtual conference, which had detailed deliberations recommended for following action: issuance of fresh LOA to DVC, Raghunathpur Thermal Power Stations Phase 2 from BCCL as per in normative requirements in terms of CEA norms dated 27th March 2019. The normative quantity of Raghunathpur so and so. Cancellations of earlier LOA dated 30th December 2010 and 30th January 2011 and consequential forfeiture of commitment guarantee of DVC Raghunathpur submitted towards issuance of earlier LOA by CCL, unquote. The recommendations of 40 COLA meeting were placed for approval before 160 CMDs met held on 29th May 2023 at CIL Kolkata, which after detailed deliberation approved the recommendation. Now CIL by letter dated so and letter dated 5th June 2023 has advised to take necessary action on the above immediately. In light of above, the LOA of Raghunathpur phase issued by CCL by letter dated 3rd January 2011 stands cancelled along with consequential forfeiture of commitment guarantee in bank guarantee of rupees 46 crore 45 lakhs 60,400 and rupees 37 lakhs 37 crores 16 lakh 53,920 milord. And milord send a letter milord to the bank milord for milord milord.
Here,
Yes.
their quote unquote within the quote unquote, they have said issuance of a fresh LOA.
Yes.
And consequentially, probably cancellation of the earlier LOA.
Earlier. But there was a recommendations, milord, that the earlier, milord, commitment guarantee, milord, shall be linked with the fresh linkage. And that was, milord, approved by the Standing Linkage Committee of Ministry of Coal, milord. So they themselves, milord, they accepted these positions, milord.
So what should be the scenario according to you? This whatever bank guarantees are there, they will be adjusted with the fresh LOA.
Yes, milord. Yes, milord. Yes, milord. And that was the recommendations, milord. And milord, this is a special circumstances or equities created in my favor, milord. It's squarely, milord, under this third exceptions, milord. So far the invoking of bank guarantee is concerned, milord.
This
and
is
that
not,
apart, milord, that
because the underlying contract is there.
yes, milord.
That there is no allegation of fraud in the underlying
Yes, no,
contract.
milord, but milord,
The usual things. I mean, the
yes,
usual,
milord, but I'm
these are not my language, you know. These
No,
are the language.
Yes, milord, but I'm saying one judgment, milord.
Justice Banerjee.
No, that is Justice Nageshwar Rao and Supreme Court, milord.
Yes, yes.
Milord, paragraph, milord, 23, milord. The ratio has laid down in paragraph 23. State where I am coming, paragraph 23. The settled positions in law that emerges from the precedent of this court is that the bank guarantee is an independent contract between bank and the beneficiary. And the bank is always obliged to honor its guarantee as long as it is an unconditional and irrevocable one. The dispute between the beneficiary and the party at whose instance the bank has given the guarantee is immaterial and is of no consequence. There are, however, exceptions to this rule when there is a clear case of fraud, irretrievable injustice, or special equities. I have made out a case, milords, under the special equities, milord. Because having known all these facts, milord, they themselves, milord, extended, milord, that the granted, milord, special OA, milord, on the recommendations of the Ministry of Coal, milord, that this was be in factor in and or adjust, milord, with the existing LOA. Despite, milord, all these facts.
Why do you say irretrievable? You say only special equity.
Yes, milord.
Special equity is neither here. No. What is the speciality in the equity?
Special equities, milord, that is also, milord, attractive irretrievable injustice, milord. Otherwise, the whole plant, milord, will be, milord, because otherwise, milord, there was a
so your cause of action is actually a new linkage has to be given to you.
Yes, milord. Linkage has been given, milord, but the milord
that has been given to you. New LOA has been issued.
No, milord. AO has not been issued. FSA has not been signed. Coal has not been supplied. They have not suffered any loss or damages, but they have forfeited, milord, my bank guarantee, milord. That is there is a clause of forfeiture, as your lordship, milord, it is, milord, by way of a compensation under section 73 of the Contract Act, milord. So all this created a special equities, milord. So that's I respectful submit before your lordship, milord. After it's a corporation is going to, milord, set up a plant, milord, and with the interventions of the Ministry of Coal, Ministry of Power, milord, there was no damage, there was no loss suffered by the Coal India Limited.
Let me hear Mr. Sen on this. Yes, Mr. Sen.
Lordship, only two words that is very important, my lord, in my learned senior submission. My lord, that is a recommendation and fresh linkage. My lord, the recommendation of the ministry is at page 64.
Yes.
My lord, the ministry has recommended that, I will read that particular paragraph. In view of the above, Ministry of Power recommends for a grant of fresh coal linkage under the Shakti policy with allocation from the same source, CIL subsidiary, and to factor in the deposited commitment guarantee for existing linkage with the fresh coal linkages to be granted under the scheme.
So what about this factoring in?
Yes,
and adjustment?
factoring in this recommendation was not approved by the committee. Well, that was left, being a commercial aspect, that was left at the discretion of the Coal India. Well, it kindly takes up that particular paragraph. Well, it is at page.
And the subject was also request.
Yes, subject was also request. Well, that is why I'm saying, well, it was a recommendation. It was not a decision. Well, it kindly sees page number 73. That is the record of discussion portion, my lord. Page 73, the middle part.
Yes.
My lord, kindly sees Ministry of Power recommended for grant of fresh coal linkage under para B, clause 1 or subclause 1 of Shakti policy to Raghunathpur TPS phase 2 of DVC with allocation from the same source, Coal India Limited subsidiary, and to factor in / adjust the deposited commitment guarantee for existing linkage with the fresh coal linkages to be granted under the Shakti scheme. It was discussed that SLC LT, that is the committee, does not have or does not recommend for the coal linkage from the particular subsidiary of company of Coal India Limited. So the Ministry of Power had recommended that you take it from Coal India only or its subsidiary. Even this committee does not have the power to give a stamp on that recommendation. Secondly, in addition, the adjustment of commitment guarantee is a commercial matter of Coal India Limited, its subsidiaries and the buyer. It was further informed that as per the government approved Shakti policy, it has been mentioned that after 31/3/2022, the old regime of LOA FSA would come to finality and fade away. SLC LT considered that the linkage of DVC falling under A1 of Shakti policy has expired after the due date of 31st March 2022. So what is now the recommendation? The Ministry of Power's recommendation that you grant a fresh linkage, factoring in the already submitted commitment guarantees. But here, the recommendation has been curtailed into the approval has been curtailed that you only grant a fresh linkage. Regarding factoring in of the commitment guarantees, there is no approval, and this particular minutes has not been challenged by the petitioner. So, the petitioner accepts the minutes. The bank guarantees, the commitment guarantees which were already there, it has been left to the commercial wisdom of Coal India Limited. What is to be done with it? Now kindly sees the LOA. The LOA is at page, it is P2, page 40.
What about this, the recommendations at page 74?
Yes, my lord.
Under that caption, recommendations. In view of the recommendation of Ministry of Power, SLC such and such, recommended
at page 64.
At page 74.
As page
74.
Well, the agenda 7 was pertaining to DVC.
At page 64, my lord.
That is the Ministry of Power's recommendation.
At
page 74, the recommendation, it only pertains to the recommendation in connection with DVC. Well, there were several other agendas.
No, my lord, that was my lord. That was my lord. My lord, that was.
I'm talking about the
yes, but here DVC is the petitioner.
Yes, DVC is the petitioner.
In respect of DVC, why is that recommendation? It has been stated in view of the recommendation of Ministry of Power, recommended for
grant of linkage, but not the factoring in of the commitment guarantees. That has not been approved. That has not been approved. Well, only that they were entitled to a fresh linkage under the Shakti scheme. So the LOA is gone.
My respectful submissions that was a discussions, my lord, but the recommendations was made on the basis of the recommendation.
Recommendation is not binding, he says.
No,
that's why it was couched as a recommendation and request.
Yes, my lord.
So that has not been accepted.
So that's right, my lord. That my lord, that thereafter, my lord.
So where is the special equity?
Then that was approved by the Ministry of Coal, my lord, at page 82.
This recommendation was approved.
Recommendation was approved. Page 82.
The SLC committee, minus the factoring in of the commitment guarantees, was recommended by the
Yes, agenda 7 was also also approved.
Yes.
But that agenda 7 said that they are not accepting the
minus the commercial guarantee, the commitment guarantee.
My respectful submissions is this, my lord, That was the discussions, my lord. And the discussions, my lord, that this is of course, my lord, by and between the, my lord, that the CCL and the DVC, my lord. But, my lord, while recommending, my lord, recommendations was made on the basis of the, my lord, Ministry of
Recommendation is
Powers
not binding.
recommendation.
Recommendation cannot be binding.
My lord, then,
Court of law cannot implement
yes, my
the
lord,
recommendation.
then I respectfully submit before your lordship, my lords, and two other aspects, my lord, that, my lord, that the cancellations of LOA, my lord, by invoking, my lord, the power of forfeiture, my lord. The question of power of forfeiture doesn't arise, my lord, because there was no question of compensation. There was no loss occurred, no damage occurred.
My lord, that is the
Even
reason why-
FSA has not been signed, my lord.
But I wanted to read
Fuel
out the
supply,
relevant
my lord,
paragraphs of
full-
the LOA.
Full fuel supply agreement, my lord, has not been signed, my lord.
Before
Coal has not been supplied, my lord. Yes, my lord, it was a prerequisite, my lord, before granting LOA, that the TBC has to furnish commitment guarantee in the form of bank guarantee. That was done.
My lord, the clauses of the LOA will suffice, and kindly see page 80.
Yes,
My lord,
yes.
the Ministry of Powers representative was also present. Well, this is a high-level committee meeting wherein the representatives of all the ministries are present. Ministry of Power, Sri Sumon Mujumdar, Deputy Secretary. My lord, a recommendation was made for DVC. That recommendation was curtailed to the extent that the commitment guarantees will be at the sole discretion of Coal India as per their commercial wisdom. That recommendation was not accepted. The recommendation only for fresh linkage was accepted. Well, now I would only like to show two.
No,
or
Mr.
three-
Sen, only one aspect of the matter. Now here in your the impugned communication, 6th of June,
Yes.
page 87.
Hmm.
In the last paragraph of page 87, you have stated the matter was deliberated such and such. The last sentence is regarding the adjustment of commitment guarantee.
Hmm.
In fresh LOA, it was deliberated that it is a commercial matter of Coal India Limited, stroke its subsidiaries and the buyer. So you did not give that opportunity of the commercial matter being discussed with them before invoking the.
My lord, because it was unconditional. Because, my lord, under the LOA, if they had failed to commercially to commission the plant or to take steps under the LOA, it was bound to be forfeited. My lord, that is the clause I wanted to indicate, your lordship.
Show me that clause.
Yes, your lordship. Kindly seize the LOA, my lord. It is at page 40. My lord, page, it is P2.
Page 40 I've got,
Page
yes.
40 of the petition.
The relevant.
And then, my lord, kindly see time-bound achievement of milestones.
Where is that?
My lord, it's at page 42. This is clause 2.1. The assured shall undertake to complete all the activities. Here, the assured is DVC. We are the assured. Here, the assured shall undertake to complete all the activities as mentioned in Annexure 1 to this LOA within 24 months. So they had to commission the plant within 24 months. We would have supplied them coal for their power plant. They had to commission the plant within 24 months from the date of LOA, and each activity within time period mentioned against it unless such completion is affected due to force majeure. Even provided that such force majeure event shall not include inability or failure to obtain financing for the plant. That is exactly the case.
This LOA
That is
granted,
exactly
my
the
lord, in
case.
the year 2011, my lord.
My lord, kindly allows
2011,
me,
24 months has gone, my lord.
kindly allows.
Yes.
Yes, your lordship. To comply with the existing rules and regulations, and assure notifies in writing 7 days occurrence of this is relating to the force majeure. And now, my lord, kindly sees additional commitment guarantee they have granted because it is at page 43, clause 3.3. This is with regard to additional commitment guarantees. The additional commitment guarantee was of 37 crores. The original bank guarantee was of 46 crores, and the additional commitment guarantee is of 37 crores. They have given this additional commitment guarantee because they failed to adhere to the timelines.
But Mr. Sen, did you cite this ground in your communication? Because by way of this communication, you are saying, yes, LOA, we are partially accepting the recommendation, we are revoking the previous LOA.
Because, my lord, the cancellation of the LOA leads to forfeiture. Because this is cancelled formally 6th June 2023, the clause is 3.4.1. Cancellation or withdrawal of the LOA. Now see, my lord.
Let us see that.
In the event that any of the activities or milestones is delayed beyond the period specified against each such activity, milestone, etc., 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 the assurer shall have the right to cancel. I'm just reading the later part. the assurer shall have the right to cancel or withdraw this LOA after duly notifying the assured in writing at least 7 days in advance. For the avoidance of any doubt, all the milestones as specified in Annexure 1 shall be need to be fully completed, and any partial completion with regard to any activity milestone at the end of the validity of the LOA shall entitle the assurer to cancel or withdraw this LOA. Now, upon cancellation or withdrawal of this LOA, the assurer shall encash the CG, including any additional CG submitted by the assured. It is clarified for removal of doubt that this clause shall survive the cancellation stroke withdrawal of this LOA. So, my lord, on cancellation, the resultant effect is the forfeiture of the commitment
True,
guarantee.
you are right, Mr. Shen, but the difficulty is that regarding the delay beyond the specified period, nothing has been stated or indicated even in this communication. Did you ever indicate anything that they were delayed beyond the specified time? Unless you indicate
My lord,
that,
because
what is
in
the occasion to do this?
2017, there was this particular recommendation. Of the
Recommendation you
ministry.
cannot say partially binding. It's you ultimately recommendation request was made.
Yes.
You accepted it partially. If it did not have any binding effect,
But
it's
the
your
time
decision.
was extended till 31st March 2022. The time for performance was extended in 2017. They had abandoned the project.
Are these reflected anywhere in this communication?
My lord, I shall
There is nothing.
indicate.
The cancellation of existing LOA does not even give a reference to any such ground being satisfied. It may be your unilateral perception as per that clause.
Yes, Your
Maybe. Arguably, it may be. But even then, it has to be reflected somewhere.
Your Lordship, the recommendations of the CLOA meetings.
Special
everything
equity
is there.
at best for them can be this. This is palpably bad. I mean, without any citation of any reason, you unilaterally you accept a part of the recommendation and don't accept the other.
My lord, it is not only about the recommendation. We have also indicated regarding the Shakti policy. All points have been covered, my lord. The first page, the first page of the of the particular termination notice. This is in reference to the LOA issued by CC.
Or you have also stated could
Yes.
not get commissioned.
Yes,
Correct.
my lord, that is my case. They failed to commission the plant. My lord, the LOA is anyways gone. My lord, this is just a formal termination.
Then
And
this
is already gone.
respectful submissions, my lord, also, my lord, on this point, my lord, that the cutoff dates.
Bank guarantee
31st
injunction.
March 2022, my lord.
Made out, my
This
lord.
is-
Not a case
why-
of injunction
why, my lord,
restraining bank guarantee.
Because, my lord, the COVID pandemic, my lord, because.
That
my lord,
is a
on-
different
on-
aspect.
Yes, on 22nd, my lord,
lord,
because
before I
31st March 2022, my lord.
No,
But
my lord,
during
before
that
I
the
period, my
moment
lord,
you give this bank guarantee,
Yes.
you know these clauses because letter of intent was there.
Yes.
So you are bound by these clauses.
No, that's
So
right.
if they can do this, that was within your knowledge.
So,
And
yes.
with that knowledge, you had given furnished the bank guarantee.
My lord,
Now,
one more
bank guarantee cannot be invoked. Bank cannot do it. We cannot grant that injunction.
No, my lord, but my lord, why, my lord, that
It's
that
a
could not-
dispute, yes.
So
It's
this
a
is
legitimate dispute.
special,
Raise
no,
it.
my lord, that the special equities, my lord, why, my lord? Because, my lord, it could not be, my lord, Delhi High Court, my lord, on the self-same matter, my
Nothing
lord,
special
Delhi
in the
High Court-
equity.
Yes, my lord, on
Just
COVID,
one-
my lord. But
one
though, my lord,
submission, my lord.
facts has not been narrated, my lord,
You
so I
cannot do
brought
this
the
piecemeal.
petition.
You have to
I
do it at
brought the
once.
petition.
My lord,
my
one
lord,
submission,
coming
my lord,
up.
I would like to
How
make.
many
This
judges
is on
are-
instruction. I have received instructions from Coal India today
Yes,
only.
I'm
That-
saying,
The fact that the bank guarantee of 37 crores was invoked and the bank was
What is this?
It's this, my lord, on this petitions, my lord, because nothing, my lord, has recorded in the order, only, my lord, the order of injunction. So, my lord, that is the fact where, my lord, that the case was made out. my
No,
lord,
the
that
issue
there
is
was
that this is a status quo as of today is maintained.
not
Justice
findings, my
Pratibha
lord,
Singh.
but not in the civil. No, my lord,
you
that I
should
know.
not cite this.
Yes, that I know,
Your
my lord.
Lordship,
But, my lord,
You should not cite this.
yes, my lord.
That
not
stage is
citing.
long over
No,
for.
I'm not citing.
Your Lordship,
Even he cannot cite it.
Just, my lord, persuasive value, my lord, nothing else.
Justice
my lord.
Pratibha Singh felt so. I don't feel so.
Yes.
with your lordship's permission, my lord, only one submission on instruction.
I've got a different engagement, professional engagement immediately. So I'll have to finish it now.
I'll
Wind
take
it up.
30 seconds, my lord. The bank guarantee amount, that is 37 crores of the additional commitment guarantee, they have taken back the bank guarantee. That is my instructions, and they have paid us 37 crores. They have acted upon the termination.
Now, why, my
That
lord?
is my
Why,
submission.
my lord, that
They have paid us
my lord,
that
that there
amount
was
and
a
they asked
delay.
that you give
No, my
give
lord,
back
there
the
was-
bank guarantee.
No, my lord,
I'll
there
pay you the sum.
Yeah, there was a
They have
delay,
acted
my
up.
lord. No, my lord, there was a delay, my lord. So that's why this
It's not
37
so.
lakhs, my lord, was given, my lord. My lord, in the
No,
agreement itself, my lord, in the agreement itself, my lord, there was.
No, sir. Learned counsel appearing for the petitioner contends vehemently that the invocation of bank guarantee by the respondent authorities ought to be restrained in view of the bank guarantee being sought to be invoked unilaterally by the CCL, by cancellation of the existing LOA within bracket letter of assurance, comma, without any cogent reason therefore. For next para, learned counsel places reliance on the clauses of a recommendation in an office memorandum dated March 25, 2022, issued by the Government of India, Ministry of Power, requesting for fresh linkage for Raghunathpur TPS Phase 2. First up, it was indicated in the said memorandum that the Ministry of Power recommends for grant of fresh coal linkages and to factor -in stroke adjust the deposited commitment guarantee within bracket CG bracket closed for existing linkage with the fresh coal linkages to be granted under the Shakti cap S Shakti scheme. For next para, it is submitted that the same featured in agenda item number 7 of a high-powered committee which was subsequently formed, represented by all stakeholders. First up, the recommendation of the Ministry of Power featured in the said agenda as well. First up, thereafter, it was communicated to the CCL by the Undersecretary to the Government of India that the competent authority has approved the recommendations, approved some of the recommendations of the SLC within bracket LT bracket close, that is the High Power Committee of the Power Sector, including agenda number 7. First up, next para, despite such approval, the respondent authorities have sought to invoke the bank guarantee by revoking the LOA, contrary to the recommendations of the Ministry of Power, which is palpably dehors the law. First up, next para, learned counsel for the petitioner, in his usual fairness, submits that in Standard Chartered Bank versus Heavy Engineering Corporation Limited, reported at 2020 13 SCC 574, the Supreme Court specifically carved out the exceptions where the invocation of a bank guarantee can be restrained by an injunction. First up, such cases, in terms of the order of the Supreme Court, include clear case of fraud, irretrievable injustice, or special equities. First up, it is argued that the present case falls within the last of the above categories. First up, next para. Learned counsel appearing for the respondent authorities points out that the language of the office memorandum dated March 25, 2022 was that the same was couched in the form of a request and was a mere recommendation. However, the high-powered committee in its meeting, which has been referred to by the petitioner, did not approve of the recommendation of adjustment of commitment guarantee. First up, by placing reliance on the minutes of the said meeting, particularly in respect of agenda item number 7 relating to the concerned coal linkage, it is pointed out that the adjustment of commitment guarantee was observed by the committee to be a commercial matter of Coal India Limited stroke, its subsidiaries and the buyer. First up, next para, the recommendations were also indicated therein below. First up, next para, in such view of the matter, there was no irregularity on the part of the CCL in accepting a part of the recommendation on the basis of the high-powered committee decision, pursuant to which the impugned communication dated June 6, 2023 was made. First up, next para, learned counsel appearing for the respondent authorities further places reliance on the concerned letter of assurance, annexed at page 40 of the writ petition and submits that clause 3.4.1 therein clearly stipulates the conditions of cancellation or withdrawal of LOA, full stop, delay in the activities stroke milestones beyond the period specified for each activity stroke milestone also features as one of the grounds of such cancellation or withdrawal. Full stop. Next para, learned counsel further argues that in the impugned communication dated June 6, 2023, the respondent authorities clearly indicated the ground for the revocation, inter alia being agenda item number 7 of the SLC within bracket LT bracket closed meeting held on August 8, 2022, as well as that the Raghunathpur phase 2 could not get commissioned within the outer limit of March 31, 2022, as provided in the Shakti policy, resulting in non-execution of FSA. Full stop. Next para. As such, it is argued that the bank guarantees were rightly sought to be invoked by the respondent authorities. Full stop. I'm not recording your other
On
that they
instructions
have
part. Yes.
on instruction is very vague.
Yes.
I mean, it will prove to be wrong. Your learned friend also does not know surely. I am not recording that.
Yes, Your Lordship.
Next para. Upon a consideration of the arguments of the parties for the purpose of considering the prayer for ad interim relief, it is evident that the petitioner has failed to make out a sufficiently strong case for an injunction being passed restraining the invocation of bank guarantee, which, it is well settled, is an independent contract between the person giving such guarantee and the bank. Full stop. Next para. In the present case, the respondent authorities have made out a sufficient prima facie arguable case to justify the revocation of the LOA in terms of the partial acceptance of the communication of the recommendation of the Government of India, Ministry of Power, as accepted by the High Powered Committee, as well as on the basis of the clauses of the letter of assurance, in particular clause 3.4.1 thereof. Full stop. Next para. It is, at best, arguable as to whether the recommendations of the ministry in question, couched as a request and a recommendation, could have any binding effect at all on the respondent authorities. Full stop. However, such arguability, per se, does not lend any special effect to the equities claimed by the present petitioner to justify restraining the invocation of a bank guarantee. Full stop. In such view of the matter, the interim order sought by the petitioner to the effect that the invocation of bank guarantee may be restrained is refused at this stage. Refused. Full stop. Next para. The respondent shall file their affidavits in opposition, whatever remains. The affidavits in opposition within 3 weeks from date, reply within 1 week. The matter shall be listed in the monthly list of August 2023 for hearing. I'm extremely sorry.
Yes. Sorry to trouble your lordship. In the next matter, there is a grave urgency. Survival of my family is at stake. I'm seeking some precedence,
Why survival of your family?
The only source of my livelihood, my vehicle, a truck, it was seized by the forest officials into January, in utter disregard to section 59B. No,
I have been refusing others. No, not at the end of the day. Not this hour notice.
This very urgency.
I'm extremely sorry. There are equally urgent matters whom I have refused. I have had to refuse. I'm sorry.